Good morning, Ms. Hofmeyer. Good morning, everybody.
Good morning, Chair.
Are you ready?
Yes, we are.
Okay, all right. Good morning, Ms. Myeni.
Good morning, Chairperson.
Before we start, I'm just going to repeat something that I said yesterday, Ms. Myeni, namely that the Commission gives you an opportunity to deal with all evidence that or allegations that may have been made against you or your board in the Commission, so as to ensure that I have before me, when I prepare the report, your version as well, not just what they have to say against you, but also your version and your perspectives. The Commission also gives you the platform in responding to questions that are being asked to inform the public of your side of the story in relation to whatever may have been said against you, about you, by witnesses who have come to the Commission. But the Commission recognizes that you have a privilege not to incriminate yourself, and where you invoke that privilege and there are reasonable grounds for its invocation, the Commission will not compel you to answer questions. But also, it's going to be important that when a question has been asked, you make up your mind whether you are going to invoke the privilege not to answer the question, and on the basis that answering the question might lead to you incriminating yourself, or whether you are going to answer the question. You can't have it both ways. You can't give some answer and then later say, no, I'm invoking the privilege. So where you are going to answer, you answer, but where you invoke the privilege, you invoke it, and that's it. If at some stage I might seek to inquire whether there are reasonable grounds to invoke it, and as I said 2 days ago, there may be cases where I compel you to answer, but I will not do so unless I think that there are no proper grounds to invoke the privilege. So I just wanted to remind you again, particularly because as things presently stand, this is the last day when you are appearing, to say it's an opportunity you have to respond to questions and deal with whatever different witnesses may have said about you or your board, but where you choose to not to answer on the basis of invoking the privilege, then that will be respected if there are reasonable grounds for invoking it. But it's an opportunity that you decide whether to use or not. But as I said also yesterday, when I prepare the report and I have to make findings, it's not as if just because you invoked the privilege, I can't make findings. All it would mean is simply that the evidence I have on which I can make findings would be of those witnesses who have given evidence, and some of them may have given evidence against you. And if I don't have your version, I make findings based only on the versions I have. So I thought that I must just explain that once again, but where you invoke your privilege and there are reasonable grounds, or we have no grounds to think there are no grounds to do so, that will be respected.
Thank you very much.
Okay, all right, thank you. Ms. Hoffman?
Thank you, Chief.
And the oath you took 2 days ago will continue to apply, Ms. Myeni? Okay, all right.
I'm just worried, Ms. Myeni, you seem to speak there and we couldn't hear you. Could you say something again, just so we can check that you're audible?
Say, Chairperson.
Chairperson.
Ah, excellent.
Okay, all right.
Thank
Okay,
you.
all right.
Thank you. Ms. Myeni, I'd like to begin this morning by focusing on Bosasa. We looked yesterday in the concluding part of the day at Mhlathu's and the allegations that have been made against you there in relation to Mr. X's evidence. And now I'd like to spend some time focusing on the evidence related to Bosasa. Ms. Myeni, how well did you know Mr. Watson?
Chairperson, may I not respond to the question so that I don't incriminate myself?
And Ms. Myeni, how well did you know Mr. Agreezy?
May I please, Chairperson, not respond to the question so that I don't incriminate myself?
Had you ever met with him?
May I not respond, Chairperson, so that I don't incriminate myself?
Mr. Agreezy gave evidence about a very particular meeting that he alleges he had with you at the Sheraton Hotel on the 23rd of September 2015. Can you confirm whether you were at that meeting?
May I not respond, Chairperson, so that I don't incriminate myself?
And there's another meeting that you are alleged to have held with him at the Intercontinental Hotel at the airport about 2 months later in 2015. Did you attend that meeting?
May I not respond, Chairperson, so that I don't incriminate myself?
Ms. Myeni, Mr. Agreezy testified before this commission about your involvement in serious acts of corruption on his version. And you, in fact, responded to his evidence in an affidavit that you prepared in March of 2019. It's the affidavit that we looked at briefly yesterday. So what I would like to do in the course of this morning is take you to aspects of that affidavit and give you an opportunity if you need to clarify or correct anything in that affidavit as we go through the various allegations that Mr. Agreezy and others have made against you in connection with Bosasa. So I'd like to just summarize the nub of Mr. Agreezy's allegations, if I may, and then what I will do is I'll unpack each of them with you. Ms. Myeni, Mr. Agreezy testified before this commission that Bosasa had paid you money and other benefits as a bribe. And one of those other benefits was an elaborate security installation done at your home. So I'm going to call that the sort of general bribe allegation. The second allegation was that Bosasa gave you money in order for you to hand it over to former President Zuma. I'm going to call that the conduit allegation. There was also evidence from Mr. Agreezy that you had facilitated meetings with the former president for Bosasa in order to advance their interests, and I'm going to call that the facilitation allegation. Ms. Myeni, I must just pause there. There has also been another allegation, not connected per se with Bosasa, but in relation to Eskom evidence, that you facilitated another meeting at which the suspension of the Eskom executives was dealt with. Now, that aspect of the evidence before the Commission is going to be dealt with by my learned friend, Mr. Pule Seleka, in questioning you, because that is an area of the Commission's investigations in respect of which he leads the investigation. So I won't be touching on that one today. I'm going to touch on the allegations that come from Mr. Agreezy's evidence, which had to do with Karoo fracking and Bosasa's sites in that area. And then the fourth main allegation, Ms. Myeni, is that you obtained confidential police documents concerning the investigation into Bosasa, and that you'd provided those documents to Mr. Watson and Mr. Agreezy in September 2015, at that meeting, which I asked you about moments ago, on the 23rd of September 2015, according to Mr. Agreezy. So what I'll do now is I'll explore each of those with you. I want to pick up on the meetings first. Now, Mr. Agreezy alleged that you used to assist Bosasa generally with coordinating meetings with former President Zuma, and that there was a particular matter that Bosasa was interested in, and it related to fracking. Now I'd like to take you to your affidavit that you deposed to on the 4th of March 2019, so that we can look there at your response to that allegation. Ms. Myeni, you'll find it in your evidence bundle, DD 34B, and we should pick it up at page 1081. For your convenience, that is under tab 9.
The affidavit starts at 1080, isn't it?
Correct, Chair.
Yes.
And I didn't actually take us there yesterday. I made reference to it. So this is actually the first time that we are going to it.
Okay.
So it may be convenient to enter it into the record. If I may suggest to follow the indexing as DD 34B.9.
Yes, I have it, Chairperson.
Thank you. I'll admit it after she has confirmed her signature and the contents,
Yes.
Ms. Hofmeyer.
Thank you, Chair. Ms. Myeni, if you'll go to page 1083, you'll see a signature there. Can you confirm that that's your signature?
Yes, that's my signature.
And can you confirm that this is your affidavit and that the contents of it are true and correct?
Sorry, I didn't get that one.
I was just asking you to confirm that the contents of that affidavit that bears your signature are true and correct.
The Chairperson, let me read this, because the allegations, I don't have a list of allegations with me of Agreezy.
Yeah. Yes. Okay. Well, Ms. Hofmeyer was just seeking your confirmation that the contents of your affidavit are, to the best of your knowledge and belief, true and correct, without asking about Agreezy, just to...
The contents of the contents of this statement, as I was legally advised, is correct.
Okay, all right. The affidavit by Ms. Duduzile Myeni, starting at page 1080, is admitted as Exhibit DD 34B.9. Okay.
Thank you. Ms. Myeni, and if we could then go to page 1081, at which you'll find paragraph 8 of your affidavit. Do you have that?
Yes, I do. Thanks, Chairperson.
What you say at paragraph 8 is, This is disingenuous for Mr. Agreezy to allege that I had an influence over former President Jacob Zuma to effect certain amendments to regulations which are required to facilitate the Karoo fracking. I vehemently deny these allegations. The meeting did in fact take place in Nkandla. There was no alleged bag of cash that was handed over to the President, and that statement is denied. Ms. Myeni, as I understand this paragraph, you are confirming here that at least one meeting did take place at Nkandla involving Mr. Agreezy. Is that correct?
Chairperson, may I not respond to the question so that I don't incriminate myself?
And then, Ms. Myeni, if you go over the page to page 1082, you deal with other meetings. You see, at the top of that page at paragraph 9, you say, I deny that I coordinated a meeting between former President Zuma, Mr. Watson, Mr. O'Quigley, and Ms. Oberholzer. Do you confirm that you did not set up a meeting between those 4 people in relation to Karoo fracking?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Ms. Myeni, Ms. Oberholzer has provided an affidavit to this commission in which she says that you did set up that very meeting that Mr. Agreezy testified about. Is she giving false evidence before this commission when she says that?
Chairperson, may I not respond to the question so that I don't incriminate myself?
I'd like to take you to her affidavit, and you will find that at page 1444 of the same bundle, DD 34B. Sorry, let me give you the starting page. It commences at page 1433.
I have it, Chairperson.
Thank you, Chairperson. This is the first time that we are dealing with Ms. Oberholzer's affidavit. Chair, if I may suggest that we enter it into the exhibit, again in accordance with the index, as Exhibit DD 34B.15.15. And this is an affidavit that Ms. Oberholzer deposed to. You'll find at page 1447 on the 22nd of October, 2020.
Just one sec. Is it DD 34B.15?
Correct, Chair.
Okay. The affidavit of Ms. Liesel Oberholzer, starting at page 1433, will be admitted as Exhibit DD 34B.15.
Thank you, Chair. Now, Ms. Myeni, what Ms. Oberholzer says in this detailed affidavit, amongst other things, is that you did coordinate a meeting between herself and the former president and Mr. Watson and Mr. O'Quigley. And she says that that took place and that you set that meeting up. Do you recall doing that?
Chairperson, may I not respond so that I don't incriminate myself?
She was very specific about the date of that meeting. She said that it took place on the 27th of July, 2014. Do you recall that?
Chairperson, may I not respond so that I don't incriminate myself?
Because your affidavit evidence before this commission is that you deny having set up this very meeting. And so, in a sense, what the commission has before it is your denial on the one hand, and Mr. Agreezy and Ms. Oberholzer's evidence before this commission that says you did set it up. That's why it's quite important in due course for this commission to be able to make a determination between those two versions. Do you accept that if one side of that debate had some documentary proof that the meeting was coordinated by you, it might tilt the balance in favor of their version?
Chairperson, may I not respond to the question so that I don't incriminate myself?
You see, what Ms. Oberholzer says about this meeting appears at page 1444 of DD 34B.15. So I'd like to take you there. Page 1444 at paragraph 38. Ms. Myeni, you'll see on that page there's a heading in bold, Nkandla, 27 July 2014. Do you see that?
Yes, I do.
And at paragraph 38, this is what Ms. Oberholzer says. She says, on this date, a second meeting was held with President Zuma at his home in Nkandla. Can I just pause there to contextualize where she is in the affidavit? She's dealt prior to this point in the affidavit with the first meeting, which I understand from your paragraph 8 of your affidavit, you don't dispute having taken place. So on that aspect, you and she are in agreement. But on this meeting, because this is the one at which Mr. Quigley, yourself, former President Zuma, Mr. Watson were present, you say on your affidavit before this commission it didn't take place. So I just wanted to give you that context for where we are. Okay, paragraph 38, she says the following. On this date, a second meeting was held with President Zuma at his home in Nkandla. Present at the meeting with me were Mr. Quigley, Ms. Myeni, Mr. Gavin Watson, and President Zuma. I understand that Ms. Myeni had arranged the meeting with the President. The arrangements were made by email between Mr. Quigley and Mr. Gavin Watson, in which I was copied. The suggestion that I attend this meeting came from Mr. Quigley via a telephone call. I attach marked Annexure L01 an email chain which was forwarded to me. The email chain starting on 20 July 2014. The email from Ms. Myeni to Mr. Gavin Watson is dated 20 July 2014 at 11:58 in the morning and 52 seconds. It will be noted that Ms. Myeni advises that I'm trying to set up a meeting for the 27th. It is for this reason that I have assumed that Ms. Myeni arranged the meeting. I'd like to take us to that email, if we may go there, and you'll find that at page 1448. Do you have that?
I see the email, yes.
So you need to start, as one often does, with email.
Yes, Chairperson, I have. Sorry, I have the email.
Thank you. So you have to start this email at the bottom of the page, as you often have to do with email chains. And what you'll see in the second half of the email is in bold the start of an email that says from Dudu M, with a email address there, Dudu Myeni @telcomsa.net. Can you confirm that that was an email address you were using in July of 2014?
Chairperson, may I not respond to the question so that I don't incriminate myself?
The date of the email is 20 July 2014, and the subject is forward, addressed by President Jacob Zuma at the launch of Operation Phakisa Big Fast Results Implementation Methodology. And then I'd like to read into the record what appears then in the body of the email. It reads, for my Nkokeli. Could you translate what Nkokeli means? Ms. Myeni, can you hear us?
Sorry, I can hear. Sorry, I was checking where the Nkokeli is.
Oh, sorry. So it's in the body of the
I
email.
can see on the email.
Yes. What does Nkokeli mean?
That was the word that was used by Mr. Watson.
Because you're addressing him here, so could you translate it for us into English? What meaning does it have for you in English?
I'm not sure. It appears to be a Xhosa word.
Okay, but you were using it in this email, so what did you mean by it?
Can I not respond to this question, Chairperson? I don't want to incriminate myself.
And the email reads as follows. For mine, Nkokeli, I hope you are well. By God's grace, we are all well. I had to get this speech of the launch of yesterday's event because I felt you have to know what the event or launch was about. Please be assured all is under control. I am trying to set up a meeting for the 27th. You see, it's that last, and then it says regards. It's that last sentence of that email where you say, I am trying to set up a meeting for the 27th, that forms the basis for Ms. Oberholzer's evidence before this commission that you did set up this meeting. You have denied that on affidavit, but I want to put to you that this is pretty clear in its terms that you are setting up a meeting. Do you have a response to that?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Let's just continue with the email because then you'll see how it gets to Ms. Oberholzer. You have to now go up from the bottom. So above your email is the email that Mr. Gavin Watson appears to have forwarded a bit later on that same day, the 20th of July 2014, at 16:11 in the afternoon. What this records is Gavin Watson, using a particular Gmail address, wrote, and I'm quoting, "Please see the email I received and who attended the meeting. We can discuss this further when we meet again. Regards, Gavin Watson." And if you go above that, you see how the email reached Ms. Oberholzer. Because it is there's then at the top of the page an email from Mr. O'Quigley, dated the 20th of July 2014, that much later in the day at 8:06 in the evening. And he sends to Mr. Watson, Mr. Agreezy, Roth Watson, and Lizelle Oberholzer, who is Ms. Oberholzer. He sends that email chain to all of them, and his email reads, "So hopefully we are set up for the meeting to take place on the 27th. I'm booked on a flight to LHR on the 24th, but will change as soon as you confirm the meeting is going ahead. Kind regards, Philip." Ms. Myeni, in the face of that documentary indication that you did in fact set up this meeting, do you want to reconsider your evidence under oath on affidavit before this commission that you didn't do so?
It looks like there may be some technical problem.
Yes.
Can you hear me, Ms. Myeni?
Chairperson, may I not respond to the question?
Okay.
I can hear you, Chairperson.
Okay, all right. Ms. Hofmeyer?
Ms. Myeni, I understand you to have declined to answer that question on the basis that it may tend to incriminate you. Is that correct?
My response is that, may I please invoke the privilege of not answering the question in case I incriminate myself?
Thank you. I'd now like to move to the allegation of cash having been provided to you from time to time by Bosasa representatives. Mr. Agreezy's evidence was that Mr. Watson had told him that he was giving you 300,000 Rand a month for the president and that it was being paid to the Jacob Zuma Foundation. Chair, just for record purposes, Mr. Agreezy dealt with that in the transcript of the evidence on the 28th of January 2019, page 52, lines 4 to 8. Ms. Myeni, are you aware of that allegation? No, Ms. Myeni, sorry, that's just a reference to the transcript. It's not in your documents. It's the transcript of his evidence on the day, and I'm just recording that for record purposes. We don't need to go to it. You are no doubt aware of Mr. Agreezy's evidence because you provided an affidavit to the Commission responding to it. What I'd like to just confirm is that you were aware of the specific allegation that Mr. Watson told Mr. Agreezy that Mr. Watson was giving you 300,000 Rand a month for the president and that it was being paid to the Jacob Zuma Foundation. Are you aware that that allegation was made against you?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Now, that allegation was another one of the allegations that you took up in your affidavit. So I'd like to go back to your affidavit, if we may. You'll find the relevant paragraph at page 1081 of the bundle we're in at the moment, which is DD 34B.
Sorry, it's page
1081.
1081.
Yes, I have it, Chairperson.
Now, there's one paragraph, well, two paragraphs here where you deal with this 300,000 Rand that was alleged to have been given to you. At paragraph 4, you say, I further deny that I received 300,000 Rand per month from the Bosasa group. And then if you jump down to paragraph 6, you also say there, I do not possess a Louis Vuitton handbag, which was allegedly filled with cash to the amount of 300,000 Rand. No such amount of money was ever given to me, as alleged. Ms. Myeni, when I read those two paragraphs together, I understand you to be conveying that you did not receive money from the Bosasa group, which found its way into the foundation in due course. I mean, I think your denial is even broader. You're saying no cash, but I want to focus particularly on the allegation of Mr. Agreezy that Mr. Watson told him that he was giving it to you and then that it was finding its way into the Jacob Zuma Foundation. Do you deny that you received money from Bosasa and put it into the Jacob Zuma Foundation?
Chairperson, may I not respond to this question because I don't want to incriminate myself.
Now, what we did manage to traverse a little bit in your evidence yesterday was that there were on occasion cash deposits made to the Jacob Zuma Foundation. Do you recall giving that evidence yesterday?
I recall that I said that yesterday, indeed.
Thank you.
There was context.
And what I was seeking to probe with you yesterday was, it's not easy to identify on cash deposit slips. Indeed, sometimes I would suggest it's impossible to identify who the depositor is on a cash deposit slip. Do you accept that?
May I not respond, Chairperson, so that I don't incriminate myself?
Because I put it to you that if it's not possible to identify who the depositor is, if all you've got is a cash deposit slip, then it is possible that Bosasa was depositing cash into the account of the Jacob Zuma Foundation, provided there is evidence of cash deposit slips. Do you accept that?
May I not respond, Chairperson, so that I don't incriminate myself?
Did you yourself, Ms. Myeni, ever take cash and deposit it in the foundation's bank account?
May I not respond, Chairperson, so that I don't incriminate myself?
Do you remember taking amounts as great as 50,000 Rand and 100,000 Rand and depositing those amounts as cash in the Jacob Zuma Foundation bank account?
May I not respond, Chairperson, so that I don't incriminate myself?
See, because the Commission has managed to find numerous deposit slips of amounts in those large quantities, which appear from signatures on those cash slips to have been deposited by you. So I would like to take you to those cash slips, if I may. I'd like to start at the one that appears in the same bundle that you're in at the moment, DD 34B, and I'd like to look at the one appearing at page 1476, 1476. Do you have that page?
I have it, Chairperson. Yes.
Ms. Myeni, you have helpfully assisted us on 2 occasions before this commission in confirming that a signature that appears on a particular page is your signature. You did it yesterday when you confirmed that the letter you sent in response to the complaints from your co-board members in 2014 was your signature. And you did it moments ago when you confirmed your signature on the affidavit that you presented to the Commission in March of 2019. So I'm hoping you'll be able to assist us with the signatures that appear on these deposit slips. You'll see a signature on this deposit slip at page 1476. Can you confirm that that is your signature? Actually, it appears twice at the bottom of the page. Do you see that?
Chairperson, may I invoke the privilege of not responding to this question?
And then if you
The reason is that each question follows another question.
And if we go over to page 1478, there is another signature on that page on a deposit slip. Can you confirm whether that is your signature?
May I not respond to the question, Chairperson, so that I don't incriminate myself?
Before I go to others that we have with your signature, it's probably appropriate to just have recorded what the amounts of each of these deposit slips was. Let's go back to the deposit slip at page 1476. Ms. Myeni, it's sometimes difficult to see the numbering on the deposit slip. It took me, I must be honest, some time to work out how these deposit slips record the amounts. But let me try and help you. If you go to the top of the deposit slip, you'll see there's an emblem ABSA and on the left-hand side an emblem for Barclays. And then below that you have a date, 8 December 2014, and there's a time. It looks like 1 o'clock in the afternoon and 2 seconds. Then it says CC, and then you'll see there 50,000.00. So that is an indication that this is a deposit of 50,000 Rand. And what's then interesting, if you go just a bit further down, there's Jacob Zuma Foundation, NPC. There's reference number donation dash, I can't quite make that out, SAS maybe. And then there is a, do you see a 100 there? And then you'll see rands and then 000,050,000.00. So that, as I understand it, is indicating that the 50,000 Rand came in 100 Rand notes. If you had been depositing this, Could you confirm for us that you took 50,000 rands worth of 100 rand notes and deposited it in the foundation's bank account on the 8th of December 2014?
Chairperson, may I not respond to the question? I don't want to incriminate myself.
And then if we go to the one that also bears a signature with quite a striking resemblance to the signatures that you have confirmed before the Commission in your evidence, that's at page 1478, you'll see there that that deposit slip is dated the 3rd of November 2016. That is under the emblem of ABSA at the top of the deposit slip. Do you see that?
Yes, I see the deposit slip, ma'am.
Thank you. And then what that tells us is that on this occasion, 100,000 rand was deposited. And if you go further down and follow the logic of the previous deposit slip, it was 20,000 rand in 200 rand notes and 80,000 rand in 100 rand notes. Do you recall taking 20,000 rand in 200 rand notes and 80,000 rand in 100 rand notes and depositing them into the Jacob Zuma Foundation on the 3rd of November 2016?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Ms. Myeni, in this section of your bundle, there are a number of deposit slips. Not all of them bear what appears to be your signature. Some of them bear signatures the Commission has not been able to identify. Some of them give a description like the one that I referenced a moment ago, donation SAS. Others bear no description at all. I'll give you other than donation. So I'll give you an example of one of those. If we go to page 1482, do you have that?
Yes, Chairperson.
You see that one?
I have it, Chair.
If you look at that one, it just says after the date, which it looks like is 16 September 2017. Chair, if I can just pause there, we did try to do the best copying we could, but these are old deposit slips. I mean, they're the original. So this was the best that we could do for the purposes of the bundle. It's the actual deposit slips, as I understand it, are in the possession of the Commission. But let's just look at this one. You see, this one has a date. It looks like maybe 14 or 16 September 2017. And there it just says Jacob Zuma Foundation NPC reference number donation. So on the first one, we got donation SAS. Here we get nothing. Unlike electronic transfers, you just don't know who's making this deposit unless you can identify the signature. Ms. Myeni, there's just one other of the deposit slips bearing your signature that I'd like to take you to, and that's at 1488.
Yes, Chairperson, I have it.
I'll take you to this one because it's amongst some of the clearest of the signatures that appear on that page. Can you confirm that that is your signature at page 1488?
May I not respond, Chairperson, so that I don't incriminate myself?
You'll see, Ms. Myeni, that this is a deposit that was made on the 6th of February 2016, and it's in the amount of 100,000 rand. And it appears on this occasion, the 100,000 rand was made up of 200 rand notes. Ms. Myeni, if you did indeed deposit these large cash amounts, can you assist the Commission as to where you got these large cash amounts from to deposit them into the Jacob Zuma Foundation bank account?
It's myself.
I'm sorry, we didn't hear the whole sentence, Ms. Myeni.
Yes, thanks, Chairperson. May I not respond to the question so that I don't incriminate myself, Chairperson.
Okay.
Ms. Myeni, I must put it to you that the discovery of these cash deposit slips, bearing what on the face looks like your signature, lends credence to Mr. Agreezy's version, potentially that you were depositing cash which you received from Bosasa into the Jacob Zuma Foundation bank account. What is your response to that?
May I invoke the privilege, Chairperson, that I don't respond to the question so that I don't incriminate myself.
Ms. Myeni, in fairness to you, I must record that the Commission has not found regular deposit slips amounting to 300,000 Rand cash, bearing your signature each month. But what it has found is these deposit slips, which appear in your evidence bundle. I haven't taken you to all of them, but they are large amounts of cash deposited by you and without explanation, given the approach that you're taking to your evidence today. Are you sure that you do not want to give this Commission an explanation for those deposits of large cash amounts?
Chairperson, with respect, may I not respond to the question so that I don't incriminate myself?
Ms. Myeni, I'd now like to move off cash and go to travel benefits.
I know you said, Ms. Hofmeyer, you didn't take her to all of them. I see there's one at page 1490 that has a signature that seems to be her signature.
Indeed, Chair, indeed. We could maybe ask Ms. Myeni again if she could confirm that signature. That would be useful. Yes. Ms. Myeni, if you could go to page 1490. Do you have that?
Yes, I do.
That appears to be a deposit also on the 6th of February 2016. We looked at another one for the state a moment ago, this time in the amount of 50,000 Rand, made up of 100 Rand notes, and there's a signature at the bottom of that page. Can you confirm whether that's your signature?
Chairperson, may I not respond to this question so that I don't incriminate myself?
Thank you. Chair, with your leave, I'll then move to the travel benefits,
Yes.
if I may.
Yeah.
So, the evidence of Mr. Agreezy and others has not been confined to cash benefits that Bosasa was alleged to have given to you, with some expectation that it would find its way to the foundation. But there are also travel benefits that you are alleged to have benefited from. So I'd like to deal with those. The allegations are those that come from an entity called Blake's Travel. And the allegation is that you received a number of travel and accommodation benefits through Blake's Travel that were paid for by Bosasa. Can you confirm that you received those benefits?
May I not respond, Chairperson, so that I don't incriminate myself?
Now, Mr. Agreezy's evidence before the Commission on this aspect, Chair, can be found both in his affidavit, which I'm not suggesting we need to go to. This is, again, just for record purposes. Ms. Myeni is well aware of these allegations. She's responded to them on affidavit. But just for record purposes, it's Mr. Agreezy's affidavit, Exhibit AA at page 65, paragraph 30.1. And he also then addressed it in the transcript of evidence on the 22nd of January 2015, page 156, lines 5 to 10. So what Mr. Agreezy says in his affidavit and in testimony before this Commission is that Bosasa used Blake's Travel to facilitate arrangement for various government officials and other persons that they regarded to have influence. And that evidence was then corroborated by Mr. Brian Blake, who is an employee of Blake's Travel. He also testified before this Commission, and his evidence is to be found in Exhibit T, that's T for tomato 18. Ms. Myeni, that should be amongst the bundles that you have with you. We've, until this point, I think, only been dealing with your bundle, but I'm now going to want to take you to T18. So can you look for bundle T18 amongst the mountain of files that you have? And Chair, yours will be provided to you.
T80, I take it, will be written on the spine of the file
It will indeed.
for the benefit of Ms. Myeni. So look at the spine of your files and look for one that's written T80.
Ms. Myeni, if you'll just alert us to when you have the file, and we'll start with it at page 70, 70.
Her picture is off the screen, but she may be hearing us.
I think that's right. I think she's gone off video so that she can move around and find it.
Okay.
So if we can just give Ms. Myeni a moment. Thank you, Chair.
Chairperson, sorry, Chair.
Yes,
All my files are Exhibit DD.
there is no TAT.
There is no TAT. All of them, they are DD, and then they have A, B, C, or Exhibit DD 11,
Yes.
DD 9, DD 8, DD 14, 13, 12, and so on. There is
Could
no
it-
TT.
Could it be that her attorney might have it? Do we know?
It's possible. These, you see, the DD series, Chair, the 55 files that are assembled behind me are the aviation files.
Yes.
The other ones, and they are usually kept together, the other ones where I have to go to other work streams.
streams, yeah.
So this is a T file. Now, this, Ms. Myeni, these two files, I'm going to take you to T18, and later I'm going to take you to T21, didn't come with the first shipment of files. They came later on your first day of evidence, as I understand the arrangements. So might it be that your attorney put them somewhere else?
May-
Can I check, because my attorney's representative is here, who
Yes.
brought the first shipment? Let me just quickly hear if we have them or not, or we can maybe continue without the files.
Yeah.
Yes. Look, the purpose of the files is to take you to certain
Chairperson, with your-
invoices.
Yes, maybe we should take an adjournment.
I think so, Chair.
Maybe we take an adjournment to enable Ms. Myeni to talk to his attorney or the representative of his attorney to establish whether they've got the file.
Yes, Chairperson.
Yes, let's make it the tea break.
Yes,
I
Chair.
see it's 11.
Well,
Oh,
it's
it is
10.
So it's 80.
Only because we started early, but it's very
Well,
convenient to take.
It will be a break without tea.
Yes, indeed, indeed.
Okay.
How many minutes, Chairperson?
Shall we make it 10? Or shall we make it
Chair.
15? I'm just not sure. Let's say we'll make it 15, but if the file is found earlier before the expiry of 15 minutes, I must just be informed and we'll resume.
Thank you so much.
Okay, we adjourn.
Thank you, Chair.
Ms. Myeni?
Ms. Myeni? Hello, ma'am. Can you hear us, Ms. Myeni? Hello?
Yes, hello? Yes.
Yes,
I'm
so
here.
we are about to resume, ma'am. Thank you so much. Please take your position. Thank you.
Yes, thank you.
All rise.
I see the challenges in finding the file took a lot of our time.
Indeed. Unfortunately, Chair, it seems what was not even a tea break became more like a lunch break, and we do apologize for that.
No, that's all right.
What I've discussed with my learned friends is that we're going to make arrangements. It was sent electronically to Ms. Myeni's lawyers, but there is an issue with it being downloaded at the moment, given its size. So we are facilitating a hard copy getting to her. I'm going to move off topics that require those two files to be addressed. And the hope is that by lunch or after lunch, she will have those hard copies and we can return to those matters.
Okay, no, that's fine.
Thank you, Chair. We're indebted. So I was going to be dealing with travel benefits. I'm now pending that, and I'm moving to that alleged meeting, Ms. Myeni, on the 23rd of September 2015. That's the meeting that Mr. Agreezy said had taken place with you, and it's the meeting at the Sheraton where Mr. Agreezy said you handed to him and Mr. Watson confidential police docket information regarding an investigation into Bosasa. Can you confirm that you had that meeting?
Chairperson, may I not respond to the question? I would not like to incriminate myself.
Ms. Myeni, you did previously respond to this allegation, though, and you did so in your affidavit that we were looking at earlier. So I'd like to take you to it. It's at page 1082 at paragraph 13 that I'm interested in, and you'll find that in your bundle DD34B.
1082,
Chair.
Okay.
I have it, Chairperson, before me.
Yes.
So Mr. Agreezy did not testify about only one meeting at the Sheraton, but there was this particular meeting on the 23rd of September 2015, where this very specific exchange of the confidential police information, according to Mr. Agreezy, took place. And as I read your affidavit, Ms. Myeni, of March 2019 that you presented to the Commission, you only deal with Sheraton meetings with Mr. Agreezy at paragraph 13. And I would invite you to direct me anywhere else in the affidavit if you have a different understanding of it. But what happens at paragraph 13 is you say, Mr. Agreezy and I had only met in Sheraton for the first time, as stated on the allegations of his affidavit. However, I was meeting Mr. Watson to request the donation for the former president's birthday event. Do you see that?
Yes, and I have the document, page 1082 in front of me.
Thank you. And then I was just reading paragraph 13, where it seems to me you deal with Sheraton meetings, and you say there, Mr. Agreezy and I had only met in Sheraton for the first time, as stated on the allegations of his affidavit. However, I was meeting Mr. Watson to request the donation for former president's birthday event. I asked whether do you have that in front of you? Do you see paragraph 13, Ms. Myeni?
I have page 1082 with all the paragraphs.
Okay, super. So I want to just convey to you, when I read that paragraph, it says to me that you are denying the meeting that occurred on the 23rd of September. 2015. Is that correct? Do you deny meeting him on that day?
Chairperson, may I invoke the privilege of not responding to the question so I don't incriminate myself?
And you also do deal with this exchange of documents in your affidavit, but not specifically the meeting at paragraph 11. You say at paragraph 11, I deny that, I think it's meant to say, I had met anyone from the NPA, nor am I aware of the document referred to. I intend to raise this matter in the cross-examination. I was not in possession of any document from the NPA. I deny that I shared such a document with Mr. Agreezy or Mr. Watson. It is indeed a lie. Mr. Agreezy must explain about this document in the cross-examination. I had no reason to get involved in their business. Do you stand by that denial that you handed over this confidential police information to Mr. Agreezy and Mr. Watson on the 27th of September 2015?
Chairperson, may I not respond to the question? I don't want to incriminate myself.
Ms. Myeni, can you tell us when the former president's birthday is?
Chairperson, may I not respond to the question? I wouldn't want to incriminate myself.
You see, from publicly available information, it appears that the former president's birthday falls on the 12th of April each year. And if that is so, it seems to me, at least, and I'd like your comment on this, to be unlikely that you would have a meeting in September of 2015 at which you were requesting a donation for the president's birthday event, because his birthday would have passed a few months earlier, or it would have been many months in the future. Do you agree with me it's unlikely that you'd be asking for a donation for the former president's birthday event in September of a year?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Ms. Myeni, as I understand your affidavit before this commission, you are accepting a different meeting may have taken place at the Sheraton with Mr. Agreezy, but you are denying that this specific meeting took place. And if that is indeed your denial, I'd like to probe the denial a bit further, because there is a series of independent evidence that this commission has received, which I'm going to put to you, tends to indicate that you were present at the Sheraton on the 23rd of September 2015. So I want to take you to each element of that independent evidence. The first is that let me start. Who is Mr. Nick Linnell, Ms. Myeni?
Chairperson, may I not respond to the question that is being asked in case I incriminate myself?
You see, the Commission has received evidence already from Mr. Linnell in which he says that he was an advisor, generally speaking, to you, and that he was quite involved in the SAA matters, certainly in 2015 and 2016. Can you confirm that?
Chairperson, may I not respond to the question so that I don't incriminate myself?
I think in his evidence, my learned friend, Mr. Seleka, put it to him that he's been described as Mr. Fix-It. Are you aware of that description of Mr. Linnell?
Chairperson, may I not respond to the question so that I don't incriminate myself?
You see, Mr. Linnell was invoicing SAA between 2015 and part of 2016 for a number of services he was providing to SAA. So what we were able to find, and I'm going to come to the topic of Mr. Linnell in due course, but what we were able to find among those invoices was an invoice that he settled at the Sheraton Hotel, which puts him there on the 22nd and the 23rd of September 2015. Can you confirm that Mr. Linnell, who would regularly provide advice to SAA, was also at the Sheraton Hotel on those dates?
Chairperson, may I not respond to the question so that I don't incriminate myself?
I would like to just show you his invoice from the Sheraton so that there can be no debate on the matter. I'd like to take you, Ms. Myeni, for that purpose, to your bundle that you have in front of you, DD34B, at page 1631. And you'll find it under tab 27.
I have it, Chairperson.
So this is an invoice that Mr. Linnell submitted to South African Airways for reimbursement. And you'll see at the top right-hand corner, there's the emblem of the Sheraton. You'll see there, interestingly, that he was staying in room 619. I'm going to take you to the evidence that's already been presented to the Commission that you were staying in room 616 on these dates. Well, you stayed actually an extra date to the one that Mr. Linnell stayed. So you'll see in the columns on the right-hand side, it says room number 619, and it says arrival 22:09:15 and departure 23:09:15. Can you confirm that Mr. Linnell was staying at the Sheraton over the same dates that you were staying at the Sheraton, Ms. Myeni, in September of 2015?
May I not respond, Chairperson, in case I incriminate myself?
Can you tell us what you and Mr. Linnell were doing at the Sheraton on the 22nd and 23rd of September 2015?
May I not respond, Chairperson, in case I incriminate myself?
Now, the Commission went to some extensive lengths to interrogate the photographs that Mr. Agreezy testified he had taken on that date of the 23rd of September 2015, when, on his version, you handed over the confidential police information to him. Do you recall his evidence about the photograph and then the efforts that were taken by the Commission to verify the carpet that appears on the photograph? Are you aware of that evidence?
May I not respond, Chairperson, in case I incriminate myself?
You see, not only were efforts made to go and check what the carpet looked like on the 6th floor of the Sheraton Hotel, where this alleged exchange took place, according to Mr. Agreezy's evidence between you and him and Mr. Watson. The Commission also went to the lengths of analysing the photograph itself, which they were able to take from Mr. Agreezy's device, and evidence was presented by Mr. Frank Dutton, one of the investigators of the Commission, confirming that the analyses that had been done showed that that particular photograph, evidencing the police information and in the background the carpet that he confirmed from his own inspection in loco had the same pattern as the one in the picture, confirmed that the date the picture was taken was the 23rd of September 2015, that the time it was taken was 10:37 in the morning, and they could assess the location of the photographs as having been at the Sheraton Hotel. Now, in the face of that independent evidence, Ms. Myeni, do you persist in your denial that you were involved in giving that document to Mr. Agreezy on the 23rd of September 2015?
I would like to invoke the privilege, Chairperson, of remaining silent and not responding to the question.
Do you deny that?
In case I incriminate myself.
Do you not deny that you were staying in room 616 on the 6th floor between the dates of the 22nd and the 24th of September 2015 at the Sheraton Hotel in Pretoria?
May I not respond to the question, Chairperson, in case I incriminate myself?
Do you deny that your advisor, Mr. Linnell, was staying 3 doors down at room 619 on the 6th floor of the Sheraton on the 23rd of September 2015?
May I not respond, Chairperson, to the question, in case I incriminate myself?
The Sheraton Hotel's records, which Mr. Frank Dutton also addressed in his evidence, confirm that you stayed at the hotel between the 22nd and the 24th of September 2015. And I want to therefore put it to you, Ms. Myeni, that the independent evidence available to this commission indicates on a strong probability that you were there, that you were staying on the 6th floor, that the 6th floor had limited access, that was another part of Mr. Agreezy's evidence, that Mr. Agreezy on the 6th floor of the Sheraton on the 23rd of September 2015 took photographs of confidential police information reflecting in its background the carpet in the floor of the Sheraton on the 6th floor that our investigator went and confirmed in 2019 remained the same patterned carpet. Against all of that evidence, will you deny that you were present on that day?
May I not respond, Chairperson, in case I incriminate myself?
You see, the challenge, Ms. Myeni, is that as the weight of independent evidence mounts, a bald denial on your part, or as is happening today, a refusal to engage in any of this, I put to you, is going to leave the Commission in a difficult position but to conclude that there is a probability that you were there, and that if Mr. Agreezy is to be believed in his evidence, that you handed over that confidential police information. Do you want to respond to that?
Chairperson, I don't want to incriminate myself.
Ms. Myeni, I'd then like to move to another of the benefits that you are alleged to have received from Bosasa, and that relates to a security installation. Did you have a security installation done at your home in Richards Bay in May of 2014?
May I not respond to the question, Chairperson, in case I incriminate myself?
Did Bosasa pay for that installation?
May I not respond, Chairperson, in case I incriminate myself?
Mr. Richard LaRue gave evidence before this commission because he is the person who testified before the commission that he actually undertook that security installation. Are you aware that he gave that evidence?
May I not respond, Chairperson, in case I incriminate myself?
You were sent a Rule 33 notice in relation to Mr. LaRue's evidence on the 3rd of July 2020. Do you recall receiving that?
May I not respond, Chairperson, in case I incriminate myself?
Now, in Mr. LaRue's testimony, he indicated that this installation at your home had taken place, as I say, in May of 2014. He estimated that it took over 21 days in total to install it because it was a very detailed installation. And he approximated the total value of it when he included labor as well as the actual purchasing of the equipment at 486,514 rand and 63 cents. Are you aware that that installation cost just under R500,000 rand?
Chairperson, may I not respond to the question in case I incriminate myself?
Do you agree that receiving something to the value of just less than R500,000 rand is a substantial benefit?
Chairperson, may I not respond to the question in case I incriminate myself?
Do you accept that if you didn't reimburse Bosasa for those costs, it would have been a gift to you?
May I not respond to the question in case I incriminate myself?
In March of 2014, Ms. Myeni, you were the chairperson of both the SAA board and the Mhlathu's water board. Can you confirm that?
Chairperson, may I not respond so that I don't incriminate myself?
The conflicts of interest policies at both of those entities require gifts to be declared. Are you aware of that?
May I not respond, Chairperson, in case I incriminate myself?
Chair, in Ms. Myeni's bundle, there are affidavits that we have obtained, both from Mhlathu's water board as well as from SAA. I don't think it's necessary to go there now. With your leave, and if Ms. Myeni is comfortable with it, I will simply summarize what they say about their records on gift disclosures, if I may.
Yes, no, that would be fine. Do you have any problem with that, Ms. Myeni?
I do not, Chairperson, although I am part of the people that would actually develop some policies relating to conflict of interest and ensure and enforce such policies at every board and every institution that I've presided over. But I'm happy that Ms. Hoofmeyer reads the policy if the Chairperson allows her. It can educate many other people.
Yes, well, let's start with the conflict of interest policy that operated at SAA at the time. because that conflict of interest policy, and I quote, required non-executive board members of SAA to declare all gifts received by non-executive directors in their capacity of officially serving SAA and of a monetary value estimated to be more than 1,000 rand shall be declared by the relevant non-executive director. Were you aware of that requirement in the conflicts of interest policy in May of 2014?
May I not respond, Chairperson, so that I don't incriminate myself?
Now, we asked SAA to go through its records of gift declarations, and the affidavit that has been provided by SAA has indicated that there's no declaration by you, Ms. Myeni, of having received a gift in the order of 486,514 rand and 63 cents from Bosasa at that time. Do you dispute the records of SAA?
Chairperson, may I not respond to the question so that I don't incriminate myself?
The Mhlathu's Water Board had a similar provision. It required declarations to be made of gifts received by board members. And in that case, there was actually a declaration by you having received a gift. It's a declaration you made later, though, in 2016. Do you recall making that declaration in 2016?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Chair, just for record purposes, I'll indicate where that entry is on the Mhlathu's gift register. I don't suggest it's necessary for us to go there unless Ms. Myeni wants us to. The entry of Ms. Myeni for this disclosure in 2016 appears at DD 34B at page 1471. Ms. Myeni, it was a declaration that you'd received, well, maybe let's just go there momentarily. Will you call up 1471 in Exhibit DD 34B?
I have it, Chairperson.
Apologies, Chair, my file is problematic for a moment. Ms. Myeni, this is the register of the declaration of gifts received by any board member of Mhlathu's Water Board. And the page I've asked you to look at, and it spans from 2012, I think it goes up to 2017, this one. No, sorry, it's much more recent. It goes as far as this year. And what it says on the page we're looking at, we searched the whole register from 2012 to 2020 for any declarations that you'd made. And it appears at page 1471. If you look at the 5th line in that table, that there was a gift received on the 20th of January 2016. The first column indicated was received from an entity, I assume, called ZDM. The recipient is indicated as Ms. D. Myeni. The description of the gift received is notebook and pen, and the value is declared at 200 rand. Do you remember making that declaration?
Chairperson, may I not respond in case I incriminate myself?
Ms. Myeni, I put it to you that this entry in this gifts declaration indicates a few things. It indicates that you were aware of your obligation to declare gifts received. Do you accept that?
May I not respond, Chairperson, in case I incriminate myself?
It indicates that you took the receipt of a notebook and pen to the value of 200 rand to be sufficiently important to declare in this gifts register. Do you accept that?
May I not respond, Chairperson? I wouldn't want to incriminate myself.
And I also put to you that it indicates that a failure in May 2014 to declare a gift of 486,514 rand and 63 cents would have been in breach of this policy. Do you accept that?
May I not respond, Chairperson, in case I incriminate myself?
Now, Ms. Myeni, you'll recall when I dealt with the SAA policy on conflicts of interests, the way that policy works is it requires the declaration to be made if it is a gift received, and I'm quoting now, in the capacity of officially serving SAA. Were you aware that that was the way in which the obligation was framed in the SAA conflict of interest policy?
May I not respond, Chairperson, in case I incriminate myself?
You see, in fairness to you, Ms. Myeni, it may well be that had you come before this commission today to answer the questions and not invoke the privilege, you might have said, well, this installation was not in any way related to my official capacity at SAA. Do you think if you were minded to have given your version, you might have raised that point of contention?
Chairperson, with your permission, may I not be fed words to say or to have said to, maybe if I was somewhere else, I would have said something. I prefer to say, here is my response, and I stand with the response I'm making that says, may I please, with your permission, invoke the privilege of not responding to the question.
Ms. Myeni, Mr. Agreezy testified before this commission that a few months, I think it was 2 months after the September 2015 meeting, there was another meeting that took place where Bosasa was meeting with the SAA CEO at the time because it was interested in pursuing security and catering contracts with SAA. Do you remember that evidence of Mr. Agreezy?
May I not respond, Chairperson, so that I don't incriminate myself?
We got in contact with the then SAA CEO, Mr. Nico Bezuidenhout, to find out from him whether he could recall any such meeting having taken place. And he provided I'm going to say a statement, I'll explain why in a moment, to the Commission. I'd like to take us to it, if we may go there. It's in the same bundle we've been dealing with, DD 34B, and it commences at page 1558 of that bundle.
I have it, Chairperson, an affidavit.
Thank you. Chair, this is an affidavit that we haven't come to yet, and so I'd like to request that we enter it as an exhibit. This will be in accordance with the Index Exhibit DD 34B.25. But Chair, if I could just request before we enter it into the record that I can give the explanation of why I'm calling it a statement and not an affidavit, despite the fact that it says affidavit on the first page.
Yes, I see that. I think you are going to tell me what I've just picked up.
Yes, indeed.
That the Commissioner of Oath did not sign.
Well, it's not quite that. The situation is such that this was prepared by Mr. Bezuidenhout and signed on the 29th of October 2020. You see that date on the last page where the Commissioner should have signed.
Yes.
But and we have his communications on this with the Commission. He was at that point in isolation for reasons similar to Ms. Myeni.
Yes.
And so what he did was he provided this signed. It was prepared as an affidavit because he had every intention of deposing to it.
Yeah.
And the arrangement we reached with him is that as soon as he's in a position to go before a Commissioner of Oaths, he will properly depose to it.
Yes.
So that will come before the Commission. But we needed to have this version to put to Ms. Myeni today. So we made that arrangement in the circumstances with your leave.
Okay.
So if we could enter it as Exhibit DD 34B.25.
Is that DD 34B point?
0.25.
25. The statement stroke affidavit by Mr. Nico Bezedino, starting at page 1558, is admitted as Exhibit DD 34B.25. I take it you will seek to have it replaced with
Indeed.
one which has got the Commissioner's oath.
Indeed.
As well.
Indeed.
Yeah. Okay, all right.
So for now, I just want to enable you, Ms. Myeni, to respond, should you wish to what Mr. Bezuidenhout confirms here. If we start at page 1559.
Well, I guess we start by saying who he is.
Apologies,
He was
Chair.
acting CEO of SAA from 10 November 2014 to 10 July 2015.
That's
That's
correct.
what he says, yeah.
Indeed.
Yes, you may proceed.
Chair, I realize that I have made an error in dates, and I need to just correct that. You'll see here at paragraph 4 on page 1559,
Yes.
Mr. Bezuidenhout says there, first, I do not carry any awareness of any meeting Ms. Myeni had at Bosasa's offices and was never informed of such. He was asked generally to indicate to the Commission what knowledge he had of any such meetings. So he indicates, firstly, he had no awareness of any meeting that Ms. Myeni, you may have had at Bosasa's offices. But then what he goes on to say is that you did, shortly after he assumed his acting CEO role at SAA, in November of 2015, and at a time when Air Chefs was experiencing operational difficulties, suggest that Air Chefs should consider engaging with and getting advice from Bosasa. And he says that you had said that Bosasa was experienced in providing meals at large scale on a daily basis. And he goes on and says that they, according to you, Ms. Myeni, had proven this capability in the prison service. And he says, and I'm under correction, I seem to recall she also mentioned hospitals. Do you remember having that conversation with Mr. Bezuidenhout?
Chairperson, may I not respond? I wouldn't want to incriminate myself.
It goes on and says that you advised that the CEO of Bosasa was traveling in Johannesburg. He says it was on a Saturday morning, as I recall, and that Ms. Myeni was in Johannesburg on the day, and you asked him if he could join for an introductory meeting at the Intercontinental Hotel. Do you recall having that conversation with Mr. Bezuidenhout?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Chair, I indicated that I had made a date error. I want to just explain why I think I've made a date error, but I suspect that
You
it
might
might
not have.
not be my error, yes, and that it may be necessary to go back to Mr. Bezuidenhout. You see, what I noticed as I was going through the affidavit, Chair, is that Mr. Bezuidenhout says at paragraph 1 that he was the acting chief executive officer for SAA from 10 November 2014 to approximately 10 July 2015. And then he goes on to talk about these interactions, and he talks about them having taken place in November of 2015. And he says that that was shortly after assuming his acting role at SAA. Chair, that date doesn't make sense in the context of paragraph 1. So we're going to need to get clarity from Mr. Bezuidenhout. It may be that there's an error in the year, that he's put in 2015 when he means 2014, because that would accord with his first paragraph, where he says he took up the position from approximately 10 November 2014. It's then consistent to say shortly thereafter there was this interaction. And certainly my knowledge is that he was there at that time. It's November 2014 to mid-2015. He's not in that role at the end of 2015, because that's when a lot is happening with Ms. Mshe, who was filling the role, and then Mr. Zwane, who replaced her. So that created the concern in my mind about the dates, but subject to a clarification from Mr. Bezuidenhout that there's an error in his paragraph 4. It should be November 2014 and not November 2015. I then want to go on to tell you, Ms. Myeni, what he says about the meeting. And for present purposes, I'd like us to assume that it took place in November of 2014, given what I've just said. So if we go to paragraph 5 on page 1559, that is where he indicated that you said that the CEO of Bosasa wanted to have this meeting, and you asked him whether he could join it at the Intercontinental Hotel. And then at paragraph 6, he says, and I'm quoting, "When I arrived at the hotel, Ms. Myeni introduced me to Mr. Gavin Watson as Bosasa's CEO and Mr. Angelo Agrizi as COO. I cannot specifically recall, but there may have been a third unknown person, but I'm not sure." He says, after introductions, Mr. Watson proceeded to do a prayer, and then discussions went into general topics and took a religious tone. Ms. Myeni, did you know Mr. Watson as a religious person?
Chairperson, may I not respond to the question in case I incriminate myself?
Did you ever attend other meetings where Mr. Watson would open the meeting with a prayer?
Chairperson, may I not respond to the question in case I incriminate myself?
He goes on at paragraph 7 on page 1559 to say, without the discussion having any objective, as far as I knew, I'm quoting from him, other than being an introduction, one of the parties, I do not recall which one, referenced SAA's security tender that was in progress at the time, and, as I recall, appeared to question whether the tender was being fairly handled. He says, I stated that whilst I'm not directly involved with the tender, SAA's tender processes entail various checks and balances, and that no information had been brought to me, that's him, to indicate that the process, as far as the security tender, was not being fairly handled. He then goes on and at paragraph 8 it says, one of the parties, again he doesn't recall which one, turned to Bosasa's experience in running large-scale canteens and that there may have been assistance in this regard at Air Chefs. He says, I advise that the management team at Air Chefs will review all possible suppliers and interventions as the need to improve Air Chefs' delivery was topical amongst SAA group management. Do you recall those discussions having taken place at this meeting in November of 2014?
May I not respond, Chairperson, in case I incriminate myself?
He says at paragraph 9 that the meeting then concluded, as he recalls it, with Mr. Watson asking whether, and I'm quoting now, I had any personal security concerns, and me advising that no, I had not, and that SAA's security division, as is customary for CEOs or acting CEOs, had performed a security risk assessment at my property. And he goes on and says the meeting then concluded. Do you remember that discussion having taken place at that meeting?
May I not respond, Chairperson, in case I incriminate myself?
He says at paragraph 10, following the meeting, I obtained confirmation from SAA's head of security that the then current tender process for SAA security services was being conducted fully compliant to SAA's procurement procedures. And he goes on finally to say at paragraph 11, I further notified the Air Chef's acting CEO of Bosasa's claimed capability for consideration amongst the other possible service providers or interventions the Air Chef's team were considering at the time. And then he says he had no subsequent interactions with Bosasa. Did those, Ms. Myeni, again, just for your version, do you confirm that any of those accounts of the meeting took place?
May I not respond, Chairperson, in case I incriminate myself?
Ms. Myeni, the evidence about the security installation at your home was first received by the Commission through Mr. Agreezy, and as I indicated to you earlier, Mr. LaRue then gave evidence to confirm that he had done the installation at your home in Richards Bay. He gave the approximate value of it. He indicated how many days it had taken. And then the Commission has identified that in October of last year, a search and seizure warrant was obtained by the Hawks in relation to the evidence that had been given at the Commission. Are you aware of that?
May I not respond, Chairperson, in case I incriminate myself?
The search and seizure was, well, for reasons that will become apparent, I don't actually think I should refer to it as a search and seizure. An operation took place in October of last year pursuant to that warrant at your residence in Richards Bay. Can you confirm that?
Chairperson, may I not respond to the question so I don't incriminate myself?
Mr. LaRue was involved in that operation, as was Captain Nevan of the Hawks, and both of them have deposed to affidavits which appear in your bundle, Ms. Myeni. I'd like to go to first Mr. Nevan's affidavit. You'll find that at DD 34B at page 1936. No, sorry, I think that page is incorrect. I think it starts at 1941. Oh, sorry, I've got confused.
I have it, Chairperson.
Let's start, apologies, Chair. I'd like to start at 1936, but that is not Captain Nevan's affidavit, that is Richard LaRue's affidavit. So do you have 1936 in front of you, Ms. Myeni?
Have you got page 1936?
Yes, I do, Chairperson.
You do, okay, all right.
Chair, this is the first time we're coming to this affidavit of Mr. LaRue. Now, this is actually the fourth affidavit that Mr. LaRue has provided to the Commission. May I request that we enter it as Exhibit DD 34B.37 in accordance with the index?
The affidavit of Mr. Richard LaRue, starting at page 1936, is admitted as Exhibit DD 34B.37.
Chair and Ms. Myeni, what Mr. LaRue begins by doing is really just for locating the reader, talks a bit about the previous evidence he's given. He confirms again that he did the installation, that there were invoices identified which reflected the equipment that he purchased between the 21st of May and the 26th of May 2014. He again confirms that it took approximately 21 days. He confirms who he was with when he did the installation. He confirms where they stayed, etc. And he concludes at page 1937 to say at paragraph 13, all the expenses relating to the security equipment, the costs, the labor, the accommodation, and the travel were all paid for by Bosasa or African Global Operations. And in paragraph 14, he says, I, in my duty as head of special projects, have no personal knowledge of what, if any, arrangements had been made by Bosasa and Ms. Myeni in regard to the costs made by Bosasa or African Global Operations. Ms. Myeni, I think I asked you earlier, but in case I didn't, can I just confirm, did you ever reimburse Bosasa for the 486,514 Rand and 63 cents that this installation cost? I'm worried we may have...
Did you hear that, Ms. Myeni? Can you still hear us? It looks like she can't hear us.
There was
disconnection.
Yeah, I can hear you now, Chairperson. There was no connection.
Okay, all right. Ms. Hofmeyer will repeat her question.
Yes, I was just asking Ms. Myeni for confirmation whether you ever reimbursed Bosasa for the 486,514 Rand and 63 cents that this installation cost at your home.
May I not respond, Chairperson, so I avoid incriminating myself?
I guess, Ms. Hofmeyer, when you say installation costs, it sounds like it's just labor costs.
No, I shouldn't.
You mean including material?
Indeed, indeed.
Yes.
So that is an estimate of the approximate cost, this is dealt with at paragraph 12, of the equipment and labor, as he previously set out. Thank you for that clarification, Chair. Chair, just before I continue with the questions, I've just been sent a note by the Secretariat of the Commission that they are having difficulty making contact with Ms. Myeni's lawyers to arrange for the drop-off of the hard copy file in Pretoria.
Yes.
So I've been asked if I could just ask my learned friends if they can please make arrangements so that that contact can be made so that we can facilitate the drop-off as soon as you're able to do so. Thank you.
Okay, and somebody will tell them who to contact within the Commission to make that possible.
Well, as I understand it, the Commission has the contact number and is endeavouring to contact the legal representative.
Oh, okay.
He hasn't answered those calls,
Yes.
but the person is waiting to make the delivery. Okay. So just so that you know, we're ready and waiting, and at any point that contact can be made, we can facilitate the delivery. Thank you.
Okay. Because that delivery is urgent, let me find out whether you think you will be of assistance in this regard.
Sorry, Chair, unless we take like 5 minutes and see what we can do, because now we're following the evidence.
Yes. Okay, let's take a 5 minutes adjournment so that, because I was thinking that if we take a short adjournment, it may well be that Ms. Myeni, who hears what Ms. Hofmeyer has just said, might on her side also contact her attorney to say, please make yourself available. The Commission is trying to contact you to deliver a bundle. So let's take, shall we say 10 minutes, it's 11:25. Let's resume at 12:25.
Thank you, Chair.
We adjourn.
adjournment, and Ms. Myeni, we were looking at Mr. Richard Leroux's fourth affidavit before the Commission, and we were at page 1937, and I'd like us now to turn up page 1938, which commences with paragraph 15. Chair and Ms. Myeni, it's not a very long affidavit, and it's quite an important piece of evidence before the Commission. And so I'm going to propose just to read parts of it into the record, also for your benefit, Ms. Myeni. It has formed part of your bundle, but you may not have had an opportunity to look at it in detail. What Mr. Leroux starts to recount from paragraph 15 is an operation that he was involved in October of last year. And just to, Ms. Myeni, are you...
Just a second, are you settled, Ms. Myeni?
I am, Chairperson, thank you. I have the page in front of me.
Okay, all right.
So, Mr. Leroux was involved in this operation in October of 2019, and I just want to locate us in time before, as I did before the break. Mr. Agreasy gives evidence in early 2019. Mr. Leroux himself gives evidence in mid-2019, and then this is what follows. There's an operation conducted by the Hawks at Ms. Myeni's home in Richards Bay, and what Mr. Leroux is now going to tell us about in his affidavit. So he says at paragraph 15, in or about October 2019, I was taken to Durban by vehicle with Captain Nevin of the South African Police Services, the Hawks, together with other members of the South African Police Services, the Hawks. Captain Nevin requested me to assist him in pointing out both the premises and the equipment myself and my team installed at Ms. Myeni's house on the instructions of Bosasa and Gavin Watson. I remember there was also a police photographer that came down with a group of people. Captain Nevin will be able to give more details as to the names and ranks of the people that came down with us. And I just pause here to indicate we have obtained, Chair, an affidavit of Captain Nevin. Mr. Leroux goes on to say, to the best of my recollection, we went down to Durban on a Wednesday in October 2019, where we slept over at a hotel in Durban, and we left Thursday morning for Richards Bay by road. We travelled down in 2 vehicles. Captain Nevin asked me if I was in a position to point out the premises to him, as he did not want to give me the address. And when we arrived in Richards Bay, I took them to the premises and pointed it out. When we arrived at the premises, Mrs. Myeni was not there, and we were not able to get access to the premises. We spent many hours sitting outside the premises, and the South African Police Service were busy in telephonic discussions with both the State Advocate and what I understood were Ms. Myeni's lawyers. We did not gain access to the house, and then we left to return to the hotel in Durban. We travelled at approximately 6 a.m. the next morning back to Richards Bay, and after various phone calls between the lawyers, when we arrived there, we were given access to only certain parts of the premises. I personally waited outside until I was called by Captain Nevin to come onto the premises. We only gained access on the Friday. Ms. Myeni, I'm now over at page 1939, and I'm reading from paragraph 25. What Mr. Leroux then says is, when I went onto the premises, I was able to point out various of the equipment that I'd installed, but this was only on the outside of the premises, and I pointed out certain items inside the premises. The Hawks were unable to get access to other parts of the house, as these were closed off with trellis door, and no one had keys in order to open same. The main equipment that I, together with my technicians, had installed was contained in the main office inside the house, to which no access was provided on the day of the search warrant execution. This consisted of the switches and the main system that operated the security equipment. The Hawks were also unable to get access to the passage where I and my technicians had installed the alarm panel, which had controlled the passives and the beams for the alarm system. The Hawks were also unable to get access to the garage, where I had installed the energizer, which had controlled the electric fence, which surrounded the premises. I recall that while I was doing the installation, there was a standalone safe inside the room that was used as an office. Towards the garage, there was also a large walk-in safe door, and this safe did not appear to be in any use. I myself have no personal knowledge as to why the Hawks did not gain further access into the premises, and I verily believe that Captain Nevin can give facts relating to why no further access was obtained in terms of the search warrant. From the security equipment that access was obtained, we managed to obtain serial numbers which were taken down by the Hawks and recorded. Members of the Hawks took photographs and kept notes of what I'd pointed out to them. And now from page 1940. After the Hawks had completed the search of the premises, I can confirm no security equipment were taken from the premises. We then left to return to Joburg. I further recall that while we were traveling back to Johannesburg, I was in the motor vehicle when Captain Nevin received a phone call from one of his fellow officers. The context of the conversation that I picked up was that Ms. Myeni was extremely upset about the way in which the search warrant had been executed and conducted, and she had phoned a very senior person in Durban who had contacted Captain Nevin's officers in order to register her complaint. Ms. Myeni, before I ask for your comment on those events that took place in October last year, I'd like us just to look at what the search and seizure warrant entitled the South African Police Service to do at your premises. And you'll find the search and seizure warrant attached to Captain Nevin's affidavit, which is the next document in the bundle. It commences at page 1941. Do you have that?
Yes, Ms. Hofmeyer.
Chair, if we could enter this affidavit of Mr. Charles Nevin into the record as Exhibit DD 34B.38.
The affidavit of Mr. Charles Nevin, starting at page 1941, is admitted as Exhibit DD 34B.38.
So, Chair, I'll return if necessary in a moment to the actual affidavit itself, but what Captain Nevin does is he gives his account, which in substantial measure accords with the account that I've just given of Mr. LaRue, and then he attaches to his affidavit both the warrant itself, which you'll see commencing at page 1946, as well as the application that was made for the search and seizure warrant, which commences at page 1950, and that is accompanied by the affidavit supporting the search and seizure warrant being issued, and that commences at page 1591. Now, what Captain Nevin confirms, he was the deponent both to the affidavit supporting the application for the search warrant, as well as the affidavit that he's provided to the Commission to explain what happened on the days of the execution of the warrant. You see, what he says in essence to the magistrate before he came in order to obtain the search warrant is that, and Chair, I'm going to paraphrase a bit and read pertinent parts where it's appropriate to do so, and also for your benefit, Ms. Myeni. Captain Nevin confirms in his affidavit, pursuant to which the search and seizure warrant was given, that he had been assigned to investigate the commission of the offence that's dealt with further below in the SAPS criminal investigation team. And at page 1952, paragraph 4.2, he says, the offence being investigated at this point in time in the above investigation, which is relevant to this application and which is submitted, is at least reasonably capable of being believed or suspected to have been committed or are being committed, as canvassed in more detail below, is as follows. And then it is offences in relation to corrupt activities relating to public officers that is then set out. Those are provisions from PRECA, as I understand it, the legislation. Oh, Chair, it seems that we might have lost connection with Ms. Myeni.
Oh, yes.
We're looking into it, I can see.
Okay, let's wait. Hopefully the technicians will sort it out quickly.
I am back, Chairperson. There was an connection
Disconnection.
problem.
Oh, okay, all right.
Yes, but I've been following what I've been hearing.
You have been
What
hearing?
the evidence leader was saying.
Okay, all right. Okay.
So what the affidavit does is it identifies that there's an investigation and reasonable grounds for suspecting that offences related to corrupt activities may have taken place. And the evidence is then set out, and that is the evidence of Mr. LaRue that was provided to this commission. Chair, you'll see that, and Ms. Myeni at page 1953 from paragraph 5.2. So what Captain Nevin is effectively doing here is going before a magistrate to get a search and seizure warrant of Ms. Myeni's premises based on the evidence that Mr. Richard LaRue presented to this commission. And that is set out clearly in paragraph 5.2 because he makes reference to the statement of Mr. LaRue before the commission. And then he says that that evidence is enough to warrant the search and seizure, to warrant the issue of the search and seizure warrant. And he concludes with something that I do believe it's necessary to read verbatim into the record. And that appears at page 1956 from paragraph 9 on that page. You see, paragraph 9 is headed "The need for the search and seizure of the articles referred above." And what Captain Nevin says in this affidavit, pursuant to which a warrant was issued, is the following. It is submitted that there is a need to secure the articles concerned by way of a search for and seizure of the articles at the premises concerned and in terms of a warrant that has been applied for and issued. 9.2, the reasons are: the above articles will form part of the evidence to strengthen the truthfulness of the allegations made against the suspect, thus strengthening the state case. The said Ms. Dudu Myeni is the alleged perpetrator of the offence concerned. Any other manner of attempting to secure the articles concerned will forewarn the said Ms. Myeni. In this circumstance, the said Ms. Myeni is likely to take all reasonable steps she can to hide, destroy, or otherwise prevent the articles being secured for the purposes of the investigation. And then he seeks a warrant in the terms that were attached to his affidavit, and that was a warrant entitling the Hawks to go to Ms. Myeni's premises to obtain access, to search for the various articles of security equipment that Mr. LaRue had testified about before this commission, and to seize those articles because, and I emphasize again, their view was that there would otherwise be a risk that that equipment could be hidden, destroyed, or otherwise prevented from being secured for the purposes of an investigation. And they made it clear that that would be evidence necessary in any subsequent case involving Ms. Myeni. So, Ms. Myeni, I've indicated to you the basis upon which the warrant was sought and obtained, and I've indicated to you what Mr. LaRue has said about how that search warrant was executed. Can you confirm whether these events did take place as Mr. LaRue describes them in October of last year?
I invoke the privilege, Chairperson, of not responding to the question so that I don't incriminate myself.
Ms. Myeni, I would like to put it to you that it is quite remarkable that the police service of our country could obtain a search and seizure warrant to secure evidence that may be relevant in a criminal trial, to arrive at your premises to seek to execute that warrant and to be kept outside the premises for a full day, only to return the second day? Were you involved in barring their entry for the first day to your premises?
Chairperson, may I not respond to the question that is being asked so that I don't incriminate myself?
When the police arrived on the second day, they were then permitted access, but they were not permitted to access the whole of the premises. Were you involved in giving an instruction that they could only access parts of the premises?
Chairperson, may I not answer the question so that I don't incriminate myself?
You gave evidence yesterday that no one accesses your premises without your permission. So I put it to you that it is likely that you were responsible for the instructions that denied access to certain parts of the premises. Can you confirm that?
Chairperson, may I not respond to the question so that I don't incriminate myself?
The police were there with Mr. Leroux, whose evidence before this commission is that he made these installations himself, and he told them that in the parts of the house and the garage that they were not permitted to access, he had installed the very equipment that the search and seizure warrant entitled the police to look for and seize. Did you give a specific instruction that they would not be permitted to do that?
Chairperson, may I not respond to the question in case I incriminate myself?
Ms. Myeni, if you did give this instruction, do you have any idea of why the instruction was abided?
Chairperson, may I not respond to the question in case I incriminate myself?
Ms. Myeni, maybe you can assist the Commission with indicating to us how it can happen that a search and seizure warrant is authorized by a magistrate, that police travel down to your home in Richards Bay, that they are delayed for the first day, they return on the second day in circumstances where the very reason that they got this warrant is because they said that there were reasonable grounds for suspecting the equipment may be hidden or destroyed or otherwise prevented from being accessed. And then when they finally are given access, they only are given access to parts of the house. How does that happen, Ms. Myeni?
Chairperson, may I not respond so that I don't incriminate myself?
The final point I want to pick up on is you gave evidence yesterday that you don't have a safe, either in your office, in your house, or in your garage. Mr. Leroux says you do. Is he lying?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Ms. Myeni, I put it to you that you are, well, you have been and you are, remain a powerful person. You're a person who can delay the police executing a search and seizure warrant as recently as October of last year. Do you have a response to that?
I cannot comment, Chairperson, on somebody's view unless I'm asked a question about Ms. Hofmeyer's view, Chairperson. He's made a view, it's his opinion. I cannot comment on somebody's opinion.
Ms. Myeni, your way of engagements with institutions of the state is something on which this commission has also received other evidence. And that was evidence in relation to the activities of the State Security Agency at SAA while you were chairperson of the board. And that is the topic I would like to move to next. And just with the caveat, Chair, I ordinarily would have concluded the Bosasa evidence, but we will come back to the travel benefits once Ms. Myeni has the bundle. But we're now going to move to the State Security Agency. Ms. Myeni, you had protection services provided to you from the State Security Agency, correct?
May I not respond, Chairperson, in case I incriminate myself?
You received those protection services according to the evidence of Mr. Y before this commission from a special operations unit within the State Security Agency. Can you confirm that?
May I not respond, Chairperson, to avoid incriminating myself?
Chair, when Mr. Y gave evidence, one of the things that was attached to his affidavit was the high-level review panel's report into the activities of the State Security Agency. That panel had found that this special operations unit of the State Security Agency was, quote, a law unto itself, and it was found to have, quote, directly served the interests of the executive. Chair and Ms. Myeni, I don't suggest we go there, but just for the record, that reference is in Exhibit DD 23 at page 237. What that report also confirms is that those who receive protection services from the Special Operations Unit were not entitled to it. Ms. Myeni, before you received these services, did you ever make inquiries as to whether you would be lawfully securing them?
Chairperson, may I not respond to the question to avoid incriminating myself?
Mr. Y's evidence was that no security assessment seems to have been done on you before these protection services were provided, according to the records of the State Security Agency. Can you dispute that?
Chairperson, may I not respond to the question so that I don't incriminate myself?
For the record, Chair, that aspect of Mr. Y's evidence can be found in the record at Exhibit DD 23, page 12, paragraph 5.3. The evidence of Mr. Y, Mr. Munsami, whose affidavit was presented when Mr. Y gave evidence, is that those state security personnel who were providing you with protection services were also on occasion involved in confiscating items from members of the board of SAA while you were its chairperson. Do you dispute that?
May I not respond, Chairperson, so that I don't incriminate myself?
Evidence has previously been received by this commission that you on occasion would insist that members of the board and management of SAA leave all recording devices, well, devices capable of recording, so cell phones, laptops, etc., outside of meeting rooms, and you further would require any notes from meetings to be torn up before people left the meeting. Do you dispute that?
Chairperson, may I not respond to that question so that I don't incriminate myself?
Ms. Myeni, do you know why you were provided with these services despite the fact that they were not lawfully procured?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Ms. Myeni, why did you arrange for the State Security Agency to conduct a security vetting operation on the managers and support staff at SAA?
Chairperson, the question that is being asked is factual question. Why did I arrange? Or somebody has alleged, or it's a fact? Just clarity, Chair. I'm requesting respectfully for clarity.
Yes, I'll certainly assist Ms. Myeni. What we did in the evidence last year is we had Ms. Myeni, who I understand conducted the operation, the security vetting operation at SAA, give evidence. Do you know Ms. Myeni?
Chairperson, may I not respond to the question so that I don't incriminate myself?
It was Ms. Myeni whose evidence was that it was pursuant to engagements between yourself and then Minister Mahlobo that the security operation was undertaken. Can you confirm that?
May I not respond, Chairperson, so that I don't incriminate myself?
When Mr. Myeni gave evidence, we were taken to the exchange of letters between Minister Mahlobo and Minister Nene at the time, in terms of which the security vetting operation had been authorized. And what was given in that correspondence as the basis for the operation was that there was, quote, sensitive information that was being received on an ongoing basis by the management and support staff of SAA. Do you recall being concerned about the receipt of sensitive information by managers and support staff at SAA?
May I not respond to the question, Chairperson? So that I don't incriminate myself.
Chair, again for the record, that letter from Minister Mahlobo to Minister Nene, in which this basis for the operation is set out, can be found in Exhibit DD 24, page 17. And also, just for the record, the evidence of Ms. Myeni occurred on the 19th of February 2020. Now, Ms. Myeni, in the course of Ms. Myeni's evidence, we established with her that the entire vetting operation was not in accordance with the governing legislation. Are you aware of that evidence having been given?
Chairperson, may I not respond to the question in case I incriminate myself?
You see, what we probed with Ms. Myeni is that in terms of the governing legislation, these types of operations can only be conducted where classified information is being accessed by those who will be security vetted. And that classified information is something different from sensitive information. Before this operation was conducted at SAA, did you ever take time to consider that distinction between classified information and sensitive information?
Chairperson, with your permission, can Ms. Hofmeyer read the letter that she is talking about?
With pleasure.
Or show me the letter that she is talking about?
With pleasure.
She
Let's
will
go
do
to
so.
it.
She will do so, Ms. Myeni.
Now, for this, Ms. Myeni, it's a DD bundle, so I'm cautiously optimistic that you have it with you. It's DD 24 at page 17. So if you'll just find that bundle, and then we can look at the letter.
I have the letter, Chairperson.
So this letter, Chair and Ms. Myeni, appears as an annexure. Oh, apologies, Chair, you don't have it yet. Let me just
Not
pause
yet.
for a moment. Ms. Myeni was quicker than you or I in taking the bundle, so. It will be page 17.
Yes, I've got it now. I've got it, Ms. Hofmeyer.
Thank you, Chair. Ms. Myeni, I was just also locating you. So this is the first annexure to Ms. Myeni's affidavit, which precedes it in this Exhibit DD 24. And what you'll see there is it's a letter. If you go over the page to 18, it's the letter that the then Minister of State Security, Mr. David Mahlobo, writes to the then Minister of Finance, Mr. Nene. And this is a letter that was copied to you, the chairperson of the board of SAA. Do you remember receiving this letter around October of 2015?
May I not respond, Chairperson? The reason why I asked the Chair was for the record, the letter be read as I requested to you, Chairperson, because it appears from what is being said and asked, I am the one who asked for the security vetting of all South African state-owned enterprises. And I don't think there is any chairperson who sits in any cabinet to take such decisions. That is why, Chairperson, I'm asking for the record that these letters be read, because there is an insinuation that I would use state organs and the views that have been expressed here, which are unfair views, Chair. I am here as an innocent person, and the way in which the evidence leader is trying to knit questions, is trying to put my security issues back in my house, that any person can just access somebody's house without her being present in the premises. And I can see that I have no rights as a black woman, because no white woman who has a house without her being in the premises can allow just about any person to walk into the house. Here now, I am the one who has given the cabinet a decision to vet all state-owned enterprises. It cannot be so. I am here because my guilt is the association with Jacob Zuma. So it can't be. As Chairperson, I would like, with your permission, to get the protection. I am an ordinary human being that makes mistakes. Where I make a mistake, I admit to make a mistake. But I cannot continuously be associated with certain decisions in state organs that are unfair. This is misleading. That is why I'm asking for the record that the evidence leader read this letter, because now it appears as though I am the one who went and asked Minister Mashoko and Minister Dele to investigate or to vet only South African Airways staff. It cannot be. I protected the staff of South African Airways through and through when I was chairperson there. That's chairperson.
Okay, Ms. Hoffmeyer will read that letter, or she might ask you to read it, so that it's read into the record. I just want to say about other matters that you have raised, that when there is only one side of the story, it could give rise to certain perspectives. So where you are able to put your side of the story or your perspectives, it helps to give a balanced view. But when I say that, I'm not saying that you mustn't invoke your privilege if you consider it appropriate. I'm just mentioning that there is a disadvantage, or there are disadvantages when there is only one side of the story as compared to when there are both sides. So when there is one side, that could easily give rise to misunderstandings or gives rise to certain perspectives which might not be there if there are all sides placed before the commission. Ms. Hofmeyer, are you going to read it, or are you going to ask her to read it?
Chair, I will read it with pleasure. I do just want to indicate one point of clarification.
Yes.
Because I do want Ms. Myeni to understand that, and the record will show this. At no point did I, in my questioning, state that Ms. Myeni had been responsible for the arranging of the vetting of all SOEs.
Yes.
That is not something that I said. What I said is that there had been evidence before this commission that she was involved in arranging the vetting of SAA management and their support staff. It's a very different statement, and it is that statement that I'm exploring with Ms. Myeni in the evidence right now. And when she asked for clarification as to where that came from, I made it clear that it came from the evidence of Ms. Myeni, who had conducted the operation at SAA, and who was asked in particular about the background to these letters. So it is not my statement.
Yes.
It is Ms. Myeni's statement giving evidence before this commission. But let me read the letter into the record as Ms. Myeni has requested.
Yes, it's a letter from Mr. David Mahlobo, Minister of State Security, dated 18 October 2015, addressed to Mr. N.M. Nene, Minister of Finance at the time. Yes, continue.
Thank you, Chair. And just to note, it is copied to Ms. Myeni as Chairperson of the Board of SAA. It says, Dear colleague, so this is Minister Mahlobo speaking to Minister Nene. Security vetting of the South African Airways executive management and support staff. 1, the above matter refers. 2, it has come to the attention of the State Security Agency that there is an urgent need for vetting and re-vetting of the state-owned enterprises, given sensitive information received on an ongoing basis. I would just like to pause there. It's precisely how it came to the attention of the State Security Agency that we traversed with Ms. Myeni. Her knowledge of what was happening around this letter was probed with her, and her evidence was that she assumed, I don't recall her having personal knowledge of it, but she assumed that there had been engagements between Minister Mahlobo and Ms. Myeni about this. And certainly the later letter is a letter from Ms. Myeni providing the list of the people who are required to be vetted. Paragraph 3 goes on. SOCs as government entities have a huge impact on the economy of the country, and therefore extremely important for the SSA to conduct security vetting as per Section 1 of the National Strategic Intelligence Act, that is Act 39 of 1994 as amended by Act 67 of 2002, states that, quote, the National Intelligence Agency, in brackets NIA, has the mandate to vet all other national, provincial and local government departments, parastatals and their service providers, close quotations. Chair, I should interject there as well, just to give the benefit of Ms. Myeni's evidence. We looked in her evidence for that alleged section from the Act. You may recall this, Chair, and
I recall.
That section does not exist in the Act.
Yes, I
so
recall
it
that.
appears in this letter as though it's quoting from a section of the Act. It cannot be found in the Act. Paragraph 4 over the page reads, this should be understood from the background of challenges affecting most of the state-owned companies. 6, the chairperson of SAA will be required to provide a list of all executive management and support staff. 7, an update will be provided on completion. 8, yours sincerely, and then it's signed by Minister Mahlobo. Ms. Myeni, so that is the letter that you've requested that we read into the record. I had asked you before your last answer whether prior to this exercise being conducted, you'd ever had the occasion to consider the distinction between classified information and sensitive information. What is your response to that?
Chairperson, may I not respond in case I incriminate myself? Thank you.
Now, this was a vetting operation that was conducted at SAA in late 2015. Ms. Myeni's evidence was also that there were no other state-owned entities that were vetted at that time. The only other ones that have been vetted were Transnet 2 years later, in December of 2017, and Eskom in April of 2019. So during the period of 2015 and 2016, there was no other vetting going on of SOEs. That reference you'll find, Chair and Ms. Myeni, in Ms. Myeni's affidavit, which is earlier in the bundle, DD 24 at page 15. Now, Ms. Myeni, one question that we probed with Ms. Myeni is the following. If the concern which underscored the need to vet people at SAA was their access to sensitive information, we asked her for her view. Wouldn't it then make sense that not only management and support staff, but also the board members of SAA be vetted? Did you ever consider before this operation whether you and your colleagues on the board should be vetted?
May I not respond, Chairperson, to the question in case I incriminate myself? But Chairperson, yesterday the Chair said, once I've responded to the question, I can say something after I have responded.
Well, if it's a question in respect of which you don't invoke your privilege, and you say something like yes to a question, but you want to explain something, yes, that you can do. So, in other words, or if you say no, but I want to explain something, that's fine. But what I said this morning, which I didn't say yesterday, was that if you invoke the privilege, then you invoke the privilege. You can't give some answer and then afterwards say you are invoking the privilege to that question. So you have to make up your mind on each question. Am I invoking my privilege? If you do, that's what you do. But if you elect to answer, then you are not forced to say yes or no necessarily if you would like to explain something. Obviously, it helps if you are able to say yes or no, or in terms of questions, so that we make progress. But if there is a need to qualify or explain, I will allow you to do that. You understand?
Yes, thank you very much, Chairperson.
Yes.
I understand, and it's clear.
Yes, okay.
What I would like to say, it's a comment to you, Chairperson. It is unrelated to the question that was asked. Under normal circumstances, Chairperson, in state-owned enterprises, board members, before they get appointed, they would be vetted. I'm saying under normal circumstances. This is a comment for you, Chairperson.
Okay. All right.
Thank you, Chair.
Ms. Hofmeyer?
Ms. Myeni, Ms. Myeni indicated that no board members were vetted during this operation in late 2015. Do you dispute that?
May I not respond to the question, Chairperson, in case I incriminate myself?
She indicated that in her view, and I'd like your comment on whether you disagree with this view, if the management and support staff were being vetted because of access to sensitive information, and the board also had access to sensitive information, then the board members should also be vetted on the basis of Minister Mahlobo's letter. Do you agree with that view?
May I not respond, Chairperson, to the view of Ms. Myeni, in case I incriminate myself?
Do you know why this operation was conducted? without board members who would have had as much access to sensitive information as anyone else in SAA were not vetted?
May I not respond, Chairperson? May I invoke the privilege so I don't incriminate myself?
Do you think it might have been because the board members didn't want to be confronted with the very intimate questions that management were subjected to when they were, had to undergo the polygraph tests?
May I not respond, Chairperson, to the question so that I don't incriminate myself?
Would you agree that being asked a question like, have you ever had an affair, is a sensitive and intimate matter?
I was not there. Chairperson, may I not respond to this question? May I not respond to this question because I don't want to incriminate myself.
We have received evidence from Ms. Pumeza Nancy before this commission that you conveyed to her that you wanted to use the outcome of the vetting to remove one of the people in the finance department of SAA, Ms. Lindsay Olitsky. Do you dispute her evidence on that count?
May I not respond, Chairperson, in case I incriminate myself?
For the record again, and Ms. Myeni, if you would like to go there, we can. Ms. Nancy's affidavit on the score can be found in Exhibit DD2, apologies, page 22, paragraph 70. Her version before this commission is that you told her to get rid of Ms. Nancy because she'd failed, to get rid of Ms. Olitsky because she'd failed the vetting on account of her dual citizenship. Do you dispute that?
May I not respond, Chairperson, in case I incriminate myself?
Ms. Nancy's evidence was further to the effect that when she had a conversation, I think it was with Mr. Zwane, she felt a bit uncomfortable about this. They were worried that there would be labor issues if this was taken forward, and so she did not take it forward. And she said when she relayed that to you, you said that you were not happy about it. Do you dispute that?
So what did you say? Who told... who sent information to SAA that the person is did not pass the vetting? Sorry, did you say that?
Yes, sorry. So let me go back a step. The outcome of Ms. Olitsky's security vetting was that...
Where is it? On the file, is it here?
Ms. Olitsky's outcome.
Yes.
No, it's not, because the State Security Agency did not provide us with those documents. But we do have an affidavit of Ms. Olitsky confirming that what was communicated to her was that she, that her dual citizenship was flagged as an issue for her security vetting, and she was asked for her attitude in relation to her dual citizenship. So that's the background, Ms. Myeni, but what I was putting to you was that Ms. Nancy gave evidence in this commission that you, Ms. Myeni, said to Ms. Nancy that you wanted to remove Ms. Olitsky on the grounds or following from the fact that she had failed the vetting on account of her dual citizenship. Do you dispute having said that to Ms. Nancy?
May I not respond to this question?
Is that on the grounds that it may tend to incriminate you?
Sorry, Chairperson, I missed that. There was a bit of a delay.
Or she's asking whether that is on the grounds that you don't want to incriminate yourself.
Yes, I completed the sentence, Chairperson. I did.
Okay, we
apologies.
didn't hear this side.
Ms. Myeni, because you've raised the issue, I actually do think it's fair to you to read exactly what Ms. Nancy said on this score. And would you like to take up the bundle? It's DD2, so you can have it in front of you.
Chairperson, I thought there was a letter that Ms. Hofmeyer was referring to that came from the state security that made or communicated the outcomes of vetting. That was the main question that I was asking, because I heard Ms. Hofmeyer saying it was communicated to her. I thought she's referring to me communicating to her.
She's going
Not
to...
to Ms. Nancy, not to Ms. Nancy, to Olisti.
Okay, she's going to clarify that.
Yes, let me just be clear, sorry. And you know, there might have been a bit of a break in the transmission.
There was.
So what happens is Ms. Nancy gives evidence before this commission about a conversation that she had with you, according to her evidence. And I just think it's appropriate, given that this is a matter that requires clarity. And in fairness to you, Ms. Myeni, I completely accept that we should be absolutely clear about it. If we go to bundle DD2 at page 21, at paragraph 70, this is in Ms. Nancy's affidavit. Ms. Myeni, you may want to get it in front of you. I see you've gone to do that.
Yes. Thank you, Chair. I've got DD2, Pumeza Nancy.
Okay.
Sorry, Chair.
Yes, Ms. Hofmeyer, I believe I've got it too.
I have DD2, and I have Pumeza Nancy's statement.
Did you say page 21? Ms. Hofmeyer?
21, Chair, yes.
Page 21, okay.
Now, at paragraph 70 at the bottom of that page, just before it, there's a heading, vetting results of Ms. Lindsay Olitsky that were performed by State Security Agency. And I'm reading from paragraph 70 there of Ms. Nancy's affidavit. She says, Ms. Myeni told me that the SSA people are still in progress with vetting for top security clearance certificate, but they are done with some people. She added that one of my staff members failed the vetting due to dual citizenship. She didn't show me the results, only told me who it was. She stressed that the finance department is a very sensitive area. Therefore, I cannot afford to have someone who has failed the security clearance. She suggested that in the following day, I should have an off-site meeting with Ms. Lindsay and first update her about the vetting results and secondly give her two options, either to dismiss her or she could choose an alternative department to work with within SAA Group. I discussed this matter with the acting CEO the following day, raising my concerns about Ms. Myeni's instructions, as it may lead to SAA facing labor disputes, especially when the employees are able to prove that the SSA process was never part of their employment contract when they were appointed by SAA. We then agreed we will discuss this item at the next EXCO meeting, and the company needs to compile or derive a policy that will address this and the policy. I didn't arrange any meeting with Lindsay. Ms. Myeni called me the same day and asked how the meeting went between Lindsay and I. I gave her the update, and she, that's a reference to you as I understand it in the context, was not happy with it. Do you dispute Ms. Nancy's evidence on this issue?
I won't respond, Chairperson, in case I incriminate myself.
Ms. Myeni, I'd like to move from the involvement of the State Security Agency, both in providing protection services to you and in conducting security vetting at SAA, to evidence that has been received in this commission by former Minister Nene and Minister Gordhan. So that those are the topics we're going to move to now.
Yes, Chairperson, I'm ready. Sorry, I was just moving this file. I'm ready.
Okay.
Now, Ms. Myeni, Minister Nene gave evidence before this commission about a meeting that he was called to in November 2015.
1 second, Mr.
Oh,
Mayor.
apologies.
I'm giving away this.
Yes, you can
file.
do so.
And DD24, can I give away?
Yes, you can.
Okay,
We've
all right.
completed our work within them. Thank you,
So we
Chair.
just remain with 34?
Yes, indeed.
Yeah, okay, all right.
Now, Ms. Myeni, when former Minister Nene testified before this commission, he gave evidence about a meeting that was called in November 2015 with the former president and yourself. Are you aware of that evidence?
May I not respond to Chairperson so that I don't incriminate myself?
Now, his evidence was that that meeting was called after he had shared concerns about your leadership at SAA with colleagues at an ANC study group meeting. Were you present at that meeting?
May I not respond to Chairperson in case I incriminate myself?
Now, what Minister Nene said is after he'd communicated those concerns at the ANC study group meeting, he surmises that somebody told you. He doesn't have actual knowledge of that, but he surmises because the next thing that happens is he's called to a meeting with you and former President Zuma. I'd like to ask you some questions about that meeting. Can you confirm whether that meeting took place?
I do not have, I do not have a response, Chairperson. May I invoke the privilege of not responding to the question in case I incriminate myself?
Minister Nene said that during the course of the meeting, you complained to former President Zuma about him. Do you dispute that?
Chairperson, may I not respond to the question in case I incriminate myself?
Minister Nene said that during that meeting, he said to former President Zuma that you were obstructive and that you played the media. Do you dispute that he said that to President Zuma?
Chairperson, may I not respond to the question? May I invoke the privilege so I don't incriminate myself?
He also said that at that meeting, he told former President Zuma that the board under your leadership had been acting recklessly. Do you dispute that he told that to former President Zuma?
May I not respond, Chairperson? I wouldn't want to incriminate myself.
Apologies. He also said that he communicated to former President Zuma at that meeting that you should be removed as chairperson of the board. Do you dispute that he said that?
May I not respond, Chairperson, in case I incriminate myself?
He said of that meeting that he also conveyed to former President Zuma that as a result of the crisis situation that was then present in SAA, remember we're in November of 2015, there was a serious threat that the airline would default on its government guaranteed obligations and that would have a ripple effect for the fiscus and the economy as a whole. Do you dispute that he said that to former President Zuma?
Chairperson, may I not respond in case I incriminate myself?
Minister Nene was quite clear in his evidence before this commission that he was concerned about your continuation on the board. But he has also given evidence in which he has indicated that any recommendation for a new board of SAA at that time that did not include you would not pass through cabinet because former President Zuma would not support it. Do you dispute his version on that score?
Chairperson, may I not respond to the question in case I incriminate myself?
Did you and former President Zuma ever discuss the views that Minister Nene conveyed to former President Zuma at that November 2015 meeting?
I beg your pardon?
Did you and former President Zuma ever discuss what Minister Nene had communicated at that November 2015 meeting?
May I not respond to the question? Chairperson, may I invoke my privilege that I was given by you not to incriminate myself. But Chair, please allow me to say something which will not invoke the privilege or maybe respond to the message.
What is that?
It's something, Chair, I would like to just state before you.
Yes.
I said something yesterday, Chair, and I would like to say it. I am guilty, Chairperson, by association of President Zuma. And it appears here there has been very glaring lines to everyone who chooses to make glaring, who chooses not to distinguish properly between the relationship, the professional relationship, and the relationship where a person presides over the Jacob Zuma Foundation. I've been guilty since I assumed office as the chairperson of the Jacob Zuma Foundation. I'm stating this, Chairperson, because a professional relationship and an ordinary relationship, those are two separate relationships. Therefore, I'm just saying this, Chair, because it does bother me. And the Chairperson did say, if something I feel strongly about, I must put it before the Chairperson. I'm still doing the same, Chair, because there has been a narrative that I cannot kill that suggests that being or working for a foundation meant that I would willy-nilly and anyhow discuss issues that are not relevant to the foundation anyway or anytime. And it is a lie that somebody can just use proximity to do certain things that are untoward and that are not professional, that also compromises the formal relationship that is written down, that talks to issues of working and operational matters of either the foundation or South African Airways. And Chair, lastly, may I put it on record that South African Airways was assigned to President Ramaphosa as a deputy president at the time who was responsible for government business. SOEs that were seen by cabinet to be problematic were all assigned under President Cyril Ramaphosa. But as you have seen, Chairperson, that all the time, whenever there is SAA matter and former chairperson's matter on SAA, I would be seen walking with the president who visited South African Airways in the media and paraded as President Jacob Zuma is the only one who visited SAA. President Ramaphosa, as Deputy President, responsible for government business, visited South African Airways, but you will never see a picture of Dudu Myeni with President Ramaphosa on any media. Yet I welcomed him and I walked him out, as I did with President Zuma. And President Cyril Ramaphosa was happy when we met at SAA. And he really sang praises about the work we had done. That, I believe, that was a statement of confidence, because I never worked for his foundation, nor did I have proximity because of the foundation-related work. I'm just putting it across to you, Chair, as something that is inside my spirit to share with you. Thank you, Chair.
Okay, but I must just point out that the questions that Ms. Hofmeyer was putting to you were related to evidence that was placed before the Commission by Mr. Nene in regard to a meeting that he said he had with you and former President Zuma. That's where the questions emanated from. Okay, Ms. Hofmeyer.
Thank you, Chair. Just before your last interchange with the Chair, Ms. Myeni, I'd asked you whether you had discussed what Minister Nene had communicated at that meeting with former President Zuma afterwards. I understand you to have invoked your privilege to decline to answer. So I'd like to ask the next question. Ms. Myeni, in the face of that having been communicated to former President Zuma at the meeting with the then Finance Minister, can you assist the Commission in understanding how, if you did, you managed to persuade former President Zuma to retain you on the board, despite what Minister Nene said was reckless leadership that risked SAA defaulting on loans?
Chairperson, do you have does the Commission have the minutes of the meeting referred to?
I don't believe that there were minutes taken. This was not a minuted meeting. What is your answer to the question whether, on what basis you managed, if you did, to persuade former President Zuma to retain you on the board despite the Minister of Finance having said to him that he was worried that your reckless leadership would risk SAA defaulting on loans?
May I not respond to this question, Chairperson, so that I don't incriminate myself?
Ms. Myeni, former Minister Nene also linked his removal a month later in December 2015, amongst other things, to the views he'd expressed at that meeting about you to former President Zuma. Do you have any insight as to the reasons why former Minister Nene was removed in December 2015?
May I not respond, Chairperson, so that I don't incriminate myself?
Ms. Myeni, are you aware of what happened to the markets the morning after former Minister Nene was removed in December of 2015?
Which markets, ma'am?
Well, it was the impact really on the bond yields and the depreciation of the South African currency the next morning. Are you aware of those impacts?
Chairperson, I need to understand, not the rand-rigged markets related issues. I must get a bit of clarity, because there was too much of the rigging of the rand during that time. And there was also a lot of other economic-related issues that happened in many other places. So I need to know what is specific about this particular question. That when Mr. Nene was removed, the markets performed badly?
Let me be clear. No, in fairness...
Was it the rigging of the rand? Was it the rigging of the rand, or was it the poor performance of general markets? I need to understand because I'm not a finance person.
Yes, Ms. Hofmeyer will respond.
This is, in fairness to you, Ms. Myeni, an issue that the Commission itself has grappled with. And the Commission, in fact, requested National Treasury to do a submission for it about this very thing. It has colloquially been called the impact of Nene Gate. And what the Commission received was an affidavit from the then Director General of National Treasury. And this is what is said in that affidavit, that the morning after the announcement of Minister Nene's removal, there was an increase in bond yields and a depreciation of the currency as investors repriced the risks associated with investing in South Africa. Were you aware that Minister Nene's removal had that impact?
Maybe just
May I not
mention
respond,
the name.
Chairperson, to this question so that I don't incriminate myself? The clarity was well received. Thank you.
Maybe you can just mention, Ms. Hofmeyer, the name of the former Director General who deposed to that affidavit.
Yes, that was Director General
record.
Madondo.
Okay.
Thank you, Chairperson.
And the other point that is made in that submission before the Commission is that the change in ministers, so the removal of Minister Nene and his replacement with Minister Van Rooyen was increased the perceptions of risk that the South African government's commitment to fiscal sustainability was weakening. Were you aware of that impact of the removal of then Minister Nene?
May I not respond, Chairperson, in case I incriminate myself?
Ms. Myeni, Chair, I see that we are just before 1 o'clock and I'm about to move on, so it may be appropriate to take the break now.
Okay. Okay, let's take the lunch break. We'll resume at 2 o'clock. We adjourn.
Thank you very much, Chairperson.
continue.
Thank you. Ms. Myeni, before the break, we were dealing with the evidence that former Minister Nene had presented before the Commission about that meeting that he had with you and former President Zuma in November of 2015. I'd now like to turn to the evidence that Minister Gordhan gave before the Commission.
Before you do that, Ms. Hofmeyer, I want to indicate that I can't think of what possible crime Ms. Myeni could expose herself to by answering a question, questions relating to that meeting. As I understand from Mr. Nene's evidence, that meeting was a meeting which, where Mr. Zuma was seeking to try and help the two of them to resolve some tensions between the two of them. I can't possibly think what crime she could expose herself to be prosecuted about in relation to the content of that meeting. So unless her counsel intends advancing any argument, I'm inclined to ask her to respond to those questions. Mr. Buthelezi?
Thank you, Chair. The question that the Chair says he sees no potential exposure to, I think it's inherent in the subsequent questions that followed. One being, it was alleged that as a result of that meeting, Ms. Myeni's advice or impressed upon President Zuma to dismiss Minister Nene. That's number one. Number two, that dismissal subsequently led to a decline in the markets. Now, it's the questions that follow that are open to, because if she then concedes that she participated in a meeting with Minister Nene and President Zuma, and shortly thereafter, Minister Nene was dismissed, it then ventures into the potential that an allegation could be made, that it could have been, as the allegation currently exists, to say it is on the back of her influence on the president that a minister was dismissed. So I think, Chair, it's the aversion to subsequent questions, that a question often is preceded by a plain and a simple factual question. But if you then allow yourself into the terrain of answering that question, you've then bound yourself to answer all questions that follow, because you say, yes, I confirm I participated in this meeting, yes, I was in this meeting. Therefore, things that flow and the allegations that flow from admitting to being present in that meeting, you are very stranded in terms of now not being able to deny your participation thereto.
Well, you see, I think we are all agreed that she needs to deal with each question on its own merits.
Yes, Chair.
Yes. So it may be that she might not have reasonable grounds to refuse to answer a particular question, but she might have reasonable grounds to answer the next one,
Yes, sir.
which is a follow-up. So I think a lot depends simply on whether, in regard to each question, the one can say there are reasonable grounds.
Yeah.
But even with that, with what you have said in mind, I would still have the concern that what crime she could expose herself to being charged for is not clear, even if she could be said to have had an influence on Mr. Zuma, even if she said, you must fire Mr. Nene. Now, I can't know what crime she could possibly be
It's the greatest irony, Chair, because the very purpose of this commission is to answer that very same question.
Well, that's what I wanted to address, to say, well, this could lead to that particular crime. That's what I want, because there can be a number of things that maybe are improper, but are not crimes. You see, some are improper, but are also crimes. But there may be others that are not proper, that are improper, but not crimes. So that's my concern, and it arises from seeking to strike a balance between, one, respecting her privilege to not to incriminate herself, but at the same time making sure that we allow that only when it falls within the reasonable grounds that case law talks about, and that where the risk of being prosecuted criminally is quite remote, that falls outside the privilege. So it's a question of trying to see where we should strike that balance.
Well, maybe you may provide guidance, but the difficulty
Yes.
is here. Incrimination may not extend to a criminal prosecution, but incrimination may extend to a point where somebody concedes to participating in improper conduct, which enables you from where you sit to make an adverse finding. And that adverse finding against that person may down the line constitute part of conduct used in evidence in a criminal prosecution, even in an unrelated crime, but can be used to corroborate certain facts or can be used to draw certain conjecture or circumstantial evidence that may then stand as a bulk of evidence against an individual. So it's a general aversion to saying, to what extent can I expose myself given the unknown and what the potential consequences may be. And I cannot participate in my own persecution. And that's the difficulty.
Ms. Hofmeyer, do you have
Yes.
something to say about this?
I do, Chair. I've listened carefully to my learned friend. The one thing I haven't heard him do is identify a crime that answering these questions could possibly lead to. I've heard about adverse findings being made. I've heard about adverse findings potentially indicating improper conduct. But I have not yet heard the identification of a crime, and I think that that is something that would weigh with you as you decide whether to exercise your discretion to require an answer. The second point, and it's the final one I wish to make, is on this line between the first seemingly innocuous question to a question where you might get into the realm of an exposure to a criminal charge, there is a protection living in the regulations of this commission. So if you're deciding between, a series of questions, the fourth of which could expose to a criminal charge, and you're at the third, and you happen to cross over to the fourth, if an answer is given, Regulation 8.2 of the regulations of this commission says, and I quote, "A self-incriminating answer or a statement given by a witness before the commission shall not be admissible as evidence against that person in any criminal proceedings brought against that person instituted in any court, except," and I'm paraphrasing now, "for the crime of perjury." So, Chair, against that backdrop, it would be the submissions of the legal team that asking Ms. Myeni or directing Ms. Myeni to answer about that meeting does not, on a reasonable basis, tend to implicate her in the commission of a crime.
Okay, Mr. Mchelezi?
Yes, Chair. The position as it existed at the formulation of the commission under Rule 8.2, I would agree with Ms. Hofmeyer that that was the initial position, but the subsequent amendments that have come through that enable the commission to collaborate with law enforcement agencies, in our view, invalidate 8.2 or at odds with 8.2. And 8.2 now, as it exists in our view, is no longer in effect. we no longer enjoy what we thought we initially enjoyed under A2, because the subsequent amendments that have come through as promulgated following, I wouldn't give you the exact date, but it was quite recent. January, at the start of this.
Yeah, I think January
this year.
or later.
These ones were July.
Or July, yeah.
It was July.
There were January ones and then
Yes,
And then,
July ones, yeah.
but the recent ones gave the commission bigger teeth. And the size teeth that the commission now has, in our view, no longer give us the protection that we enjoyed previously under A2. So that hasn't been tested outside this commission. But to err on the side of safety, we are assuming the worst in terms of what those regulations and amendments are. To think that if we were to go and rely on a defense of that we were protected by A2, that defense can be invalidated by these amendments, Chair.
I think somebody might just have to read the provision relating to the sharing of information.
I can do so.
But my understanding is that there is nothing in the provisions that relate to the sharing of information between the Commission and the NPA or law enforcement agencies that says evidence given by a witness in the Commission will be admissible against that witness in subsequent criminal proceedings. So one has got to read different provisions of the regulations as far as possible in a manner that would make all of them work. And if one adopts that approach, as I recall, that provision simply talks about sharing of information, but doesn't say what the law enforcement agencies may do with the information once they've got it. Obviously, they mustn't do anything that is not permitted by law. Now, one of the things that the regulations or Regulation 8.2 says is any evidence that a witness has given in the Commission won't be admissible against that witness in any criminal proceedings. That might not mean that the evidence of that witness can't be used against somebody else. You know, if there were 2 or 3 people who were involved in a crime and one gives evidence before the Commission, the one who gives evidence, that evidence, it may well be argued, may be used against the other one, the other person. But in terms of Regulation 8.2, it can't be used against the one who gave evidence. And the idea has to be, obviously, that the drafters of the regulations sought to encourage persons to come forward and give evidence. So the one interpretation to which I'm inclined is the one that would say the sharing of information, the provision relating to the sharing of information doesn't nullify what Regulation 8.2 says. The law enforcement agencies who obtain information from the Commission can't subsequently present that evidence in court in a criminal case against the person who gave it. They may well use it and present it against somebody else. So if that interpretation is correct, then the immunity would still be intact. What it would mean is simply that where you have given evidence, you are protected from the NPA or the police using that evidence in subsequent criminal proceedings against you. They might use it against somebody else, but not against you. That is one possible interpretation. There may be other possible interpretations.
May I go to another possible interpretation?
Yes, yes.
Is the one of what we've now observed in recent months, where persons testifying at this commission are arrested days after testifying here. and whether correctly or incorrectly so, an impression is created that says the basis of your arrest is your evidence at the commission. And it now, not once, not twice, I think it's happened to, 3 people who've testified and have subsequently been arrested. And what is also a distinguishing factor is that this was not happening pre these July regulations, but post these July regulations. We now have a sequence of events where persons come testify at the commission, and then this follows. We are here preceded by media reports saying, you are due for arrest in this week. So our aversion to whatever, and we don't even know why, what the potential charge may be. But having observed how the law enforcement agencies have behaved in relation to the commission, and what is now playing out as an interplay between, for example, sorry to cite but I'll cite the issue of Mr. Vincent Smith. He's charged based on things that relate exactly to his evidence at this commission. So we cannot, from where we sit, take the risk of saying we've got this protection of 8.2 when we are now seeing something playing out totally different on the surface. And ours is now to err completely on the side of caution to say, look, we are highly exposed and we want to minimize the level of our exposure in the best way possible. And going back to where Chair's comments initiated from, on the point of how can this question potentially expose you? But it can potentially expose you where your admission corroborates the evidence of another, or where your admission corroborates certain other things, which ultimately 2-4 questions down the line puts you in a hole. So rather than open yourself up, because if you've admitted to a question to say, I admit that I was in this meeting, then the chair can now compel you to answer to the contents of this meeting. And once you've stepped into that room, then we no longer can invoke and say, I don't want to incriminate myself because you've now said you were there. And rightfully, the chair can now then compel you to say, you've already admitted to being there. But the safer position is if I say, no, I'm not telling you if I was there or not, then I've not given the chair a basis to say, answer, because you have not confirmed your presence in that meeting. And that's the dilemma, Chair. And we sit on different spectrums, Chair. Ms. Hofmeyer sits on what she needs to do. I sit on what I need to guard against, and you sit on what you...
Yes.
It's this convergence now that's becoming a problem.
Yes, no, I understand. Of course, one doesn't know what prompts law enforcement agencies to act in a certain way at a certain time, but one expects them to act in accordance with the law. If they act or carry out arrests because they believe that people who have given evidence that they can use in court, evidence that has been given by witnesses in the commission against the witnesses, that might be their view, but the commission believes that Regulation 8.2 provides protection. Of course, I must just say that it is a matter of concern where people who are mentioned by witnesses who have come before the commission and have sought to assist the commission in its work, people who have been mentioned by witnesses who have come forward to the commission to assist the commission as having been involved in crime, and people who have not themselves come forward to assist the commission get dealt with in a manner that may give rise to a perception that law enforcement agencies are punishing those who cooperate with the Commission. So that's a matter of concern because it could discourage other people who want to come to the Commission and tell the Commission about matters that are being investigated by the Commission if there is a pattern that after you have given evidence before the Commission, you get arrested. So that would be a matter of concern. I have said publicly that when certain arrests were made last year, which included Mr. Grizi, and no arrests were made of certain other people who had been mentioned by him in his evidence, that according to his evidence seemed to have been very involved in acts of corruption, alleged acts of corruption. It was a matter of concern because Mr. Grizi could easily say, well, I'm no longer cooperating with the Commission. Fortunately, he continued to cooperate with the Commission. So, but of course, we can't make decisions based on what if the law enforcement agencies misread the law or attach a wrong interpretation of the law. One has got to look at the law and determine what it means and then make a decision based on that. Ms. Hofmeyer, you wanted to respond.
Chair, just one submission. The privilege against self-incrimination is not a privilege not to get arrested. It is a privilege to decline to answer a question if the answer tends on reasonable grounds to expose you to a criminal charge. That is the only question that needs to be answered with respect.
Yes. Okay. I'm not going to make a blanket ruling, but if you revert to that meeting, I will look at each question as it comes, and Ms. Myeni can respond if she invokes the privilege, and I will then look at each question as it comes. Yes.
Thank you, Chair.
I'm sorry, Ms. Myeni, you were following the exchange?
Yes, Chairperson, I was. Thank you very much.
Okay, all right, thank you.
Ms. Myeni, I was going to actually be moving from former Minister Nene's evidence to the evidence that Minister Gordhan gave before the Commission, and in particular when he spoke about matters relating to SAA on the 20th of November 2018 before the Commission. Now, his evidence was also to the effect that your conduct at SAA risked serious negative impacts for the fiscus. Are you aware of his evidence in that regard?
Chairperson, may I not respond to the question in case I incriminate myself?
He came before the Commission and testified that your efforts to seek to reverse Minister Nene's decision on the Airbus swap transaction would likely have triggered debt defaults by SAA due to the pressure that the pre-delivery payments under your proposed transaction would have placed on SAA's cash reserves. Ms. Myeni, you'll recall that's the Airbus transaction that was before the Ministry of Finance in 2015. Do you dispute that your efforts would have had this effect on SAA's cash reserves had you been successful in reversing Minister Nene's decision?
Chairperson, may I not respond so that I avoid incriminating myself?
Minister Gordhan testified before the Commission that he decided not to reverse Minister Nene's decision, despite your application to him for that to be done, and he decided not to reverse it for the very real impact he believed it would have on SAA's cash reserves. But then he received a call from former President Zuma asking if he wouldn't reconsider his decision. Did you ask former President Zuma to place that call to Minister Gordhan?
Chairperson, may I not respond to the question in case I incriminate myself?
Did you ever discuss with former President Zuma your efforts to seek to reverse Minister Nene's decision on the Airbus swap transaction?
Chairperson, may I not respond to the question in case I incriminate myself?
Ms. Myeni, 2 successive finance ministers have testified before this commission to the effect that your approach to SAA and its financial stability during particularly the period of 2015 was reckless. Do you dispute that evidence?
Chairperson, may I not respond to the question in case I incriminate myself?
Chair, I would now like to go back, if I may, to the Blake's travel aspect of the Bosasa evidence.
Yes. Okay.
Just to summarize where we are, because of that interruption, things had not flown as thematically as I had hoped. But what we've traversed in the evidence so far is Bosasa evidence, today at least, Bosasa evidence about alleged payments being made and benefits being given because of a particular role that Ms. Myeni is alleged to have played in facilitating matters with former President Zuma. We have then looked at, in the context of some of that evidence related to the security installation, we've looked at what happened with the search and seizure operation at the end of last year. We've looked at the state security agency's activities within SAA, and then we took that to some of the previous ministers' testimony. I'm now going to loop back to Bosasa to complete that aspect, and then we will move on to SAA matters, I think, for the remainder of the afternoon.
Okay, no, that's fine.
Ms. Myeni, in order to deal with the Blake's travel matters, you will need that file T18 that I understand you now have with you. Could you have that in front of you?
Yes, I do, Chairperson, and I thank you very much for arranging for its delivery. Much appreciated.
Thank you.
Thank you.
Ms. Myeni, Mr. Agreezy, apologies, Chair. Mr. Agreezy gave evidence to the Commission that Bosasa used Blake's travel to facilitate travel arrangements for various government officials and people who they believed had influence over, amongst others, former President Zuma. And I gave the indication previously, Chair, of where you'll find that in his affidavit and the transcript of the 22nd of January 2019. Now, Mr. Brian Blake, who was an employee of Blake's Travel, testified before the Commission, and he did so on the 29th of July 2020. And just for record purposes, I'm going to pick up his testimony, Chair, at the transcript of the 29th of July 2020 at page 196 from line 11. Mr. Blake's testimony was that Bosasa had paid for various air tickets and accommodation for you, Ms. Myeni. Do you dispute that they did that?
May I not respond, Chairperson, on the question so that I don't incriminate myself?
Ms. Myeni, what I'd now like to take you to are the invoices that Mr. Blake provided to the Commission so that I can have your response on each of them. You'll find them in bundle T18, and I'd like to start at page 70. This is an invoice according to the evidence of Mr. Blake, that evidences that Bosasa paid 17,759 Rand and 60 cents to enable you to stay at the Sheraton Hotel between the 4th of May 2014 and the 6th of May 2014. Do you dispute that that is the case?
May I not respond, Chairperson, to the question so that I don't incriminate myself?
They did so again 2 months later, according to the evidence of Mr. Blake, in July of 2014, and you'll find that at page 75.
75.
Yes, Chair, of the same bundle T18. On that occasion, they paid...
Maybe I just want to say
Yes.
something here, just to contrast with the issue I raised about the meeting between involving Mr. Nene, Ms. Myeni, and Mr. Zuma. When it comes to this payment, I accept fully that Ms. Myeni is entitled to invoke her privilege, because I can see what it could lead to. So I just want to mention that there are matters where one can see immediately that this could lead to a criminal charge, but then there are others where you struggle to see what possible criminal charge. But I just wanted to mention that in passing. Okay, all right.
So this next one is 2 months later in July of 2014. It's at page 75. Mr. Blake's evidence was that Bosasa paid for this stay between the 3rd of July 2014 and the 4th of July 2014. Do you dispute, Ms. Myeni, that Bosasa made that payment for you?
May I not respond, Chairperson, so that I don't incriminate myself?
I don't want to go to every invoice, but I want to summarize and then offer you an opportunity, Ms. Myeni, to respond. We've looked at the invoice in May. We've looked at the invoice 2 months later in July. Next, there are 3 invoices. During the course of August 2014, there are 2 invoices in September of 2014, and there is 1 invoice in November of 2014. Do you dispute that on all of those occasions, Bosasa made payment for your accommodation at the Sheraton Hotel?
May I not respond, Chairperson, in case I incriminate myself?
Do you want Ms. Hofmeyer to go to the specific invoices, or are you happy that she doesn't go to the specific invoices?
Yes, I'm happy that she doesn't go to specific invoices, Chairperson.
Okay, all right.
On my count, that aggregates to 8 accommodations over 7 months at the Sheraton Hotel in Pretoria being paid for by Bosasa, according to Mr. Blake's evidence. Do you dispute that they paid for those stays for you?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Mr. Blake's evidence was that the accommodation was not confined to your stays at the Sheraton in Pretoria. They included the Southern Sun Beverly Hills in July of 2014. And just for the record, Chair, unless Ms. Myeni wants us to go there, that can be found in T18 at page 79. And they also paid for you to stay at the Radisson Blue in Newlands, Cape Town in February 2015. And that, for the record, is to be found at T18, page 90. Do you dispute that Bosasa paid those additional invoices on your behalf?
May I not respond, Chairperson, so that I don't incriminate myself?
The benefits, according to Mr. Blake's evidence, that Bosasa gave to you were not confined to covering your accommodation expenses over the period of 2014 and 2015, but also plane tickets for you. These are tickets throughout 2014 I'll take you to one or two, but I'm going to summarize. First, there were plane tickets from Johannesburg to Nelspruit, from Durban to Cape Town, from Durban to Johannesburg, from Cape Town to Durban, from Johannesburg to Durban, and from Johannesburg to East London, and Durban to Johannesburg. Let's just go to one of them so that we can have your response on it. You can find that in bundle T18 at page 73.
I have the chairperson.
So this reflects an item of South African Airways. There's a particular ticket number. The passenger indicated on the invoice is Dudu Myeni. The route is Johannesburg, Nelspruit, Johannesburg. The date is the 29th of May, 2014. Do you dispute Mr. Blake's evidence that Bosasa paid for this plane ticket for you?
May I not respond, Chairperson, so that I don't incriminate myself?
Do you dispute any of the remaining invoices as having been paid by Bosasa for you, according to Mr. Blake's evidence?
May I not respond, Chairperson, so that I don't incriminate myself?
Ms. Hoffman, just for the record, tell me where the others are to be found.
Certainly. Let me give the full record. So the one we looked at was Exhibit T18, page 73. The next one is T18, page 76. The third is T18.
Hang on.
Oh, apologies, Chair. I'm going too fast.
Okay, right, continue.
The next one is at page 80 of T18.
Yes.
The next is at page 82 of T18.
Yes.
The next is at page 83 of T18.
Yes.
Then we jump a bit to page 88 of T18.
Just 1 second. Yes.
And then over the page at T18, page 89.
Those are just air tickets.
Those are just air tickets. So I tried to group them thematically, albeit that they are in some sense muddled up in their ordering.
Yes.
We did first accommodation.
Yes.
We did first accommodation at the Sheraton in Pretoria.
Yes.
Then we did accommodation at two other locations, Southern Sun and Radisson Blue.
Yes.
Then we moved to airplane tickets.
Yes, okay. At some stage, will there be an attempt to say how much they total?
Yes, certainly.
Okay, all right.
And then, Ms. Myeni, I'd like to ask you why it is that Bosasa was paying for you to stay at these hotels and fly around the country.
Chairperson, may I not respond so that I don't incriminate myself?
Ms. Myeni, in the absence of any evidence from you that could explain a relationship that entitled you to receive those benefits from Bosasa, I want to put it to you that the fact that these payments were made is supportive of Mr. Agreezy's evidence before this commission that these benefits were given to you because of the influence that you were understood to be able to exert. Do you dispute that?
It looks like there is a disconnection again.
So that I don't incriminate myself.
I'm sorry, we had lost you, now we hear you. Did you hear everything? Did you hear the question? Ms. Myeni?
We seem to have a bit of a interruption.
Yes, Chair.
Can you hear me now, Ms. Myeni?
I heard the question, Chair.
Okay.
Yes, I heard the question, Chairperson, and I responded. But
What was the answer?
I did respond to the question.
Oh, just repeat the response because I didn't hear it.
The answer was, may I not?
Oh, she gets cut off again.
Chair, I've been informed that the issue is a bandwidth issue. It happens intermittently. It is on Ms. Myeni's side, so there's nothing we
Yes.
can do sitting here. But,
Yes.
but it has been restored previously.
Yes.
So maybe we wait a few more seconds, and if
Yeah.
not, we could take an adjournment. Thank you.
No, that's fine. I'm sure she's going to come back. If you are back, if you can hear us, Ms. Myeni, just tell us.
Chair, what we're going to now try and do is just restart the session, the Zoom session, because that sometimes assists. So if we could request just a short adjournment to facilitate that.
Okay, all right. We adjourn.
I am connected again, Chairperson. I'm connected again, Chairperson. I'm connected again, Chairperson.
connection with you, I had put it to you that in the absence of any explanation from you that would give this commission insight into why Bosasa was making these payments for you routinely between the periods of 2014 and 2016, there is credence added to Mr. Agreezy's version that these payments were made because of the influence that Bosasa believed you had in respect of former President Zuma. Do you dispute that?
May I not respond, Chairperson, so that I don't incriminate myself?
Ms. Myeni, the total value of these various payments that Mr. Blake from Blake's Travel has testified before this commission were paid on your behalf by Bosasa is an amount of 101,576 Rand and 67 cents. Do you dispute that you received a benefit of that amount from Bosasa in the period 2014 to 2015?
May I not respond, Chairperson, so that I don't incriminate myself?
Are you able to provide any legitimate reason why Bosasa would have spent these amounts on your behalf?
May I not respond to you, Chairperson?
In order not to incriminate yourself.
Just for, sorry?
In order not to incriminate
Sorry,
yourself.
Chairperson?
I'm saying, are you...
Correct, Chairperson.
Okay, no, that's all right.
And then
Ms.
just,
Sotomayor?
thank you, just for the record, of that 101,576 Rand and 67 cents, 21,660 of it was spent on the travel, the flights, the air tickets, and 69,916 Rand on accommodation. Ms. Myeni, Mr. Blake also testified that in 2014, the Hawks had started to investigate the Bosasa travel benefits with respect to various government officials. And part of that investigation involved cloning Blake's Travel's hard drive with all of its customer information on it. Are you aware that Mr. Blake gave that evidence before the Commission?
May I not respond, Chairperson, so that I don't incriminate myself?
Mr. Blake also testified, and Chair, just for the record, you'll find these parts of his testimony in the transcript of the 29th of July 2020 from page 198. He also testified that he had deposed to an affidavit for the Hawks and was prepared to testify about what he knew regarding these benefits that you'd received, but that the Hawks had then suddenly informed him that the case had, quote, disappeared. Can you assist the Commission in relation to those facts? Do you have any basis for disputing them?
May I not respond to the question, Chair, to avoid self-incrimination?
And then finally, Mr. Blake testified that in 2019, after Mr. Agreezy had testified, Mr. Blake followed up with the Hawks about his cloned hard drive and was informed that the hard drive had been stolen or had disappeared from Hawks' custody. Again, Ms. Myeni, do you have any insight that you could provide to the Commission or any evidence that you can make available to us to dispute that?
clarity, the disappearance of the information from the Hawks and my involvement and what I need to dispute. What is it that I've got to dispute
What I'm asking is if you have...
when somebody says the information?
I think there is a little bit of disconnection. Can you hear me, Ms. Myeni?
Yes, there was a disconnection, Chair. I'm back now.
Yes, I think
Yes, very well, Chairperson.
just start your response afresh because we had some parts, but I think we didn't hear some parts of your response.
In other words, Chair, I was asking for clarity.
Hey, these technical challenges are really problematic. We can't hear you from this side, Ms. Myeni. Maybe you do hear us.
To say when what is it? Also, I can't hear you. I can hear you very well.
Oh, you can hear us. We can't hear you. Now I can hear you, but as you give your response,
Yes.
you get cut off. So I don't know, before lunch, everything seemed to be smooth. I don't know whether there's something that shouldn't be used for too long or what. I think we'll try again. Let's try again, Ms. Myeni. Each time you start giving your response, a disconnection happens. So just try again to give your response again. I think she
I need
can't
to assist the commission about disappearance of, what is it that I can assist with when the Hawks say their information disappeared and I don't know, Blank said that, Hawks said that. So what is it that I've got to respond to? That's what I'm trying to ask, Chair. I need clarity, in other words.
Okay, no, that's fine. Ms. Mayor?
Thank you, Chair. Ms. Myeni, I completely understand your request for clarity. It is simply, and if you say I have no knowledge of those allegations at all, that would certainly be an answer you could give. What I'm seeking to do is give you an opportunity that if you happen to have some information that you thought was relevant to indicate that what Mr. Blake had said was false, we would certainly want that to come before the Commission. So it's just an opportunity to say to you, do you have any evidence that indicates that what he has said is not correct?
I have not responded to this question, Chair.
Okay,
To avoid self-incrimination.
okay.
Chair, I would then, that completes the Blake's travel evidence. And so now I would like to go, if we may, back to South African Airways, actually, and matters arising there.
Okay, before you do that, so this has completed the Bosasa related evidence questions?
Yes.
Is that all right? Okay, Ms. Myeni, with regard to Bosasa, I just want to say this, and you can say that you don't have any comments or you don't want to say anything, that's fine. I just want to say that the fact that you have not responded to most, if not all, the questions relating to Bosasa and to Mr. Agris's evidence that was put to you, Mr. Leroux's evidence about the security installations, and Mr. Agris's evidence relating to the meeting at the Sheraton may well make anyone who has been following the evidence to ask the question, what relationship was there between Bosasa or Mr. Watson, or Mr. Agrisi, and Ms. Myeni and or Mr. Zuma that made Bosasa spend the amounts that Mr. Agrisi spoke about, because a lot of that evidence has not been denied in your oral evidence. What is it that made Bosasa spend the kinds of money is that, according to Mr. Richard Leroux, they spent, I think, close to $500,000 at your residence in Richards Bay in terms of security installations that made them spend the kind of money they spent on you in regard to traveling and accommodation. So in other words, it would make somebody ask that question to say, why would a company spend so much money on somebody who doesn't work for it and who doesn't seem to have been conducting any business with it, and so on. And of course, when I evaluate the evidence that is before me, and I need to mention this to you as part of being fair to you, when I evaluate the evidence before me to try and establish what happened, I will be having this evidence of these payments without any denial from you or any explanation to say, no, but these payments, there was nothing wrong with them, they were legitimate, this is what they were about the payments for air tickets and payments for accommodation. I will be evaluating evidence in circumstances where I will not have your evidence to say, no, there was nothing wrong with this, with Bosasa paying for these air tickets and paying for accommodation because of ABCD. And if there is no evidence that gives an explanation on these things, it might be difficult not to accept the reason being advanced by Mr. Agrisi. Because Mr. Agrisi says Bosasa spent the monies they spent on you for a particular reason that he has given. So I'm just mentioning that so that you understand the impact of there being no answers from you on, or evidence from you that either denies or explains some of these things. You understand?
I do understand, Chairperson.
Okay, thank you. Ms. Hofmeyer?
Is the Chairperson wanting me to make, to comment or to respond?
Well, I just wanted you to be alert what the implications are. That's what I wanted. Did you want to say something? You don't have to comment, but if you want to comment, I can listen.
With respect, Chairperson, thank you for the clarity you have made in relation to the Bosasa matters, and all what the chairperson has granted to. Chairperson, I think also I need to clarify that when I say I would not like to comment or to respond to a question that is put before me, Chairperson, it does not mean admission of guilt, nor admission of wrongdoing.
Yes.
So that if I say I don't want to incriminate myself, people or any other listener, or it is placed on record that when I don't say anything about what is put before me, I am and I have in another, during another time I had responded, like for instance, there is an affidavit I submitted to the commission, but Chairperson, at the right forum, if I'm charged, I will be able to give proper responses that are not muddied by any other narrative that has been happening in the country. Chair, with respect as well, in my submission that I made before you, before coming into to this commission, I referenced your comments regarding Bosasa. And I'm sure the chairperson has been able to read the comments I made.
I've
when
read, yeah.
Somebody is, sorry, Chair?
I have read, yes.
That chairperson, somebody would be testifying, not mentioning my name, but my name will be drawn into that particular person's evidence that he is putting to say, oh, Dudu Myeni yena, you know, like, where would he and Dudu Myeni la? When the person has not mentioned my name and then the person gets led into mentioning my name. The classical example is Vincent Smith. So I'm saying, Chair, let me remain with my silence as the privilege been given to me by your good self, Chair, so that I don't incriminate myself. And then I get into a place where, or a forum, where I'll be able to clear my name on things that have been said at this commission or even by the media. So, Chairperson, maybe I should just say thank you very much, but I think I will continue with the preference that I've made to say I would rather not respond to some of the things that have been put before the commission. Yes, Chair.
No, thank you, Ms. Myeni. I appreciate that. And what I said was not meant to say change your view. It was simply to make sure that you understand the implications. Because sitting here, if I like, I can sit here and just keep quiet, even if there is something that I'm thinking, and keep quiet. But the other approach, which I prefer, is to articulate what's going on in my mind, because then it gives you an opportunity to know what's going on in my mind and put your side of the story and influence me in regard to a certain issue so that I can listen to everybody. Otherwise, if I like, I can just keep quiet, and you might then think I'm not thinking anything, but I prefer to put matters in front of you to say, there is this issue, what do you say about it? You get a chance to address it. It doesn't mean I have made up my mind. It just means I want to hear what you have to say about it, so that if I make a finding about it, you have had a chance to have your say on it. You understand?
Thank you very much, Chairperson, and it's greatly appreciated.
Yes, okay, all right. Ms. Hofmeyer, you may proceed.
Thank you, Chair. Ms. Myeni, I'd now like to take us back to SAA, if I might. You recall that on Wednesday we left SAA Matters really at the end of 2014 after quite I would say, tumultuous year at SAA, given the factions that had developed in the board. We saw the report that the DPE had done about that. We traversed the complaints that 6 board members had made against you and your responses to them. And we culminated with the decision of then Minister Brown to retain you and Ms. Kwinana on the board in October, and the rest of the other board members left, and you were joined on the board, as I understand it, by Dr. Tambi and Mr. Dixon. But I want to focus in a little bit further in 2014, because at the time where there was that conflict amongst the board members, as we saw evidenced in the letters that we looked at, we have evidence before the Commission that you engaged the services of worksmen's attorneys to provide advice on the issues that you were having with the board. Is that correct?
May I not respond, Chairperson, so that I don't incriminate myself?
Now, what Worksman's did is, Chair, we have received an affidavit from Mr. Manaka at Worksman's, which we can go to and just enter into the exhibit, if we may, enter into the record as an exhibit. It's actually the last document that's been included in Ms. Myeni's bundle DD 34B, and it is under tab 43, and it starts at page 1977.
I've got it.
Thank you, Chair. If I could request that we enter this...
Let's check if Ms. Myeni has got it.
Yes, certainly.
Have you got it, Ms. Myeni?
I'm going to it, Chairperson. I just would like to check if this document 1977.
Yeah, the page is 1977.
Of DD 34B.
The bundle that has got your affidavit. 34, DD 34.
Chairperson, it ends on page 1960.
Oh,
Oh, I know why that is. That is because the updates have been sent via email since Wednesday, and we're going to encounter the same difficulty.
Okay.
Chair, I can do this part of the evidence without reference to Mr. Manaka's affidavit, so
Okay.
let us rather do it that way.
Okay.
Sorry, Chair.
No, sorry.
Yeah, sorry. Sorry.
Sorry, Chairperson, I was asking if it was emailed as a Rule 3.3 to us when Mr. Manaka was presenting to the Commission.
No, Ms. Myeni, it wasn't, because Mr. Manaka has not presented to the Commission. He prepared this affidavit for your evidence, and that is why it was provided to you when we received it, which was, I've lost track of the days today. We got it on Wednesday, the 4th of November, so it was sent through on that day to your attorneys. So we only received it about 2 days ago, and that's why I intended to traverse it with you today.
Sorry.
Okay, I think your counsel wishes to say something, Ms. Myeni, Mr. Pulezi.
Sorry, Chair.
Thank you, Chair.
We have this affidavit. We received it this morning
Yes,
on our arrival.
yes.
And this affidavit presents us with several challenges. And if I'd like to go to the affidavit with you, Chair, starting at paragraph 3. It says the following, under the heading Purpose of Affidavit. I have been requested by, it's the affidavit of Mr. Manaka. I have been requested by the State Capture Commission legal team working on matters pertaining to South African Airways SOC Limited, SAA in brackets, to provide it with an affidavit detailing the circumstances which culminated in the issue and the payment of certain invoices during 2014. Then I skip, I go to paragraph 6, and then I'll go to paragraph 7 and 7.1. It says, on Sunday, 30 March 2014, I received a telephone call from Advocate Lindy Nkosi Thomas, SC, a former member of the SAA board. Advocate Nkosi Thomas advised me that then chairperson of SAA board, Ms. Myeni, Ms. Dudu Myeni, Myeni in brackets, required an opinion on a number of issues and would be contacting me directly in this regard. Paragraph 7. On 31 March 2014, following the telephone call from Advocate Lindy Nkosi Thomas, I received a call from Ms. Myeni, during which she advised that 7.1, she, in her capacity as chairperson of the SAA board, required the advice relating to her powers and duties and responsibilities. Now, Chair, in my understanding of the law, this seeks to violate client-attorney privilege. How it is that the commission can write to an attorney and ask for information that this person had consulted. Now, Chair, I'll refer you to the leading authority, Chair, in this country here, a company, and others versus the Commissioner of South African Revenue Service, 2014 case, where they say the following: the requirements to claim legal privilege is the following. The legal advisor must have been acting in a professional capacity at the time. So Mr. Manaka says he's contacted in his capacity as a legal person. 2, the advisor must have been consulted in confidence. 3, the communication must have been made for the purpose of obtaining legal advice. The legal requirements of client-attorney privilege. Now, I'm saying to you, Chair, this is sacrosanct in the legal space. And we cannot comprehend how this commission, Chair, and by extension yourself then, can venture into the space where an attorney is now on record saying, I have been asked to give evidence about the circumstances where the former SAA chairperson asked me about legal advice. We're saying, Chair, this now then brings the proceedings into serious disrepute, Chair, to have such an affidavit. Now, 2 problems with this affidavit that continue, Chair. This affidavit, if you go to the back of it, Chair, is deposed to on the 4th day of November. The 4th day of November, we were here testifying. The confusion that then arises is to say, why do we have an affidavit while the witness is on the stand being deposed to, while she's been given evidence? Are we being ambushed with this evidence? When would we have consulted? And it's not the only one, Chair. 2 affidavits referred to today are affidavits deposed to this week. This week, the affidavit of Leroux was deposed to on the 2nd. The affidavit of Mr. Who else? The Captain Nevin. His affidavit is deposed to on the 3rd, talking about incidents that happened last year when they said they did an inspection. Now, sinister as well, we've got a situation with respect to counsel. She seeks to amend the affidavit of Mr. Poseidonhout from the bar about a contradiction that emerges on the dates. And she says, no, this must definitely be a mistake. But she knows legally that's not how you amend an affidavit. And she throws this into the evidence and says, evidence that the commission must accept this as a bundle or annexure. However, but these are the problems that emerge. Now, we are registering, Chair, for purposes of this hearing, extreme prejudice. Extreme prejudice that has been going on even till now. The last bundle that Ms. Myeni has had to deal with was delivered to her now. now during lunchtime. And the commission has had knowledge of her attendance for the longest time. And we have to continuously bend over backwards and accommodate inefficiencies that are emanating from the other side. And I ask this one last question, Chair. In which forum in this here country, which court would allow one litigant to behave the way that the evidence leaders have behaved here? It's never happened, Chair, where a witness is on the stand and the one other party is allowed to give them affidavits while they give their evidence. It's never happened.
Well, let me start with your last concern. Up to now, I didn't hear any concerns relating to the lateness of any affidavits. And the reason I'm mentioning that is simply that one knows that between colleagues, there's accommodation, you can accommodate one another. Obviously, somewhere you are entitled, everyone is entitled to draw a line, but you know, sometimes you accommodate one another. So I hadn't had any issues about any complaints about the lateness of affidavits. But where there are real concerns because the affidavits have been made available late, you know, those concerns need to be looked into properly. With regard to attorney-client privilege, I'll hear what Ms. Hofmeyer may have to say, but I wonder whether the problem that may arise in invoking it wouldn't be that the privilege did not attach to Ms. Myeni personally, because the privilege related to her in her official capacity as chairperson of the board at the time, so that once she is no longer chairperson of the board, the person who is chairperson of the board at the time when such an affidavit is sought is the person who could object rather than the person who is no longer in that position. So there may be that issue. But with regard to the question of the lateness, I think that may need to be looked at.
Sorry, Chair. May I just give you a few pointers? I think the reason why the lateness issue only arises now, we've tried our very best not to be obstructive and to be collegial.
I accept that.
But if we now look at a string of incidents, it then brings us to a point to say, I think we've been very understanding in that regard. And I think to be now saying, client must now go to this affidavit that she doesn't have, and we ourselves only received this morning. It's the last hour of the hearing.
No. When I said I had not had any complaints about the lateness, I didn't mean that as criticism to you. Actually, I meant to say probably it's because you were trying to accommodate one another as colleagues, so it's not meant as criticism at all. Ms. Hofmeyer, do you want to say anything?
Yes, certainly, Chair. Let me begin with the privilege point, because my learned friend began with it, and pick up, Chair, on the point that you made. Indeed, the situation is such that this memorandum was procured from Worksman's by Ms. Myeni when she was chairperson in April of 2014. It is work that that Worksman's did, and Ms. Myeni required the SAA to reimburse her for, on the basis that the memorandum had been presented to the board and had been procured for the benefit of SAA. The consequence of that is that it is SAA's privilege. It is not Ms. Myeni's privilege, and there have been engagements with SAA in respect of which they consented to the production of the memorandum. Mr. Manaka at Worksman's was very careful to confirm that privilege the holder of the privilege SAA was such that they were happy with him traversing the matters in the affidavit. So privilege is not an issue in my submission. I then want to address the question of lateness. I began on Wednesday, I think it was, to reference some of the history of the engagements with Ms. Myeni. And the point that I'd like to emphasize there is the Commission has been trying for it's more than a year now, to engage Ms. Myeni because our investigations within SAA were so critically relevant to her and her position, and it was essential for us to obtain her version throughout our investigations. So those engagements started in 2019. There were repeated invitations for Ms. Myeni to meet with the Commission initially, to discuss what we were investigating, to give her an opportunity to assist us with her version. She was asked repeatedly when those meetings were declined to give an affidavit to the Commission, numerous correspondences following up, will it be forthcoming? Until, Chair, you issued the 10.6 directive to Ms. Myeni, which you did on the 9th of October, other than the affidavit in response to Mr. Agreezy, which we've looked at already, there was no affidavit forthcoming from Ms. Myeni. So from the point of view of early engagement on issues, certainly the Commission has endeavoured from more than a year ago to be engaging with Ms. Myeni. So let me move to why we get to where we got to on the 4th of November and the bundle. Chair, you will have seen in many of the proceedings of the Commission, we're running against the clock and we don't have control over the timelines that third parties have in coming back to us. And sometimes we do get things late in the day. But we have one chance and the Commission's work is about to end. And so what we endeavour to do is where we do get things late, we make them available as soon as possible. Now, importantly, there are two different types of engagements with witnesses. They're witnesses who come really keen to tell their story, and often early on ask for the bundle, which will be presented and dealt with in their evidence so that they can prepare. At no point prior to Wednesday of this week was there a request on behalf of Ms. Myeni or her lawyers to be provided with any of the bundle that would be presented to her. I must be clear, there was a request, I think it's a few weeks ago, I can get the relevant correspondence if it becomes pertinent, where Ms. Myeni's new attorneys, because she'd moved attorneys, requested us to provide them again with all the 3-3 notices that Ms. Myeni had received and the underlying affidavits. And we indicated to them that Ms. Myeni would have those in her possession. We'd already provided them on one occasion previously. We suggested that they engage her to obtain the documents. And we furthermore said if they, in doing so, discover any that are missing, we then stand ready to send on a second occasion those documents. But we did not ever receive an indication that there was something missing. The only thing we did receive was the response to your 10.6 directive. So when we have a situation where we get affidavits late in the day, it has happened on many occasions in this commission that the affidavit is presented to the witness. It's another version. The witness is given an opportunity, if there's a need for an adjournment or a consideration of it, to take the time to do so. But at most, it's another version in respect of which they now have the opportunity to respond to that version. So I again want to emphasize this is nothing peculiar about Ms. Myeni or what's transpired this week. It's happened on many previous occasions with witnesses. It's a function of the fact that we don't control the timelines against which third parties who are presenting evidence to the Commission can produce it for us. And when we do have the fortune of a witness before the Commission, with little time left in which to complete the work, we endeavour to put whatever information we have received, versions we've received from others, to the witness for their comment. So, Chair, that is just a background on privilege and then why we've got to where we are today, and certainly explaining the lateness, why it has arisen, and the efforts, certainly as soon as we were in receipt of them, to get them to the attorneys as quickly as possible. There's a process where they have to be paginated, but then they get across. Thank you, Chair.
Well, Mr. Buthelezi, in terms of trying to find a way forward in regard to this affidavit, have you got any ideas?
No, Chair. I think in as far as the evidence leader insists that this affidavit be admitted, then she may have it. The problem we've got is the client hasn't seen it and she doesn't have it. So, but she said she would proceed without it, and that's okay. The extent of our complaint to you, Chair, it's just to register our prejudice.
Yes.
So that you note our prejudice in these proceedings, and we still proceed.
Yes.
Thank you, Chair.
Yes. How long is this affidavit of Mr. Managa, Ms. Hofmeyr?
Chair, it's 20 pages, but I do want to emphasize the point. You see, we met some time ago with Worksmans, and there has understandably been a delay in production of the affidavit. That is why the documents actually reference the underlying work product, like the opinion, which we received from SAA and which was in the bundle from Wednesday when Ms. Myeni received the bundle. So I can deal with this evidence without the necessity of going to the affidavit, but similarly would have absolutely no difficulty with some arrangement where we don't deal with it now, we admit it later, but it is a 20-page affidavit.
Yes, I'm just concerned if she has not had a chance to read it. That is Ms. Myeni. Of course, if it may be that if you tell her what Mr. Managa's version is about the matters that are covered in the affidavit, it may be that she will say she prefers not to answer, but preferably one would prefer that she has had a chance to read it first. I think Mr. Buthelezi is keen not to obstruct the proceedings or delay the proceedings, but he just wants to place on record their concerns as well at the same time.
Indeed, so, Chair.
So one way is to one approach is to deal with other matters, and when they are dealt with, adjourn, give her a chance to go through it. She might need 30 minutes and then she's ready. I don't know what a fast reader she is, but if she reads fast, she might be able to. Another option is to ask her to respond to certain questions by way of an affidavit after reading it, which she can send to the commission by a certain date. That would be another way.
Indeed.
Yeah, you have no problem.
I have absolutely no difficulty with that. What might even be useful is, without reference to the affidavit,
yes,
to take her to the underlying documents so that Ms. Myeni has a sense of the issues arising from the documents, and then to facilitate an opportunity in due course for an affidavit responding to Mr. Manaka to be produced. That should, certainly the legal team would have no difficulty with that.
Yes, yes. Okay. I think what should be done, therefore, is to give you a chance to inform her of the real issues or underlying documents. Without asking her questions, or if you ask her questions, she must feel free to say, I would prefer to deal with it after I've read the affidavit. Then that can be done. Ms. Myeni, have you been following the discussion?
Yes, Chairperson.
Yes. There are 2 or 3 possibilities. One possibility is that Ms. Hofmeyer won't ask you about this affidavit now, but will ask you about other matters. And when she's done, we could adjourn for 30 minutes or so to allow you to read the affidavit, and then we resume after that and she can ask you questions. That is scenario 1. Scenario 2 is that she doesn't ask you questions on this affidavit today, but she sends you through your lawyers questions that you must look at, and then you prepare an affidavit. After you have read this affidavit, you then respond to those questions by way of an affidavit. That is scenario 2. Included in scenario 2 is that if she wishes to alert you to certain things connected with this affidavit now, she can alert you so that when you respond later, you have the background, you understand the issues. I think it's those 2 scenarios, really.
Indeed, Chair.
Have you got a preference of which one you prefer, Ms.
The
Myeni?
second one is much more preferred, Chairperson, because
second
I
one.
need to read
Yeah.
that particular 20-page
Yes,
affidavit, and
yeah.
as well as other related documents,
Yeah.
and get a sense,
Yeah.
as the Chairperson suggested. Scenario 2 is much more preferable, Chair.
Okay, no, that's fine. So let's go with that route. And then, Ms. Hofmeyer, if you do have things that you want to bring to her attention in connection with that affidavit for her benefit, so that when she deals with questions later in terms of by way of an affidavit, she has the context, that's fine, you can do that. Or if you want to move to
Chair,
other matters.
I think it makes sense to move. I
Yes,
appreciate
okay.
the situation. What I want to emphasize is that it was not of our making at all.
Yes,
We
yes.
really are beholden to others and their own time
Yes,
constraints for receiving
yes,
things. So
yes.
my suggestion is we simply leave it.
Yeah.
We can send a set of questions through.
Yeah.
Ms. Myeni can consider them in the goodness of time. We'll give a reasonable amount of time, and she
Yeah.
can provide an answer on affidavit when it's convenient.
Okay, all right. So that is what will happen, Ms. Myeni. You will get correspondence from the commission through your lawyers, and then you will respond by way of an affidavit. Okay, all right. Thank you,
Thank
Ms.
you.
Hofmeyer.
Of course, let me just emphasize on Ms. Myeni's behalf, if her attitude is similar to the one that she's taken today, that she invokes her privilege, of course that could be the response that she gives. But we will wait to see after consideration.
Yes, yeah. Okay, all right.
Right, so then I would like to move, Ms. Myeni, to a topic that I picked up on yesterday momentarily, but now I would like to explore in a bit more detail. And that was the role that Mr. Nick Linnell played at SAA.
Maybe, Ms. Hofmeyer, seeing that we are at 22:04, maybe we may as well discuss now what's possible in terms of how far we go. I'm available to continue beyond 4 o'clock. What's your situation?
Chair, I certainly can continue, and I would be very keen to make a push to complete the evidence. I'm not very far from the end. And so, subject to the convenience of my learned friends and Ms. Myeni, I would suggest we run on to completion, if that is possible.
What's your estimate of how much more time you need to get to completion?
I would think we're now at 3:30, maybe 5:30, something of that order,
Okay.
possibly 6. But
Mr. Mchelezi, how is your situation?
5:30 is too far, Chair. I've got toddlers in waiting. The best I can accommodate to say is 5, given
It's
the fact
5.
that we even started at 9, Chair.
Yes,
So I think for me,
Yeah.
5 o'clock would be the longest stretch.
yes.
But if I'm venturing to 5:30, I've still got to negotiate traffic to try and catch a 6 o'clock
Yes,
deadline across town, Chair.
yes.
It would be highly.
Yeah.
problematic, Chair.
Of course, having started at 9, we probably would have finished by 4 if we didn't have
Yes,
the
indeed.
technical glitches
Yes.
that we had. Yeah,
Yes.
yeah. Okay, right. Ms. Myeni, what is your situation?
Chairperson, I am flexible. My flight was this evening.
Yes.
But I'm willing to travel tomorrow, Chairperson.
Yes.
Therefore,
Yes.
the 5 o'clock is okay.
Yes. Okay, let's continue and see where we are by 5 o'clock.
Thank you,
Okay.
Chair.
All right.
Right. Mr. Linnell, can you assist us with what services he was providing at SAA?
Chairperson, may I not respond to this question to avoid incriminating myself?
Mr. Linnell testified before the Commission just a few weeks ago that he was brought in to coordinate some of the difficult investigations into senior executives like Mr. Kalawe, the former CEO. Can you confirm that that was part of the role that he played?
Chairperson, may I not respond to the question to avoid incriminating myself?
Why was his services required by SAA?
Did you hear that, Ms. Myeni?
Came late, Chair. It was, I don't know, there was a delay. Yes, I've heard, I've got no response, Chairperson. I don't want to incriminate myself.
You see, the reason why I ask is because the investigation and then the proceedings against Mr. Kalawe were being managed through ENS attorneys, wasn't it?
May I not respond, Chairperson, lest I incriminate myself?
You see, so already SAA had its lawyers, ENS, running the Kalawe investigation and then proceedings. And yet, in addition to that, Mr. Linnell appears to have provided services despite, on his own version in his evidence before this commission, the fact that he was not an admitted attorney in South Africa, had never held himself out as such, and just had a law degree from Zimbabwe. Against that backdrop, Ms. Myeni, what role would he have been playing in addition to that of SAA's firm of attorneys on the matter?
May I not respond to the question, Chairperson? I do not wish to incriminate myself.
Would he bill for his services to SAA?
May I not respond, Chairperson, so I don't incriminate myself?
Ms. Myeni, in your bundle DD34B, we have collated the various invoices that Mr. Linnell submitted to SAA over the period of December 2014 to August 2016. It's just over a year and a half, and I'd like to take you to some of those, if I may. We will start in DD34B at page 1590.
Did you say 1950?
1590, Chair.
1590. So I had it the other way.
Yes.
around.
It is possible I said it the other way. I have to confess a smidgen of tiredness, but we'll keep going.
It's late in the day
It is. And in the week.
and in the week. And you are working tomorrow also.
I know.
Well, I'm working too.
You indeed, Chair.
Yes.
Ms. Myeni, do you have page 1590?
Yes, I do.
So you see, this invoice is consistent with Mr. Linnell's evidence before the Commission. He indicated that he'd been involved particularly in relation to Mr. Kalawe's investigations. And you'll see on this page, there's a very, well, let's go back a page actually, if we may, to 1589. Do you have that?
Yes, 1589.
Yes. So this is an invoice submitted to SAA dated the 2nd of February 2015 from what is, I understand, to be Mr. Linnell's business, the project office. Can you confirm that?
May I not respond, Chairperson? I'm on page 1589, but may I not confirm any, or may I not respond to whatever needs to be confirmed in case I incriminate myself?
So, as I said, a 2 February 2015 invoice from the project office, and you'll see it covers the period. It's headed Independent Advice with regard to alleged irregularities at SAA, December 2014 and January 2015, and it's addressed to yourself as Chairperson of South African Airways. Can you confirm having received this invoice?
May I not respond, Chairperson, in case I incriminate myself?
If you look in the box in the middle of the page where there's the description of the work done, you'll see under the second column, matter, it says 2-hour fee for advice to the subcommittee and the board regarding the Kalawe investigations and related matters for December 2014 and January 2015. See billing memorandum attached. And then you go over to that page where we started, and you have what I would suggest is a fairly detailed billing memorandum dealing with the work that Mr. Linnell had done. And there is an invoice and a total of 192,645 Rand and 26 cents, excluding VAT, which brings the total with VAT to 219,615 Rand and 60 cents. Ms. Myeni, do you know if that invoice was paid by SAA?
May I not respond, Chairperson, in case I incriminate myself?
Now, we've managed to obtain all of the invoices that Mr. Linnell submitted over that period, December 2014 to August 2016, to SAA. And what we noted, and I'd be interested in your comment on, is that the invoices start of this sort of detail, where you get a very detailed memorandum over the second page of the invoice explaining with some particularity what Mr. Linnell was doing from time to time. But then as you get later in the course of 2015, his invoices become much more brief. Let me take you to one, for example. You'll find that at DD 34B from page 1686.
1686. I missed that. Page 16.
1686. 1686.
Thank you, Chair. Yeah. Thank you, Chair. 86. Thank you, Chair. I've got it.
Okay.
This is an invoice dated the 19th of April 2016, and there under matter, it becomes much more brief. It says 2-hour fees in respect of advice provided to the board on various matters. And in brackets, narration included in a separate billing memorandum, which we were, certainly there's no record in SAA of that more detailed billing memorandum. Are you aware whether one was provided with this?
Sorry, Chair, this invoice is provided to
Yes.
the director.
No, that's a good point. This one is addressed to the director. It just says South African Airways, attention, Ms. Yake Kwinana. Were you aware of this invoice when you were chairperson in April of 2016?
Chairperson, may I not respond to the question? I wouldn't want to incriminate myself.
Ms. Kwinana gave evidence earlier this week, and she was asked about Mr. Linnell and his services and the advice that he'd given to the board. And as I have it, her evidence was effectively that he would on occasion attend board meetings and answer when a legal question cropped up. But her approach to Mr. Linnell's services was that they were not really needed. Do you agree with her in that evidence?
May I not respond, Chairperson, to the question? I don't want to incriminate myself.
And then, Ms. Myeni, there are a series of invoices which continue in that pattern of the service being general advice to the board. And within this section of your bundle, we also have the expense authorizations from South African Airways related to these invoices. And I'd like to take you to one of them, for example. You'll find that at page 1684.
Yes, Chair. I've got it, Chairperson.
Thank you. You'll see there, it's an expense author. Is this the type of expense authorization you were familiar with when you were at SAA?
May I not respond, Chairperson, to this question? And I would want to invoke my privilege by saying I was a chairperson, I was not a CEO, and I was not a CFO. So I would leave it at that, Chair. May I not respond to the question?
What caught our eye on this page is where you see sort of a third, in the bottom third of the page, there's in red something that says, please confirm the following, and then there's a box that says one procurement process has been complied with. Do you see that?
I see it, yes.
And then 2, compliance with DOA. I understand that to be delegation of authority. And then 3, budget facility is available for this cost element. Do you see that next to 3 is written there, no budget, not accrued for? Do you see that?
I have seen that.
And just
Yes,
in relation to number 1, procurement process has been complied with. There doesn't seem to be an indication that one was. Are you aware of any procurement process having been followed before Mr. Linnell's services were procured?
Chairperson, I was a chairman, I was not a CEO.
Yes, and happily, Ms. Myeni, if you don't have any knowledge about whether his procurement processes were followed, you could certainly say so. Were you aware?
May I not respond, Chairperson, in case I incriminate myself?
So when he was attending those board meetings, when we were questioning Ms. Kwinana earlier in the week, the chairperson actually raised the question of why there would be a third-party outsider attending board meetings. And as I understood Ms. Kwinana's evidence, it was that he was there to be sort of generally available. I think she said he, on occasion, did ad hoc presentations. She, I don't think, could give us clarity on at whose invitation he appeared. Did he appear on your invitation?
On that particular question, Chair, can I have a supporting document? When you attend a board meeting, there is a attendance register. There is an invitation to attend the board. There is an attendance register. There is also, obviously, when somebody is traveling, there will be a staff, maybe a slip that he flew at this time on this day to attend a board meeting on this. Can I have that record of Mr. Linnell attending board meetings? Then I'll be able to help Chairperson by responding perhaps to the question, or maybe when I say I do not want to respond to this question, then I'm able to make a proper judgment so that I don't appear not to be useful to the Commission. But this information I'm asking is for me to verify Mr. Linnell's attendance to board meetings.
Well,
And maybe just one board meeting where he attended, the attendance register, his flight from wherever he came from to Gauteng to attend the board meeting. Thank you.
it may be that Ms. Hofmeyer does have such documents. It may be that she doesn't have, but I just want to say this. The trouble that sometimes the Commission goes to in order to obtain documents arises when it knows that certain things are being denied or disputed, but it doesn't go to certain trouble if it knows that everybody admits that certain things happened. Now, if, for example, you were to say, I do know that he attended certain meetings, but if you ask me about a particular meeting, whether he attended it, I would need minutes to see. It's one thing. But also if you say, as far as I know, he never attended any meetings, it might warrant trying to get that information. So the start might well be to say, on your recollection, or as far as you know, did he attend certain board meetings or did he not attend any board meetings where you were present, or do you not remember? And then, because Ms. Kwinana certainly said he attended certain board meetings and he attended meetings of certain committees. So maybe, do you want to look at that, or maybe let me check with Ms. Hofmeyer? Do you want to react to the question raised by Ms. Myeni?
Yes, certainly, Chair. I must be clear here. I have looked at lots of board minutes. I can't have said all of them. But as I stand here, I have no recollection of any board minutes, minutes of any board meetings reflecting Mr. Linnell as an attendee. I could be wrong, there might be one or two. My team knows these papers better than me, so I've asked them just to address it. But actually, that is why I was somewhat surprised by Ms. Kwinana's evidence the other day, because she indicated the role he played was at board meetings. So actually, Ms. Myeni, when I put it to you, it's predominantly based on the evidence that Ms. Kwinana gave. And what I was going to follow up with you on is, well, if he was at those board meetings, we haven't seen him reflected in the minutes, and you as chairperson would certainly have had oversight at those meetings. So could you help us, just from your personal knowledge, can you confirm whether he did or he didn't attend meetings of the board of SAA?
Listen, the problem I have is that I am expected to respond to an evidence that was presented before the Commission by Kwinana, which I have not. Perhaps I still need to sit down, go to the Commission of Inquiry's website to listen to Kwinana. I haven't had that opportunity to do so. I have not heard Mrs. Kwinana's evidence in the Commission. So if I'm going to rely on what she said, then I'm not empowered to respond. But Chair, the easiest thing for me as well to add on what I've requested, if I'm to assist this commission, because going forward, I'm certainly going to be able to assist the commission, even post your commission's term, maybe. I would be able to talk to this information if the contract that Mr. Linnell signed would be attached in this file with his invoices and also the title, Mr. Fix. If it was part of his contract, then I'll be able then to confirm. Also, Chair, to assist the Commission, there is a company secretariat at South African Airways. Whether it's me assisting the Commission or it's South African Airways assisting the Commission, including Mrs. Quinan, then that would be, we will all be able to give proper information, which will be factual information, so that I don't listen to what Mrs. Quinana said. All I can say is that if I am empowered with the information before me, I will be able then, Chairperson, to be of assistance to you.
Well, the only thing, Ms. Myeni, is that all that Ms. Hofmeyer was asking is what you know or what you don't know, what your recollection is, irrespective of what documents might say. It may be that there are minutes somewhere. Ms. Hofmeyer says she has seen a lot of minutes of board meetings, but she doesn't recall seeing any minute that reflected Mr. Linnell as having attended the board meeting, any board meeting of those that she saw. She doesn't say that there are no board meetings that might reflect that. She doesn't know if somebody in her team might have seen such minutes. But of course, she does say what Ms. Quinana said, namely that she said Mr. Linnell did attend some board meetings. So she is simply asking you to say, on your recollection, do you remember Mr. Linnell as having attended some meetings, or do you have no recollection whether he attended any meetings, or is the position that you feel that you might incriminate yourself and would prefer not to answer the question?
Chairperson, I need to have Mr. Linnell's contract, which would have been generated by SAA, not by Dudu. That's one. And the board resolution, Chair, that was taken to appoint Mr. Linnell as an advisor to the board, not as a Kalawe somebody, but as an advisor to the board. The board resolution would articulate those things, and his contract would articulate those things. And Chair, for my understanding, SAA had consultants, different consultants, but no consultant would simply be part and parcel of a board meeting. The consultant would be required to walk inside the board meeting to present a certain aspect that the board would need in terms of update or in terms of a report to also understand the status of where whatever the consultant is doing, where the status of that particular advice to the board or to the company is. But for me to, because this thing is put before me as Dudu's Mr. Fix, I prefer that I get the attendance register, all the things that I've requested, the contract, and the board resolution that appointed Nick Linnell to advise the board, not Dudu. So in other words, then, Chairperson, in that regard, I leave this question as something that I can be of assistance to the to the commission and to the chairperson, but I need to be empowered with the information that I've spoken about. Chair.
Yes, but
Other than that, I can't then.
But you see, Ms. Myeni, the problem with that answer is that Mr. Linnell's contract is not going to tell you whether he attended a particular meeting of the board or how many meetings he attended. So what you are being asked is something that you either know or you don't know, or you remember or you don't remember. That's all that is being asked. And if you are not sure, you are not sure. So the minutes of a board meeting, if they reflect that he attended, they might assist, but it may be that they don't reflect. And all that you are being asked is, on your knowledge, on your recollection, what was the position? Did he attend some meetings of the board, the whole meeting? Did he attend only briefly on certain specific issues? Or on your recollection, he did not attend at all?
May I not respond, Chairperson?
Okay, all right.
I don't want to incriminate myself.
Okay.
Thank you.
Ms. Hofmeyer?
Ms. Myeni, the answer you've just given is consistent with the answer that you gave in your affidavit when you were asked by the chairperson of this commission in his Regulation 10.6 directive to tell him everything you know and provide as much information as possible about the legal fees paid by SAA to Nick Linnell and reimbursements to yourself. Do you remember answering that question in the chairperson's directive?
Not sure.
Okay, well, it's at page 8 of DD 34A, which is the file that we aren't often in, but it is part of your bundle. If you'd like to turn it up, at page 8 of DD 34A.
DD 34A, page 8, is that right?
Yes, indeed.
Yeah.
Page 8.
Yes, page 8.
I've got it, Chair.
You'll see there you deal with the second topic in the chairperson's directive, and it's headed legal fees paid by SAA to Nick Linnell and reimbursements to myself. And you say at paragraph 23 there, I'm advised that in view of the possibility that the National Prosecuting Authority may want to charge me in accordance with the order of Tolmay J, I do not have to answer this question. So, Ms. Myeni, do you accept that you had fair warning before today that this was going to be a matter to be traversed?
I think, Chairperson, as much as the Chair had said, I must not have a blanket response, but anything pertaining to what the order is before me by the judge, this is consistent with the order. Chair, for what I've been asked now, may I invoke the privilege of not responding to the question?
You see, Ms. Myeni, I asked you about procurement processes because in our engagements with SAA, we did not find any procurement process having been followed. What we did find was that there had been an endeavor to motivate for Mr. Linnell's invoices to be paid, and I'd like to take you to that motivation. You'll find it, well, let me be clear. It's a motivation that comes before the SAA Board of Directors on the 29th of February 2016, and you'll find it in DD 34B, the old file we were in. And
What page?
at page 1695.
I do have it.
What you see there, the first thing I have to say to you in fairness that I noticed when I looked at this memo is it's very like the memos that you usually see from South African Airways and that me and my team have become far too familiar with for our own good. It usually has that block at the top where it says to SAA Board of Directors, date 29 February 2016. But there's actually usually a third block there that indicates who within SAA was the author of the document. Does it surprise you like it surprised me that there isn't a third block there?
What is surprising you, ma'am? Sorry.
That there isn't, you know, on the usual board memos, my team will maybe help me just to find one so I can take you to it. There's usually that block at the top. It shows you who it's addressed to, the date of it, and then it usually says who wrote it from. You know, it's been written by the acting CEO, or it's a document prepared by the legal department. But this one doesn't have that third block. Is that unusual?
May I not respond, Chairperson? The only thing I'm seeing here is the company secretary. So may I not respond because I don't know.
Where do you see the company secretary? Because I was about to say a resolution, one would expect the company secretary to sign at least. Is there something to suggest?
Top right, Chair, to assist.
Top right. Just below the address. Are we on the same page, 1695? Ms. Hoffmeyer, is that the page you said we must go to?
That is where we are, yes.
Okay. Where about at the top right, I can see South African Airways Company Secretary. Oh, that's what you are referring to?
That's what I'm referring to, Chairperson.
Yes.
Well, this is what I'm seeing now, Chair.
Yes.
That talks to the letterhead of the company secretary. And at the back here, Chairperson, I see that there is a resolution that was generated by the company secretary. So,
well, the letterhead may be that of the company secretary, but one would normally expect a resolution to be signed by somebody. My impression is that it's normally signed by the company secretary, but it may be that sometimes the chairperson signs, I'm not sure. But I don't see anybody having signed here, and other than the company secretary being reflected on the letterhead, there seems to be nothing on the document itself to indicate who prepared the document.
Ms. Myeni, I might just be able to assist. If you go to DD19, you'll have DD19 amongst your files there. It's the bundle of Mr. Motibe's evidence. I've just picked that randomly because it's one of the memoranda that I would like to just show you as striking me as a comparison.
I'm sorry, Ms. Hofmeyer, please don't forget
Of course.
what you want to go on to. I see that on the next page, namely 1696, there is a letter from the company secretary addressed to, or dear director, and then it says SAA Board of Directors written resolution number 2016/B04, ratification of the appointment of the external advisor to the board. And it says we refer to the above matter and attach here to the written resolution number 2016/B04. Kindly consider, sign, and return to us the written resolution by 12 o'clock Thursday, 3 March 2016, via email. Kind regards, Ruth Kibuga, Company Secretary. Now, I don't know whether, I think that's a reference to this resolution, because this resolution at page 1695, because it does refer to, it does say written resolution number 2016/B05.
Yes.
If that is so, then one can take it that the company secretary knows about or knew about
Yes,
the resolution.
indeed.
Yes.
What I really, my question...
That's part of what I didn't understand.
Of
At
course.
least that part seems to be clarified now.
No, it does indeed, Chair, and we're indebted for that. I guess where my point drives at, and maybe I must just go there immediately, it's not clear to me who the author of this document was, because usually it's identified acting CEO is presenting this to the board for consideration and requires a particular resolution to be taken. This document is not like that, and I was just wondering if Ms. Myeni found it unusual in the same way that I did. Ms. Myeni, would you like to answer that? Is that unusual to you too?
Let's first check. Did you follow what I was saying about the letter or email at page 1696, Ms. Myeni? I know your picture was, you did follow what I was saying. You had everything.
I stood up to take the file, Chair, sorry.
Yes, okay, no, that's fine. Okay, maybe you can repeat your question then, Ms. Hofmeyer.
Yes, I was just...
I heard what she wants me to respond to.
Oh, okay, all right, yes.
Could you give us your response?
I'm going to check.
Thank you.
Okay.
Yes, you may respond, Ms. Myeni.
No, Chair, I'm not going to respond to this particular document, Chairperson, but I'm going to say that a ratification of a decision that has already been made might be different from a memo to the board, which is a normal memorandum that gets submitted by the staff, by the executives. So when the executives presented or would like the board to approve something, and the board meeting maybe is still forthcoming, maybe the board meeting is in a month or 2 months, because the board is not a Monday to Friday thing, Chair. The board would meet maybe bi-monthly or every quarter, 4 times a year, depending on the size of the entity. So some decisions that are needed urgently would be sent, a motivation would be sent electronically to all board members. Board members then would send individual responses to the company secretary's office. When the company secretary has all the responses, then the company secretary at the board meeting formally will say, we have to ratify what was electronically decided upon. So the ratification I see here is based on many other ratifications that would occur under normal circumstances, under normal circumstances. So I'm saying this could be amongst those, but I can't confirm that this is. All I'm saying is that if it is different from a board memorandum that Ms. Hofmeyer refers to, 1, 2, ratification of a board resolution is not a board resolution that would be a normal way of asking the board to approve something at the board meeting while the board is sitting. That's my only way to assist you, Chairperson. Also, if I check here on the page 1698, normally at the board meeting, the board of directors would sign there where it says name of the director, in favor or against or abstain. So we would sign such things, but sometimes they would send us information individually for us to take a decision after reading whatever that is being proposed by the executives or whatever that is required in terms of urgent approvals. So this, for me, is a ratification.
Thank you, Ms. Myeni. We're indebted to you for that insight. I would just like to take you to the page 1697 of this document. And we really do, we're now chasing the clock, so
Yes,
we're going to try and
terribly sorry, I think we must take just a brief
of course.
adjournment. Let it be 10 minutes only, and then we will resume. We adjourn.
Thank you.
Ms. Myeni? Ms. Myeni, we are about to resume. Ms. Myeni, we are about to resume. Are you connected?
Yes, sir.
Thank
I'm
you.
available.
Ms. Mayor? All rise.
Okay, let's continue.
Thank you, Chair. I'm very mindful of the limited time, so I would like to just raise one further aspect in relation to Mr. Linnell with Ms. Myeni. Ms. Myeni, over the period that Mr. Linnell was providing services to SAA, which was between December of 2014 and August of 2016, do you know how much SAA paid him in that period?
May I not respond, Chairperson, so that I don't incriminate myself?
If I told you that it was just short of 2 million rand for that little bit more than 18 months, would that surprise you?
May I not respond, Chairperson, so that I don't incriminate myself?
Ms. Kwinana's evidence the other day was that his services were not really needed. Do you hold that view as well?
May I not respond, Chairperson, so that I don't incriminate myself?
Do you accept that if a state-owned entity paid just under 2 million rand for services that were not really needed, that would constitute wasteful expenditure?
May I not respond, Chairperson, so that I don't incriminate myself?
Ms. Myeni, I'd then like to move to an allegation that has been made in this commission previously by Ms. Nancy. You will have received a Rule 33 notice in relation to Ms. Nancy. Did you follow her evidence at all?
Chairperson, I don't watch the state capture inquiry evidences of anyone. So
Well, let me tell you what she did say in her evidence. She dealt with this topic of false whistleblower reports that she indicated she had been told by Ms. Kwinana you used to prepare in order to get rid of executives who you no longer wanted in the management of SAA. Are you aware of those allegations?
in this regard, Chairperson, I think I responded when I was asked a question. What I don't recall properly with regards to Nancy, who was the acting CFO when he became CFO. What I don't remember properly is whether my response was as a result of, whether my response was as a result of the media inquiry or something. But I remember responding.
Well, could you, sorry.
In particular to the allegations that were leveled against me by Nancy. And I said, I would hope, that was my response then, and it's going to be my response now. I would hope, Chairperson, that the Commission is not a hiding place for tainted employees who leave employment having committed serious offenses where they come from. That was a general response I made when I was asked about Nancy. And therefore, it's the same response I'm making right now about what is being said about whistleblowers and about about what Nancy alleges I would have done regarding the whistleblowers. But also, Chair, there are too many gossips going around. Now, when I read Nancy's affidavit on whistleblower, she was sitting with her friend, Queen Nana, gossiping, talking about whistleblowers. And I cannot then change my response then and my response now. Yeah, sorry, Queen Nana and Nancy are friends. And they've been business partners, or they've worked together in some businesses, including Dinel. Therefore, I do not want to glorify what is being said here about Nancy talking about me and whistleblowers.
Ms. Myeni, did you?
My response. That is my long-winded response, Chairperson, because I'm referring to what I responded to last time, and it's the same response I'm making right now, Chair.
Ms. Myeni, did you prepare false whistleblower reports in order to target members of management who you did not want in the organization?
Chairperson, may I not respond to that particular question being referred to, in order not to incriminate myself?
Ms. Myeni, I didn't have an opportunity to ask Ms. Kwinana about these allegations because her evidence didn't complete on Tuesday and I was still coming to the question. But are you aware that she gave this account of false whistleblower reports to out her shortly after she left SAA in August of 2016?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Chair, I do just want to, for the record, be clear. Ms. Kwinana was asked about this in her Regulation 10.6 directive. Her response in her 10.6 directive is, I quote, "I have no way of knowing whether the false whistleblower reports allegedly prepared by Ms. Myeni are false or not." That is her version on affidavit. I intend to pursue that with her tomorrow in the evidence. I wanted to give Ms. Myeni an opportunity to answer that allegation against her, though. Ms. Myeni, I'd now like to move to the BNP transaction. Is that a transaction you're aware of?
May I not respond, Chairperson, to the question to avoid incriminating myself?
Ms. Myeni, we received evidence of Ms. Cynthia Stimple before this commission. I think she testified over 2 days dealing with the BNP transaction. And she explained that around February 2015, SAA was in dire need of cash and had reported that to Treasury, and so it was in the process of securing funding. Can you confirm that that was the position in February 2015?
May I not respond to the question, Chairperson, to avoid incriminating myself?
Ms. Stimple's evidence was that there was a cross-functional team established in order to secure this funding, and that they'd worked quite steadily on it. But then in October 2014, remember when the old complaining members of the board are not retained, and a much smaller board of yourself, Ms. Kwinana, Mr. Dixon, and Dr. Tambi is then put in place. The board, on her version, started to involve itself in securing funding. Can you dispute her evidence on that?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Ms. Stimple's evidence was that that level of board involvement was something that she had not experienced before at SAA in her many years. Are you aware of that level of board involvement prior to this transaction at SAA?
Chairperson, may I not respond so that I don't incriminate myself?
It got to a point where the board actually involved itself both in reviewing the draft RFP for the funding that was required, evaluating proposals and appointing bidders. And Ms. Stimple said that similarly was unprecedented in the history of SAA's funding endeavors. Do you dispute that?
What is the name of the person? Sorry, what is the name of the person?
Ms. Stimple, Ms. Cynthia Stimple.
Was she an executive?
She was group treasurer at the time.
So was she an executive, ma'am?
No, she was not.
Was she in the EXCO?
No. No, she was running the cross-functional service team who was responsible for securing the funding.
It's unprecedented for a junior executive or a junior manager or a manager to expect that the chairperson would just know her from Cynthia. Under normal circumstances, chairperson, if the board members mentioned here do not include executive directors, then it's not a factual reporting or accurate representation. The board was constituted in accordance with the MOI of the organization. There will be a specific number which would be minimum to maximum. Now, what I'm surprised about is the mention of the non-executive directors, but the executive directors are not mentioned, Chairperson. Secondly, if you were not a deputy finance person or a deputy CEO or maybe an HR executive or any other executive, it would be difficult for me to remember the other layer that was not at the executive level. So there is an assumption by Ms. Hofmeyer that when she says Cynthia, then I would automatically know who Cynthia is. I was not a CEO of SAA. I was a non-executive director and a chairperson of the board.
Ms. Myeni?
So that is why I'm asking, who is Cynthia?
Ms. Myeni, I think it's a product of the delay and maybe a break in transmission. I would never, in the proceedings of this commission, refer to somebody by only their first name. I did refer to her as Ms. Cynthia Stimple. I asked you about whether you'd watched her evidence. And the question I put to you is just the evidence she's presented to the commission. Her evidence is when they were seeking this funding in February of 2015 and the months thereafter, the board got involved in vetting the RFP for the funding, evaluating the proposals for the funding, and appointing the bidders in a way that she had never, appointing the bidders to whom the RFP would be circulated. And she said she'd never experienced that before. And so what I was asking you was, do you dispute that this was the first time in a funding scenario that the board was getting itself involved?
May I not respond to the question, Chairperson? In case I incriminate myself.
What happened was the RFP went out according to Ms. Stimple's evidence. Bids were received, evaluations were done, and that cross-functional sourcing team in which she was involved selected a combination of 3 banks to source the funds: Standard Chartered, Nedbank, and ABSA. And they were ready to go, but then there was a board meeting that was convened on the 3rd of December 2015, at which it was decided that the Free State Development Corporation should be the funder for SAA. Do you recall that decision being taken by the board?
May I, Chairperson, not respond to the question being posed to avoid incriminating myself?
Ms. Myeni, you are indicated as having been a member of the board at the time and a supporter of that decision, and that was the evidence of Ms. Stimple insofar as the record of the decision-making was concerned. And in the light of that, I'd like to ask you how it could be that you took the view, as one of the voting board members, that a public entity like the Free State Development Corporation could become involved in funding an SOE?
What is the problem with the question you're asking, ma'am?
Well, National Treasury later said that it was not within the Free State Development Corporation's legal mandate to fund an entity like South African Airways. Its mandate was limited to development projects within the Free State. So I'm asking you why you as a board member supported the FDC funding SAA to the tune of 15 billion rand.
May I not respond to that question, Chairperson, so that I don't incriminate myself?
So what happened first is that there's this decision of the board on the 3rd of December 2015 to get FDC to be the funder, but that is scuppered because in early January 2016, National Treasury conveys to the team at SAA that the FDC would be beyond its mandate if it were to provide this funding. And on Ms. Stimple's evidence, what then happens is that the board decided to appoint a transaction advisor to source and facilitate this funding that SAA was looking for. Do you remember making that decision?
May I not respond, Chairperson, in case I incriminate myself?
Do you dispute that you were a member of the board that made that decision?
May I not respond, Chairperson, so that I don't incriminate myself?
Ms. Stimple said the board's decision was, to her mind, concerning because all that work that her team had done in running the RFP process, in getting the bids from the banks, was now going to be redone by this transactional advisor. Why was the board thinking a transactional advisor needed to be appointed to do work that had already been done?
May I not respond, Chairperson? I don't want to incriminate myself.
So a process was run according to the evidence of Ms. Stimple, and an entity called BNP Capital was awarded the contract as a transaction advisor. We received the evidence of Mr. Mahlangu, who was a director of BNP Capital before this commission. And in the course of his evidence, it was pointed out to him that there were numerous false statements and incomplete documents in the bid submission. Does it surprise you that an entity like BNP Capital could run through a procurement process at SAA while you were its chairperson, be awarded a tender, and then having done so when it had included false statements and incomplete documents in its bid submission?
So only white transactional advisors would rather be preferred. Is it because he was a Mahlangu, or is it because he had no capabilities of doing the work, or he did not compete with other tenderers, with other service providers? It's a question of clarity, Chairperson.
Yes, certainly.
What would make him not able to do a job for South African Airways? Was it a reserved space for either banks, or was it a reserved space for some of the consultants or financial entities that would be able to source funding for South African Airways? I'm just asking a question because there must be a beginning for a new entrant to be able to be also counted in the current situation in the country, where any other person who is competent to do the work must do the work. But now I'm asked, why Mahlangu, why BNP Capital? I've never met him, I don't know him, but I'm being asked a question which is operational. Cynthia, Chairperson, would have reported to the CFO, who is an executive director of SAA. Therefore, Chair, with this background, I'm not invoking my privilege but I'm not responding to the question that has been asked.
Ms. Myeni, that is not an answer to my question. My question was based on the evidence before this commission that BNP Capital submitted a bid containing false statements and incomplete documents, and despite that were awarded a tender. And I asked you whether it would concern you to learn that that is how a procurement process was run at SAA.
If the non-executive director, if the executive director, the CFO, had come to me and told me that these bidders are before us with false information, that is something else. But for me to say, did it concern me or does it concern me or would it have concerned me? Chair, may I not answer this question in case I incriminate myself?
Mr. Mahlangu testified that a Mr. Masocha Mngadi was, I'm paraphrasing now, but really the brains behind BNP, and that was he who had all the meetings with SAA, and there was an allegation that Mr. Mngadi is a business associate of your son's. Is that correct?
May I not respond to the question, Chairperson, in case I incriminate myself?
What then happened in the passage of events is after BNP was appointed as a transactional advisor, there was a decision taken to get the BNP to then source the 15 billion rand. That had never been part of the original tender, but the board took a decision to now extend the scope of BNP without going out on tender for the sourcing of the funds and to get it to do so.
Can I just, a clarity there, who appointed BNP Capital?
BNP Capital as transaction advisor was appointed, I think it fell within the CEO's delegation. I will just have to check that.
Thank you for clarity.
Sure. So now I'm asking, this extension of the scope of the transactional advisor was a decision of the board. So the transactional advisor had been selected through a procurement process, but then the board intervened on the 21st of April 2016 to extend BNP's scope to include the sourcing of funds. Do you recall having made that decision?
May I not respond, Chairperson, to the question?
Do you dispute that as a member of the board? Do you dispute that as a member of the board you took that decision to extend the scope in a situation where no procurement process was followed prior to its extension?
I request to invoke the privilege, Chairperson, of not responding to the question.
Now then a fairly odd thing happened because the board had taken the decision to extend the scope of BNP to include sourcing of funds. And that was on the 21st of April. But then on the 6th of May, a few weeks later, Ms. Stimple was asked to sign a bid adjudication committee submission motivating for the decision that the board had already taken. Is that something that regularly happened at SAA under your watch?
May I not respond, Chairperson, in case I incriminate myself?
Ms. Stimple, around the 6th of May, was going away on, and she was concerned that this BAC submission should not be signed. And she instructed her colleague, Mr. Klein, not to sign the BAC submission, but she was told by him that he had received pressure to do so and had done so. Were you aware of this pressure being applied pursuant to the board's resolution on the 21st of April 2016 to get the BAC submission signed?
May I not respond, Chairperson? May I not respond? I don't want to incriminate myself.
And then what happened was the board approved the appointment for a second time of BNP on the 24th of May 2016. Do you dispute that you were a member of the board that took that decision?
May I not respond to the question, Chairperson? I don't want to incriminate myself.
Now, the board took the decision on the 24th of May 2016. It was communicated to BNP on the 25th of May 2016. And on the same day that BNP was appointed to source funds, BNP wrote back to SAA and said that it wanted SAA to commit itself to a cancellation fee for the work that it had already done on sourcing funds, despite the fact that it hadn't been appointed to do so. Were you aware that BNP was seeking a cancellation fee on those terms?
May I not respond to the question, Chair, in case I incriminate myself?
So on the very same day it's appointed, it wants SAA to commit to a cancellation fee. I think the cancellation fee started off at about 300 million rand. Do you recall Ms. Nancy having discussed that with you?
May I not respond, Chairperson, in case I incriminate myself?
Do you dispute that that initial amount of 300,000 was brought, 300 million was brought to your attention?
May I not respond, Chairperson, in case I incriminate myself?
There was a series of correspondence between BNP and SAA at the time as it kept motivating for this cancellation fee. It made reference to the fact that they'd been trying to seek funders in all sorts of foreign locations and had to take trips there in order to do so. We received, however, the evidence of the main funder, which was an entity called GRISAG. Do you know the entity GRISAG?
May I not respond, Chairperson? May I not respond, Chairperson, because I don't want to incriminate myself.
The Commission received the evidence of Mr. van der Merwe, who was a director of GRISAG, who told the Commission that what BNP was telling SAA about all of the costs and work that it had done was false. Are you aware of that evidence?
May I not respond, Chairperson, so that I don't incriminate myself?
All of a sudden, in this interchange between SAA and BNP Capital, that initial fee of 300 million dropped to 49.9 million. And Ms. Nancy's evidence was that that followed a call that she was told you had made to Mr. Zwane. Do you dispute that you made a call to Mr. Zwane dealing with this drop of the BNP Capital cancellation fee amount?
May I not respond, Chairperson, in case I incriminate myself?
Ms. Nancy's evidence was that in that conversation, as relayed to her by Mr. Zwane, was that you'd inquired about the level of the CEO's cap of delegation because Ms. Nancy was raising issues about it going to the board, and you wanted to find out from Mr. Zwane at what level the decision to approve the cancellation fee would not be required to go to the board. Do you dispute that that conversation took place between you and Mr. Zwane?
May I not respond, Chairperson, so that I don't incriminate myself?
Ms. Myeni, you were, I think on our records, the only member of the board who supported approving the cancellation fee. Do you dispute that you were the only member of the board that approved the cancellation fee?
Where did the approval, the motivation come from, Ms. Hofmeyer?
I'll deal with that in a moment. It came from Ms. Nancy. I'd like to take you first to your email in which you convey your approval. You'll find that in bundle DD1. So if you can pick that up, and it's the second file, so it'll be DD1B, And we need page 559.
I see we are at 5.
I have it, Chairperson.
Do you plan to ask 1 or 2 questions, or what's your?
If I could just deal with this email and then we could think about logistics, Chair. Could I complete the email depending on my learned friend's position?
Oh, Mr. Butulez, is that fine? Okay, all right.
Thank you. You have 559 in front of you, do you, Ms. Myeni?
I was going to ask for the page.
Sorry.
I have the file I found, so page 559.
Yes, you'll find it under tab 59 in that file, if that assists.
I have it, Chairperson.
I'd like to start midway on the page because that is an email from the Deputy Company Secretary. It's addressed, Dear SAA Board Member, and it says, attached herewith for your consideration and approval, please find the round robin in respect of the approval of the cancellation fee to the transaction advisor. Please kindly communicate your decision as indicated in the round robin form. And then above that is an email from your Jacob Zuma Foundation address, dated the 7th of July 2016, responding to the Deputy Company Secretary, and your email reads, Dear Mdu, does this need board approval? If so, I approve it. Regards, Ms. Dudu Myeni, Executive Chairperson. Ms. Myeni, do you dispute having sent this email?
Chairperson, may I not respond so that I don't incriminate myself?
Ms. Myeni, in fairness to you, I must put it to you that your first sentence of that email, querying whether this decision needed board approval, is consistent with the version that Ms. Nancy presented to this commission, related to your conversation with Mr. Zwane about what the level would be in order for the matter not to come to the board for approval. Do you dispute that?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Chair, those were my questions in relation to that email, and I'm very conscious of my learned friend's constraints, so maybe we should be thinking about taking matters forward.
Yes. You might be needing about 30 minutes, or at least not more than an hour to finish.
Oh, yes, certainly.
Yes. Should we make arrangements for Ms. Myeni to give evidence during one of the evening sessions that we can look at on one of the days? From your side, how does that, without speaking about the date, how does that sound, Ms. Hofmeyer, from your side?
Yes,
Subject to the date.
Indeed, Chair.
Yeah. Mr. Buthelezi, is subject to the date, would that be fine with you? It might be from 5 to 6, 1 hour, or depending, but coming in at 5 or at 4, just depending on the date that we can arrange.
See, Chair, the time now is just slightly above 5.
Yes.
If we could get a firm undertaking that.
Sorry?
If I could get a firm undertaking by latest 5:30. we could then wrap it up
We could wrap it up.
then in its entirety so that it doesn't
We don't have to, yes,
roll over.
yes. How does that sound, Ms. Hofmeyer? It's just that sometimes you can never be sure.
I really can't. I will do my absolute best, Chair.
There's,
I can't commit it in a way that
yes.
means.
I guess you can commit if it were something like not more than 45 minutes, not more than an hour.
Not more than an hour,
But-
I could very
Yeah,
comfortably
but
commit to. It's
within
just,
the time that's left,
Yes.
you might not be sure because you
Indeed.
don't want to mislead him.
Of course,
To say
of course
you finished by 5:30.
Yes.
No, Chair, I object to the hour. I'm giving 30 minutes because we are here now.
No. I'm not saying let's go for an hour.
Yes,
No, I'm not saying that.
So I'm saying, Chair, we've done the utmost in making sure that we wrap everything up by today, including the fact that we agreed to coming early, even after having run late. We're agreeing now a second time to a further extension. So I think, Chair, that there's got to be a level of fairness to say, look, the commission must do its work, but also have within reasonable parameters for the rest of us to say, what I don't want to happen is to leave this hanging today and then we spend 2, 3, 4 weeks trying to organize the next date because of availability issues on our side. I think it's also prejudicial to clients to have this thing now hanging by another hour after she spent 3 days committed to the process. So what we envisaged at the start of the process was that come this time today, this would be behind us. So we are making as much compromises as we can to say, let's put this behind us. And we then also implore the commission to say, having allocated the time of 3 days for yourselves, to say, we want this witness here for 3 days. The witness has been here for 3 days. And we've now, even on the third day, given further times. I think they also need to come to the party, Chair.
Well, the problem with that is even if Ms. Hofmeyer, even if we continued and she finished by 5:30, that would not necessarily be a guarantee that Ms. Myeni won't be asked to come back. So that's not a guarantee. But what I'm interested in is to try and make sure that everyone is reasonably accommodated. If the position is that we can't finish today because of time constraints, we look at another time when everybody can make themselves available. Now, when I talk about an evening session, maybe from 5 to 6 or whatever, from my side, I'm looking as soon as possible, but I accept that not everybody might be available, so it's subject to discussion, that part. When we are looking at a date that's close by, like within 2 weeks, that we discuss, we can discuss, but when we looking at a date that's quite far, we don't discuss that. We can fix the date because we are giving reasonable notice. But when it's close, we accept that that might not be reasonable notice, therefore it should be subject to discussion. But I don't know what Ms. Hofmeyer actually did say. There is a part that would be dealt with by another member of the legal team. That's the part that relates to ESCOM.
Yes.
So when Ms. Hofmeyer has finished, it doesn't mean that everything has been finished. I know that Mr. Slegger had in mind that he would get time today to question Ms. Myeni on ESCOM, but obviously that hasn't happened. So it may well be that we might not be looking at an hour, but the ESCOM part, I know, is a very narrow issue.
Yes.
It's a very narrow issue. I can't see it taking more than an hour. So it may be that we should look at maybe about 2 hours, which could be 4 to 6, which could be 5 to 7 on an evening that we can agree upon in the next 2 weeks or something like that. So basically, the idea is we can talk about when it should be, as long as everyone accepts the principle.
Sorry, Chair, we've just got one of two propositions. Initially, we had the one question that hung over with Mr. Manaka's affidavit, where we had accepted that we could receive written questions which we'd respond to. I don't know whether it's still feasible to take the same approach for the balance of Mayor's questions, to come via written questions. I'm not too sure what the attitude is with regards to Mr. Sleka's questions. However, then, given clients' constraints and logistics, we cannot commit at this point what we could do, but we would endeavor, if the chair insists that it proceed with oral evidence, then that we just do a similar formula, even if we do it in the evenings via video link, so that it doesn't matter where she is, that she's still able to then, doesn't have the burden of having to plan a whole logistics. We are Gauteng based. It would be easier for us. So if we can leave it to the attorneys then to arrange maybe dates, I can't speak for them, but maybe around, if you say chair, it should happen soon, then she'll still be allowed to then do that.
Yeah, no, in terms of Ms. Myeni giving evidence via video link, that can still happen. That can be arranged. That's point one. Point two, as long as the principle is accepted to say we might have to use an evening session, then one, I can leave Mr. Mayor and yourselves and maybe Mr. Sleka to talk about a date which I can approve. If no agreement is reached, then I will fix a date and give reasonable time.
Chair,
That would be the arrangement. But preferably, I would seek that we all agree on a date that's close.
Chair, could I just make the following submissions? My learned friend referenced the fact that 3 days had been set aside, which we absolutely accept. But we should not lose sight of the fact that we started appreciably later than we had hoped to on the first day, because we were told the day before, and let me be clear, I fully understand why we were told the day before, that Ms. Myeni had recently had an exposure to COVID. She needed to take precautions, and because of that, we, from Tuesday late afternoon, had to start making arrangements for how to facilitate the video link evidence that would happen the following day. So what I'm just trying to get clear is there was a delayed start. We really had estimated being able to do it in 3 days, but unfortunately had to take those steps to facilitate the Zoom evidence given her recent exposure. I understand she couldn't have notified us earlier than that. What I'm particularly worried about, as I think about it now, is these 55 files that have to get to Ms. Myeni, wherever she is going to be.
Okay.
And I understood her earlier to say that she's going to be flying somewhere, either tonight or tomorrow. So that might mean she's in a different location when we convene. And off the back of all of that, what I would like to suggest is whether there's any way that at least this evidence could complete itself today. I'll explain why. If all that's left over is the ESCOM evidence, I know that there's one file for ESCOM. So that would be a much easier logistical thing to manage with Ms. Myeni wherever she's located, and to do it potentially by Zoom. But there really will be a logistical difficulty. If we can't go on today, I do understand if we can't, but then we need to think very creatively of how we're going to get 55 files to wherever Ms. Myeni is going to be after she takes her flight. I think it was either later today or tomorrow.
Well, the question that would arise is whether, given the fact that you think you are something like 30 minutes or 45 minutes away from finishing, whether she would still need all those many files, or whether there would only be a few, 2 or 3 that she might need, which would obviously be better than 55.
That is true. No, there
Yes.
could
Yes.
be a culling, definitely,
Yes.
Chair.
Yes, okay. Okay. So, I mean, certainly if one is talking about 55 or 40-something fires, logistically, that could be a nightmare in terms if she has got to testify via video link from too far from away from Gauteng. But if it's a few fires, as you say, that might be fine. Okay, shall we say one, you will talk, the lawyers will talk on both sides, and can then be approached by yourself to approve a date. And then, as I say, if there is no agreement, I'll just fix a date, but
Certainly.
give reasonable time. Before we finalize, or you want to say something, Mr. Mchilesi?
Yes, Chair. We were going to ask that we adjourn for maybe just 5 minutes. We discuss amongst ourselves the extent to which we
Yeah.
can accommodate today, because first prize would be
To finish.
to finish.
Yes,
So there's
yeah.
other work that we all must do.
Yeah.
So if this can remain today,
Yes.
it should be ideal.
Okay.
And I think I also am conscious of client not to have this pending.
Yes,
It's been
yes.
pending pre this, it's going to
Yes.
be pending even after. So
Yes.
the more of it we bring to an end, Chair, it would be
Yes.
ideally appreciated. So
Yes.
we're going to try to accommodate, but the reluctance, I'm not saying there's a reluctance to accommodate us. I'm saying
Yeah.
Ms.
You want to
Hoffmeyer
explore?
must also try herself to say, okay, fine, let's
Yeah.
let's cut it.
Yeah. No, that's fine. Now, we can adjourn. I
Thank-
think
five
as long as you appreciate, I don't know, Ms. Hoffmeyer might be up to date about this. As long as you appreciate that there is the ESCOM part, which might have to come later or might continue depending. I don't know if Mr. Slegger is around or whatever, but let me adjourn for 5 minutes. Ms. Myeni, you understand what is being discussed there?
I do, Chair. Thank you so much.
Yes. From your side, you don't have any particular serious difficulty with whatever arrangement?
Chairperson, with respect to the commission, I made an undertaking, and I still do. Whatever that is reasonable to all of us. But the first prize is to finish.
Okay. Today, if possible.
Because what I don't want is to find myself, Chair, with the exposure.
Yes.
And now the pressure that I'm
Yes.
undergoing here.
Yes.
Then I end up starting to have my low immune system. So I'm trying by all means. In between here,
Yes.
these breaks have been assisting.
Okay.
Because I'm taking vitamins and stuff like that. So I'm just saying, Chair, I'm
Yes.
flexible, but
Yes.
I'm also within a certain reasonable time.
Yeah.
I would prefer to finish.
To finish. Okay, no, that's all right. Let's take an adjournment. It's about 17 minutes past. So maybe we return at 25 past. We adjourn.
Thank you, Chair.
Mr. Buthelezi?
Thank you, Chair. We've said, let's proceed, Chair. And Mr. Silega must also come and proceed because he's one person with one file. So I don't foresee why it would be difficult for him to latch onto that. We'll run it for how long, however long it needs to run. Let Ms. Hofmeyer finish her part, and then Mr. Silega arrives, and then we finish tonight, and then we all go it.
Well, as I say, I don't know what Mr. Silega's position is. He, as I understand it, certainly was going to be available if Ms. Hofmeyer had finished at a certain time, but whether he was going to be available after is something that I don't know anything about. So it just depends on that. That's something that I don't know anything about.
Chair, let me be clear. I indicated to Mr. Seleka that we were going to run for the day, and so that it would not be the case that we would get to his evidence today.
Yes.
And so he would not be prepared in any way to do the evidence.
Yes.
And it would not, in my view, be in any way feasible to drag him here in those circumstances. So whatever happens, that evidence, if we're able to complete this evidence today, will have to be done at another point, which regularly happens when we run out of time on the allocated days. If that's an issue for my learned friends, then we must move everything to that other day, but I would be keen again to try and finish my section if we can.
Yeah. Okay, Mr. Buthelezi.
Sorry, Chair, we don't have an answer on the prospect of receiving written questions from Mr. Silega.
By Mr. Silega?
Yes, Chair.
Well, one, he is not here. Two, I doubt that in regard to the ESCOM part, I doubt that I would prefer that it be dealt with by way of written questions. But for example, with regard to the Manaka affidavit, I don't have a problem that be dealt with. Each issue depends on its own merits.
Then before we proceed, then can we get an undertaking from Ms. Hofmeyer? How much longer are we here for?
As I said previously, certainly no longer than an hour and maybe even shorter than that.
That's fine. Let's go.
Okay, all right.
Thank you.
Thank you. Let's then proceed then on that basis. Thank you.
Thank you. Ms. Myeni, where we had stopped before we had this exchange, which unfortunately, I'm sorry it's taken long, and I know that it's going late into the evening, was at your email that we had looked at, where you asked whether the approval of the cancellation fee requires board approval, and you say, if so, I approve it. What I'd like to ask you following from that, Ms. Myeni, is what motivated you to approve 50 million rand being paid to BNP Capital as a cancellation fee in circumstances where they asked for the fee on the very same day they were appointed on the basis that they'd undertaken work already? How could that be a justifiable ground for committing to a just short of 50 million rand cancellation fee?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Ms. Myeni, Ms. Nancy's evidence before this commission was that she did write that recommendation that you highlighted a moment ago in a question you asked me to the board to approve the cancellation fee. But her testimony before this commission was that she had reservations about it, and she nonetheless wrote the recommendation because she feared what would happen if she did not do that. Because she said you were putting pressure on her to get this deal done. Just for the record, before I have your answer on this, Ms. Myeni, Chair, that can be found in the transcript of Ms. Nancy's evidence. It's on the 19th of June 2019, page 51, lines 1 to 19. Ms. Myeni, do you dispute that you were placing pressure on Ms. Nancy to get this matter approved?
Chairperson, may I not respond to the question in case I incriminate myself?
She also indicated that one of the points that you made when you were encouraging her, or on her version, pressurizing her to get this deal done, was that costs had been incurred in Paris. How did you know that?
May I not respond, Chairperson, in case I incriminate myself?
Because Mr. van der Merwe's evidence for GRISAG before this commission is that no costs had been incurred and that the letters prepared by BNP Capital motivating for the cancellation fee on the basis that those costs had been incurred was false. So it's just difficult for me to understand how you had come to have knowledge of those alleged fees being incurred. Can you assist us with that?
It's very difficult to sit before this commission and get asked about nitty-gritties of operational matters. May I then, with respect, Chair, not respond to this question?
This is not a nitty-gritty operational matter because you yourself, Ms. Myeni, approved that SAA would pay BNP Capital 49.9 million rand if SAA pulled out of the transaction. So the reason for my questions is because you yourself gave that approval, and I'm probing why you would give your approval in a situation where a cancellation fee was sought on grounds that cannot possibly be justified for work that was done before the appointment was made. How could that be a valid basis for a cancellation fee?
Chairperson, may I not respond to the question so that I don't incriminate myself?
You see, what emerged in the evidence was that BNP Capital had had its FSP license suspended at a point in time before it was approved as the sourcer of these funds. Were you aware of that?
Chairperson, may I not respond to the question so that I don't incriminate myself?
You see, the concern that arises from that fact is that someone at BNP was aware that this license had been suspended, was aware that the license was a prerequisite for their valid appointment, and may well have been concerned that should SAA find out about the suspension of the license, they might pull the whole transaction. And so instead of scoring a success fee, which was their first terms of remuneration in this transaction, they then motivated for a cancellation fee. Do you have any comment on that being what might have been going on in the background?
May I not respond, Chairperson, to the question so that I don't incriminate myself?
There's also been evidence before this commission that your son, Mr. Ltd Myeni, is a business associate of Mr. Mngadi, and I know I dealt that with you about that earlier, but there was a further indication that they had been seen at SAA together on occasion. Can you confirm whether that is so?
May I not respond?
Have we lost connection with Ms. Myeni? Can you hear me, Ms. Myeni?
I can, Chair, thanks.
Okay, I think your answer was not complete. Do you want to repeat it? Or your response?
May I not respond to the question, Chairperson, in case I incriminate myself?
Okay.
Ms. Myeni, were you going to benefit in any way if BNP Capital had secured the 49.9 million rand cancellation fee?
May I not respond, Chairperson, to the question so that I avoid incriminating myself?
Ms. Myeni, did you lodge a criminal complaint against Ms. Yake Kwinana arising from the AAR JM Aviation contract on the components tender?
Please, can you finish the question, ma'am? Because that would be per instruction by who? And what is the motivation that you are talking about?
No, sorry, I think you may not have heard me. I just asked, did you lodge a criminal complaint against Ms. Kwinana arising from the AAR JM Aviation contract for components?
Chairperson, it's important to get a full picture to say if I lodged a complaint, as who? Because there is no decision when you are a board that you just decide alone on your own. If, for instance, you are a board of 10 people, at least the majority of the board must agree to doing something. Now I'm saying, Dudu Myeni goes and open a case against Yake Kwinana, or the board takes a decision, a resolution, to go and open a case against Kwinana per instruction by the minister, per instruction by the investigators, per instruction by the CEO. That's why I would like to hear.
No, Ms. Myeni. The question is simple. Did you lay a criminal complaint against Ms. Yake Kwinana in regard to the AAR/JM Aviation? Is it tender bid or contract? Indeed. Now, if you want to say, I did, but I was not acting personally, I was acting on the strength of a resolution of the board, that's something that you can clarify. But if you say you did not, then you say you did not.
May I not respond then, Chairperson, so that I don't incriminate myself?
Chair, this is an occasion where it's not clear to me that this privilege can be invoked. I struggle to know what possible crime could arise from a question that asks, did you lodge a criminal complaint? But I just note that, and I'm happy to proceed depending on your direction.
Well, I indicated, I think on Wednesday, that we'll proceed and Ms. Myeni would invoke her privilege where she considers that it's applicable, but at some stage, either yesterday or today, I might have a look at and see whether there are not certain questions where I would rule differently. So I have not done that except maybe in in regard to one or two questions over the past 3 days. As we speak now, I'm inclined to take the view that when we are done, it might be important that the legal team could go through the transcript and see whether there are questions that it wishes to present submissions on whether she should be compelled, I would probably also want to go through and see that it may be that there might be none, it may be that there might be some. So I, if you want to leave it and move on and just place your position on record, I don't have a particular problem, but Mr. Mchilezi wants to say something.
Yes, Chair, just one point.
Yeah.
There may not be possibly any criminal liability that may arise from the question on the surface, but even the prospect of perjuring yourself renders you susceptible to criminal prosecution. So I think in part it also goes to that point to say I do not want to incriminate myself in as far as I may perjure myself. So this is one of those questions where the witness is, in our view, is entitled to avoid the question because they do not want to run the risk of perjuring themselves. Thank you.
Mr. Mayor, you might want to say something. You might want to simply say you have recorded your position. You will take it from there, or what would you like?
Chair, the threat of committing perjury could never be a basis for invoking the privilege against self-incrimination. If that were so, every person who ever comes before this commission would be able to invoke it in order, in a sense, to invoke a right to silence, which they do not have. So you can't say I will lie if I give my answer. So I invoke my right against, my privilege against self-incrimination not to give a lie. Chair, we can make further submissions in due course, but that could never be a basis for the invocation of the privilege.
Okay, but you have...
I'll leave the question. I've noted that is, and Chair, the record will show, I have been very careful to only raise the issue where it just does not appear on its face to be a question that could ever lead through a series of questions to an exposure to a criminal charge. And I'll just continue to note them when they arise. My next question, Ms. Myeni, is did you provide an affidavit to the police regarding the AAR JM Aviation contract for components?
May I not respond, Chairperson? To avoid incriminating myself, Chair.
You certainly, Ms. Kwinana gave evidence on Monday or Tuesday that around the time that the contract was being finalized on the AAR JM Aviation matter, you had asked her to give an account because there was commentary in the media, I think flowing from Air France's litigation on the case. I think she said that the unions may have raised a concern. Do you confirm that you asked her for an account of the allegations that there was something untoward in the award of that contract?
May I not respond, Chairperson, in case I incriminate myself?
There was also evidence given by Ms. Mamela, who appeared before this commission, that your specific concerns about the award of this contract in questionable circumstances had been raised at SAAT board meetings after the award was made. Can you confirm whether you had those concerns, and if so, what they were?
May I not respond, Chairperson, so that I don't incriminate myself?
Ms. Myeni, I'd then like to turn to the 30% set-aside policy that was embarked upon at SAA. That policy was linked to the President's State of the Nation address in 2015, wasn't it?
May I not respond, Chairperson, so that I don't incriminate myself?
Again, Chair, for the record, it's not at all clear to me whether the 30% set-aside policy was linked to the former President's State of the Nation address in 2015 could expose Ms. Myeni to a criminal charge. But I will move on for now. Ms. Myeni, you received communications both from National Treasury and from the DTI that the 30% set-aside policy was unlawful, didn't you?
Chairperson, may I not respond to the question because I don't want to incriminate myself?
And having received those communications from National Treasury and the BBBEE Commissioner, why was it that despite that, you and particularly Ms. Kwinana, together with your other board members, pushed for the imposition of this 30% set-aside policy?
May I not respond, Chairperson, in case I incriminate myself?
Ms. Myeni, the Commission has received evidence that on Friday, the 2nd of October 2015, you and Ms. Kwinana held a lengthy meeting with Dr. Dawa, who was then the head of procurement at SAA. And his version is that you placed pressure on him to prepare letters of award to Swissport and Engen arising from the 30% set-aside policy. Ms. Kwinana has denied before this Commission that that meeting took place. Do you confirm that the meeting took place, or do you, like her, deny that it took place?
May I not respond, Chairperson? I don't want to incriminate myself.
Again, Chair, it's not clear to me that that question could, answering that question could expose Ms. Myeni to a criminal charge. Dr. Dawa's evidence is that at that meeting, you said to him that you were keen to take his job away, that the EFF were going to be protesting at SAA the following Monday, and he would be at risk because they were going to be protesting against those who are anti-transformation and Zimbabweans. Do you recall issuing that threat to Dr. Dawa?
Chairperson, may I not respond to the question? I don't want to incriminate myself.
Do you dispute that you threatened him in that way?
Chairperson, may I not respond to the question?
Dr. Dawa
I don't want to incriminate myself. And Chairperson, Dr. Dawa did not report to the Chairman of the Board. I don't want to incriminate myself. May I please not respond to the question?
Dr. Dawa's evidence was that he was extremely distressed by that meeting on the 2nd of October 2015. Were you aware that he was very distressed by it over the course of the day?
Chairperson, may I not respond to the question so that I don't incriminate myself?
Again, for the record, Chair, it's not clear to me that that is a question that the answer to which would expose Ms. Myeni to a criminal charge. After that meeting, you received a letter from Ms. Kwinana in which she called on you to take strong disciplinary action against Dr. Dawa for what she alleged was his insubordination, his efforts to sabotage SAA. Did you share those views of Ms. Kwinana?
May I not respond to this question, Chairperson? I don't want to incriminate myself.
After that letter was sent to you, Ms. Myeni, on the 9th of October 2015, Dr. Dawa was served with a charge sheet, and he then was subjected to a disciplinary process. Did you support the decision to discipline him?
May I not respond, Chairperson, to the... May I not respond, Chair, to the question? I wouldn't want to incriminate myself.
Again, Chair, for the record, it's not clear to me that the answer to that question could expose Ms. Myeni to a criminal charge. Dr. Dawa's letter of suspension was prepared by Ms. Pumeza Nansi just a few days after she'd taken up the position as acting CFO. So she was in a position where she had no personal knowledge of the grounds for disciplining Dr. Dawa. Did you assist in the compilation of that letter of suspension at all?
May I not respond, Chairperson, to the question? I don't want to incriminate myself.
Again, Chair, it's not clear to me that that could be a question, the answer to which would expose Ms. Myeni to a criminal charge. Ms. Myeni, the disciplinary proceedings against Dr. Dawa commenced on the 16th of March. And do you have any knowledge of these proceedings?
That's an operational matter, ma'am.
Is the answer no, then?
The answer is it's an operational matter.
That's not an answer to my question. My question is, did you know that his disciplinary proceedings began on the 16th of March 2016?
Chairperson, in view of my answer not acceptable, then may I not respond to the question?
Ms. Myeni, just to be clear, it's not that it's not acceptable. It's just that that question requires a yes or a no. So it would be helpful if you could indicate, if you don't have knowledge, that you don't. Saying it's an operational matter doesn't actually answer the question.
Yeah, you see,
May I not respond then, Chairperson?
You see, Ms. Myeni.
Because all these questions, sorry, Chair, sorry.
Yes, I'm saying.
I missed you, sorry.
I'm saying the question requires you to say whether you know or you don't know, and that it may be an operational matter might mean that you don't know, but there may be operational matters that you know. So it's more about what you know or what you don't know.
May I then, I appreciate that you've given me clarity. Then can I then invoke my privilege to say I would not like to respond to the question in case I incriminate myself?
Again, Chair, for the record, that is not a question that certainly, as I consider it, would expose, the answer to which would expose Ms. Myeni to a criminal charge. There was quite severe concerns within the HR department of South African Airways about the manner in which that disciplinary process was conducted. And despite the head of HR raising those concerns, well, the head of employee relations raising those concerns, the process was continued with. Did those concerns ever reach your level, Ms. Myeni?
May I not respond to the question? I don't want to incriminate myself.
That, again, Chair, is not a question, the answer to which, in our view, would expose Ms. Myeni to a criminal charge. Chairperson, I appear to have done a little bit better on my own estimation of time. I'd like, if I may then, to move to some of the conclusory aspects that I'd like to put to Ms. Myeni for her comment.
Yes, no, that's fine. Matters relating to the suspension and ultimately departure of Ms. Mshe, did you cover those?
No,
something that...
I've dealt with Dr. Dawa because
yes.
there were indications in the papers that that might have elevated to Ms. Myeni's level.
okay.
But sorry, Chair, you do remind me about an aspect that I must traverse. Thank you very much for that. Ms. Myeni, Ms. Mshe gave evidence before this commission about the Air Chefs contract. Well, it was first the LSG Sky Chefs contract, the award to it to provide lounge catering services at various airports, and then an attendance at Parliament on the 2nd of September 2015. Do you remember attending Parliament on that day?
May I not respond, Chairperson, so that I don't incriminate myself?
Chair, let me just record now. Knowing the questions that I'm anticipating asking, it's not clear to me that the answers to any of these questions would tend to expose Ms. Myeni to a criminal charge. So I'm going to say that now just to cover all of them so I don't have to keep saying it. Ms. Mshe said that there was an issue taken up when you presented before the Portfolio Committee on that day. And there was criticism levelled at SAA for having awarded this contract to LSG Sky Chefs. Do you recall that criticism having been made?
May I not respond, Chair? I wouldn't want to incriminate myself.
Her evidence was that when the meeting adjourned and you were outside the room with her, you berated her in front of colleagues and said, how could we give this contract to a foreign company? Do you remember saying that to her?
May I not respond, Chairperson? I know for a fact that I would incriminate myself.
Ms. Myeni, do you dispute Ms. Mshe's version that that is what you did after the meeting at Parliament?
May I not respond, Chairperson?
What then followed, Ms. Myeni, was...
Don't incriminate me.
What then followed, Ms. Myeni, was a number of interactions between the board and Ms. Mshe as she endeavoured to explain to the board why the decision had been taken to go out on tender on that matter, what had informed that decision, the fact that LSG Sky Chefs was actually a local company, not a foreign entity. She explained that the concerns that Ms. Kwinana had raised around the loss of jobs had been catered for because the employees would be moved over. She also addressed how negligible a portion of the revenue of Air Chefs this contract actually occupied. She went and got advice from the legal department about the consequences for SAA of cancelling that contract. And despite that, the board of SAA on the 28th of September 2015 took a decision to cancel the award to LSG Sky Chefs and to award it to Air Chefs. Against the backdrop of what the acting CEO was saying to you as the board at that time, why did you make that decision, Ms. Myeni?
Do what, ma'am? To cancel LSG tender?
Yes.
Chairperson, may I not respond to the question so that I don't incriminate myself?
You took that decision.
But also, Chairperson, sorry. But Chairperson, it can also help you, Chair, to say, or help this commission to say, where I'm sitting, it would not make sense to take a competitor of Air Chefs and give all the work of South African Airways to another company. In as far as I'm concerned, Chair, in any work environment, Chairperson, there are decisions you take that are motivated and informed by the CEO or the CFO, that they motivate for you to consider, apply your mind, exercise duty, care and skill, and ensure that the decision is a proper decision that you would stand by. In this case, Chair, Air Chefs was, if it still exists, a subsidiary of South African Airways. So South African Airways catering services ought to have been provided by Air Chefs. So, Chairperson, I can safely stop right there. I've provided what I can, but I'm deliberately limiting it to as far as I've spoken. Thank you, Chair.
The board's decision to cancel the award to LSG Skychefs was against the advice of its own internal legal department. Why did you take a decision against the advice of your own legal department?
I said the motivation when it comes to the board, it's not a gun put on the face of the board or on the head of any decision maker within the board. When a motivation comes, it's not a do or die. You've got to read what is before you, understand the financial implications, understand the risk, understand also the maybe capabilities of those that you prefer than what you already have. In this case, Air Chefs, LSG provided similar services. Now, if we are to close Air Chefs and take LSG, that process ought to have been a properly deliberated upon process, but whoever provides any motivation to the board, it does not mean that you won't have different views as the board. One can decide to say yes, one can decide to say no. So unless you are asking me as Dudu, then I can tell you what my view was then or what my view is today. But, Chairperson, I'm saying I can only go as far as this. It doesn't mean that when you are given legal advice, you must take every advice that comes. It doesn't mean that the board memos, all board memoranda that were provided to the board meant that all of us will say yes. It does not operate like that at that decision-making level. You've got to apply your mind. You've got to ask questions as well. It doesn't mean also that when you receive a memorandum from whoever, then it means that memorandum is like, you must say yes, thumbs up. You weigh many things. My views might not even touch on the, say for instance, another person would look at a risk that I would not have thought about. Another person in the board might raise another question that you did not think about, or you yourself, you would ask a question to say, have we really thought about this, or should we defer this decision? And then come back about it and say, maybe, let us explore this. So it doesn't mean, Ms. Hofmeyer, that because it came from a legal department of SAA, then it meant that we must just rubber stamp and not apply our minds. I'm just saying that, Chair, I can go as far as that because it looks like these questions, they keep following each other. I wouldn't, in my personal capacity, replace Air Chefs without following a proper process of killing a subsidiary and opt for LSG instead of continuing with your own baby. In other words, we ought to have killed the child that was established by SAA as a subsidiary. In other words, low-cost airline like Mango, we would have, like, it's a comparison to say, in other words, take our passengers to a competing airline, leave Mango. It wasn't going to be a good decision. This is my view, Chairperson, and I can only elaborate further at another forum, Chairperson.
Ms. Myeni, are you a lawyer?
In the board, you have a different type of skills. I am not a lawyer, but a lawyer might not be a finance person. A lawyer can be a legal expert, but a chartered accountant can look at the financial risk. Another person would look at the HR component of the risk of whatever decision. Then you listen to all other inputs from different people. I don't have to be a lawyer to be able to take decisions that are good for that particular operation that you are running. So if all of us would be lawyers in order to take good decisions, then we won't complement each other. You need a spread of skills to be able to complement each other. Definitely, you've seen my CV, ma'am. Therefore, I don't think I need to respond to your question.
Did you seek the guidance of any other lawyers to check whether they disagreed with the advice that your own legal department was giving you about the consequences of cancelling the LSG Sky Chefs Award?
What was your question, ma'am?
Did you seek the views of any other lawyers about whether the advice of your own legal department concerning the consequences of cancelling that award were correct or not?
Chairperson, with respect, any submission to the board is not for the board to rubber stamp. People get bribed to push certain decisions to the board. Other people don't get bribed, but they think that this business case as executives is a good business case. But you need also a fair spread of different minds around an issue that you are talking about. You see, Chairperson, as the board, we were reporting to the shareholder ministry. And as the board, we had an oversight structure in Parliament where we reported about the performance of the airline. So if we were to kill airchefs, we needed first to get the approval to say then we are killing airchefs, we are taking airchefs' functions to somewhere else. I'm making a very broad statement, but a narrow statement I can provide the Chairperson is that it does not mean that when a submission is made to the board, 10 people will have the same answer. One person might say, I prefer not to approve this, and then sometimes they even provide some motivation in terms of the reasons why they don't approve. Or 8 people can say, we are against this. Say, for instance, you are not at the board meeting, you are on your own wherever you stay, but you are reading something via the email. You have no one to ask any question, but sometimes you follow up by asking questions to check if this is this decision you are going to take is the right decision. And the other thing is, I did not have veto powers. So whether I wanted to say, as Dudu alone, let this continue, it would never happen. So I'm just saying, Chairperson, I don't want also to waste much of our time.
Ms. Myeni, did you...
It's important to say that I'm not a lawyer. 2, it does not mean that any submission that a person makes in the board, that means it's a done deal. No.
Ms. Myeni, did you... Apologies. Ms. Myeni, did you believe that the legal department of SAA had been bribed to give the advice that they gave you on the consequences of cancelling the LSG Sky Chefs Award?
When I said it doesn't mean that every submission that is presented to the board means everyone must then rubber stamp and approve. I do not insinuate that somebody was bribed or not. I am saying the expectation of this commission would be whether we were able to apply our minds when taking decisions. Because then, Chair, you don't need a board. If then that legal department would take decisions, why are they bringing it to the board? Then it means the board was just a collective of maybe people who do not think properly and who are not qualified to be able to use proper skills to assess the risk involved, financial side of the organization, capability of whoever that is coming to render any service, but also the labor issue that now you have equipped air chefs. Now you're closing air chefs with all the new equipment that exists at air chefs. You're taking the business away somewhere else. I also, Chairperson, do not want to talk too much about one service provider and take so much time about one service provider. Because, Chair, it would then mean the whole country lost by not giving LSG the contract. So I'm saying, Chair, please allow me to stop right there and not continue further about this question of LSG.
Ms. Myeni, the problem, and in fairness I must put it to you, with what you've said now about rubber stamping and the role of the board to interrogate what's placed before them, is that this decision was never within the delegated authority of the board. It was a decision that had been taken by the acting CEO because it fell within ultimately her decision-making delegation. It was done off the back of a fully lawful and procedurally fair procurement process. So there was no motivation to the board. There was no decision that the board was required to take. The lawful decision had been taken by the acting CEO. A letter of award was sent to LSG Sky Chefs. And despite that, after receiving some tough questions in Parliament on the 2nd of September 2015, the board of its own account decided to overrule that decision. So I put it to you, Ms. Myeni, you cannot justify that decision on the basis that it's important for boards to consider carefully what come before them. You were overturning the lawful decision of your acting chief executive officer. Do you have a response to that?
Sorry, I'm losing you. Sorry, I'm losing you a bit, yes. Sorry, now I hear you.
Did you?
Ms. Hofmeyr.
I can hear you, Chairperson. Now.
Yeah, Ms. Hofmeyr says the difficulty with the response that you have given to her question is that this was not a case where the board was given any submission in order for the board to make a decision. She says this was a case where the decision fell within the delegated authority of the acting CEO, Ms. Mshe, and she had made a lawful decision. But the board, after facing some tough questions in Parliament on the 2nd of September, came back and then decided to overturn the acting CEO's decision. Ms. Hofmeyr, did I put it correctly?
Almost verbatim, Chair, so thank you so much.
Okay, so that's what she is saying. So she says, what do you say to that?
Chairperson, then may I not say anything, lest I incriminate myself, because once something is in Parliament, Chair, once something is in Parliament, it attracts the board's attention. So that is why then, Chair, nobody was taking away anybody's delegations of authority, but it was being asked in Parliament, as Ms. Hofmeyr was saying. So, Chair, I invoke my privilege of not saying anything,
What would you say?
so that I don't incriminate myself, Chair.
What would you say to somebody who says, you and your colleagues on the board ought to have, after getting questions in Parliament about this issue, ought to have investigated it and then given answers to Parliament maybe later on, because the decision that had been made was a lawful decision made by somebody who was acting within her delegated authority. What would you say to someone who says, maybe you were caught off guard by the questions that you were asked in Parliament as board members, but then you should have investigated and then maybe subsequently went back to the board and say, this decision was taken by the acting CEO, she was acting within her delegated authority. Maybe as the board we don't agree with it, but she made the decision, it was a lawful decision, we won't interfere. What do you say to somebody who might put that proposition to you?
I won't make any comments, Chair.
Okay, all right. Ms. Hofmeyr.
If Ms. Myeni has refused to answer that question on the basis that she's invoking her privilege against self-incrimination, Chair, we submit that that is an abuse of the privilege. Ms. Myeni has given us almost 20 minutes of an account of this matter. At this point, she is seeking to invoke the privilege to avoid answering difficult questions. Those will be our submissions in due course. Do you want to respond to that, Ms. Myeni?
Yes, Chair. It is not accurate that it was 20 minutes. That's a starting point, Chairperson. I'm sitting here, I'm watching minute by minute on the iPad here, and it is not fair to say I've given a 20 minutes response to the question, or I don't know, the comment that you've described. It was not 20 minutes. Certainly, Chair, not. Secondly, Chairperson, I said I'm making a broad account of submissions that get made. I did not say LSG was not within the delegation of authority of Ms. Mshe. And secondly, as the acting CEO. And thirdly, Chair, I cannot answer before you today to say what were the steps that were followed then in the process of cancelling the LSG tender. I don't have that information, Chair, unless maybe I can go back to my documents. Before going back to the documents, I would want to go back to the recording of the Parliament about the things that were raised. So, Chair, even now, I've just spoken for 1 minute.
Ms. Hofmeyr.
Ms. Myeni, you have given a version on this. You gave it a few moments ago. You said that your decision to reverse the decision of the acting CEO was based on the fact that you were concerned that it would, quote, kill the child, and you associate the child being air chefs. Ms. Myeni, the evidence, at least the submission that acting CEO Ms. Mshe placed before the board, showed that the impact of this contract on Air Chef's revenue was less than 4.3%. How could you possibly decide to overrule a lawful decision if the impact was only going to be less than 4.3% of revenue on the basis that it was going to kill the organization?
The reference that is made was for me to explain to you, Chairperson, in broad terms. And now I'm being asked about a further question, which I'm going to happily invoke my privilege to say I prefer not to respond to this question, Chair.
You see, Ms. Myeni, you remember this morning I said you must make an election, and I think I repeated during the day, each time a question is put to you, whether you are going to invoke your privilege to refuse to answer or whether you are going to answer. And I said, if you are going to answer, you can't later on say you are revoking, you are invoking the privilege. Now, when you, in response to a certain question, there are some things that you say, or you have a lot to say, but when you are being challenged on your answer, you then invoke your privilege and say you prefer not to answer because you don't want to incriminate yourself. It will come across as if you are quite happy to give an answer as long as you are not being challenged on it. Or when you think the question is easy, you answer, but the moment questions become difficult, you then invoke your privilege. That's how it will come across. So I just mentioned that so that you are aware. Okay, all right, Ms. Hofmeyr.
Thank you, Chair.
Sorry, thank you, Chair. The other decision that the board took at that meeting of the 28th of September 2015, when you decided to cancel the award to LSG Sky Chefs and give the contract to Air Chefs, was to reduce the acting CEO's limit on her delegation of authority from 100 million to 50 million. Was that an act of retribution against acting CEO Ms. Mshe for having taken this decision that you didn't like on LSG Sky Chefs?
May I not respond, Chair? May I invoke the privilege, Chairperson? In case I incriminate myself, Chair.
Chair, we will argue in due course that Ms. Myeni is now abusing the privilege for the reasons I've given previously. Ms. Myeni, in conclusion, Chair, subject to your questions, but let me conclude, and then, of course, if there are other aspects, no doubt you'll address them with respect. Ms. Myeni, the legal team of the Commission is likely to submit in due course what I'm going to set out for you now as having emerged from the evidence that you've given over the last 2 days and all of the other evidence that has been presented to the Commission. And I do so that you have an opportunity to answer or respond to what I'm putting to you now. So, Ms. Myeni, the likely submissions of the legal team in due course to this Commission will be that you knowingly misrepresented to the Minister of the Department of Public Enterprises in 2013 that the board of SAA had resolved to change the Pembroke transaction in circumstances where you knew that they had not done so, and that misrepresentation cost SAA in the order of 800 million rand. Do you have a response to that?
I do not have a response, Chairperson, so that I don't incriminate myself.
The Jacob Zuma Foundation received 2 million rand that originally came out of the Free State government's coffers was routed through V&A Consulting, went from V&A Consulting to your son's company, Premier Attraction, went from Premier Attraction to Mr. X's company, and if it were to be found by this commission that 2 million rand constitutes the proceeds of crime, do you agree that the Jacob Zuma Foundation should have to pay that money back to the National Revenue Fund?
May I not respond, Chairperson, in case I incriminate myself?
Ms. Myeni will argue in due course that you set up meetings with the former President Zuma so that those seeking to influence the President would have an opportunity to do so. Do you have a response to that?
Chairperson, may I not respond so that I don't incriminate myself?
Ms. Myeni, it will be argued in due course, receive benefits from Bosasa, including security upgrades valued at just less than R500,000, rand, travel and accommodation benefits just in excess of R100,000, rand, and cash. Do you have a response to that?
I don't have a response, Chairperson. May I invoke the privilege of not incriminating myself?
You handed over confidential police and NPA information to Mr. Agreezy on the 23rd of September 2015 in the morning at the Sheraton Hotel. Do you have a response?
I thought we had, oh, sorry, these are conclusive
yes, indeed.
Remarks. Okay. I stand by the answer that I gave, Chairperson, and I would rather not respond so that I don't incriminate myself.
The submission will be that you managed to delay and undermine the execution of a search and seizure warrant at your home in October of 2019. Do you have a response to that?
May I not respond, Chairperson, to the question so that I don't incriminate myself?
You arranged for the State Security Agency to conduct an unlawful vetting operation at SAA of managers and their support staff. Do you dispute that?
May I not respond, Chairperson, so that I don't incriminate myself?
You tried to use the outcome of that operation to remove a member of the finance department or move her to another department. Do you dispute that?
May I not respond, Chairperson, so that I don't incriminate myself?
You used false whistleblower reports to start investigations against managers whom you wanted to remove. Do you dispute that?
May I not respond, Chairperson, in case I incriminate myself?
You created a climate of fear and intimidation while you served as the chairperson of the board of SAA. Do you dispute that?
May I not respond, Chairperson, in case I incriminate myself?
You bullied Dr. Dawa, the head of procurement, when he refused to agree to your unlawful 30% set-aside policy. Do you dispute that?
May I not respond, Chairperson, so that I don't incriminate myself?
Your decisions at SAA during your tenure as chairperson took no account of the considerable negative consequences for the fiscus whenever you had to approach the Minister of Finance, both in relation to the Airbus swap transaction and the Pembroke transaction.
May I not respond, Chairperson, in case I incriminate myself?
50 million rand that would have constituted the cancellation fee to BNP Capital was approved by you in circumstances where there was no justifiable basis for that cancellation fee to be paid. Do you dispute that?
May I not respond, Chairperson, in case I incriminate myself?
Chair, that brings me to the conclusion of my questions. I think I went 1 minute or two over the allocated hour. Chair, it has done full circle because we ended with the BNP Capital issue. That is the issue that we started the aviation evidence with about 18 months ago.
Yes.
Thank you.
Okay, no, thank you. We are going to stop here for the day. One thing that does remain is that Ms. Myeni still needs to be questioned with regard to ESCOM. So arrangements will have to be made in due course about that. So that's the one point. The other point is the one that I mentioned earlier, namely that there is no time now and it's not convenient really to look at Ms. Myeni's entire evidence and see which questions she may have justifiably invoked the privilege not to incriminate herself, and which ones, in respect of which ones she might not have done so justifiably or correctly. I think the legal team would want to have a look at the transcript, and they would take a view one way or another in regard to whether there is a need to do anything about any of the answers or questions or invocation of the privilege. I probably will also have a look and see, and obviously if there is something that needs to be raised with Ms. Myeni's legal team, it will be raised, and if there is nothing, then there would be nothing. So that's another point that I wanted to mention. But apart from that, before we adjourn, I just thought that I need to say something or to draw the attention of the public to to say something about what has happened over the past 3 days, because it is something that has not happened before. And it is important that the public also understands some of the things that happen and why they happen. When a commission such as this one is established, it is established primarily to establish facts in regard to certain matters that fall within its terms of reference, matters that are viewed as very important and in the public interest. And in order to carry out its mandate, a commission such as this would conduct investigations and, when necessary, have public hearings such as the ones this commission has had since August 2018. And it relies largely on the cooperation of people who have knowledge in regard to the matters that fall within its terms of reference in order for it to carry out its function properly. Now, prior to Wednesday this week, there were about 2 or so witnesses who had invoked the privilege not to incriminate themselves and therefore sought not to answer certain questions. But for the most part, they answered most of the questions that they were asked. So Ms. Myeni was the first witness who So not to answer most of the questions that were asked, that were put to her, and answered only a few that she felt she could answer without the risk of her incriminating herself. Now, when the regulations applicable to this commission were made, and they were made by the president at the time that the commission was established, they have since been amended on 2 or 3 occasions. They included a provision in Regulation 8.2 to the effect that a witness who gives evidence before the commission that evidence that relates to matters before the falling within the terms of reference of the commission, that evidence would be inadmissible in subsequent criminal proceedings against that witness. That therefore meant that if somebody gave evidence before the commission and in doing so incriminated himself or herself, that evidence would not be used in subsequent criminal proceedings against that person. And therefore that person could feel free to be as helpful to the commission as possible, knowing that that evidence would not be used against him or her. But the Commissions Act number 8 of 1947 is the legislation that governs this commission. Together with the regulations. And in section 3, subsection 4, it provides as follows, and I quote, "Any person who has been summoned to attend any sitting of a commission as a witness or who has given evidence before a commission shall be entitled to the same witness fees from public funds as if he had been summoned to attend or had given evidence at a criminal trial in a superior court held at the place of such a sitting." And this is the relevant part. In connection with the giving of any evidence or the production of any book or document before a commission, the law relating to privilege as applicable to a witness giving evidence or summoned to produce a book or document in such a court shall apply. Now, this latter part of section 3, subsection 4 is understood to include the privilege against self-incrimination. And it is this provision that enables a witness who appears before this commission to invoke the privilege against self-incrimination and therefore to refuse to answer questions that may tend to expose her to criminal prosecution. As Ms. Hofmeyer indicated, when this issue was dealt with either yesterday or I think on Wednesday, the case law relating to this is to the effect that the court, or in this case the commission, that is the chairperson, needs to give a witness latitude if he or she claims that she believes that if she answers a certain question, she may incriminate herself. As Ms. Hofmeyer indicated, the case law doesn't mean that whenever a witness invokes the privilege, it means necessarily that she can't be compelled to answer a question that he or she feels she may incriminate herself if she answers. But it would seem on the case law that the court, or in this case the commission and the chairperson, is required to give quite some latitude to the witness when she does so. This is despite the fact that Regulation 8.2 of the regulations of the commission do say that if a witness gives evidence before the commission, her evidence can't be used against her in subsequent criminal trials. The fact that Section 3, subsection 4 of the Commissions Act is there simply means that a witness is able to invoke it, and the commission cannot act illegally. The commission has to operate within the ambit of the law, and that includes that provision. Therefore, the commission must respect that provision. But the regulation, or Regulation 8.2, enables, it seems, any witness who wants to assist the commission and wants to put his or her side of the story to do so. It enables him or her to do so, knowing that his or her evidence will not be used in any subsequent criminal trials against him or her. So the commission has to operate within this, and I thought it's important to mention this and refer to the section for the education of the public as well. The provision doesn't mean that the commission cannot compel a witness to answer certain questions, but it can only do so if the invocation of the privilege is not justified. And it would seem from the case law that it would not be justified if the apprehension of the witness that she may incriminate or he may incriminate himself or herself if she or he answers a certain question is not based on reasonable grounds. But it is a matter that the commission needs to deal with properly and carefully, having regard to its obligation to operate within the ambit of the law and having regard to the obligation to strike a balance between the rights of witnesses as well as its own mandate. I thought that I should just make those remarks so that the public can have some understanding of the legal framework surrounding what has happened since Wednesday, because it is something that had not happened before in the past 2.5 years, that during which the Commission has been hearing evidence. Ms. Hofmeyer?
Thank you, Chair. I think that it's 9:30 tomorrow morning, is that right, when we will be
Yes,
assembling?
it will be 9:30. Is there anything you want to say arising?
No, thank you, Chair.
Yes, okay. So tomorrow, yes, we'll have a session here to complete Ms. Kwinana's evidence. We will start at 9:30. Mr. Buchelez, is there anything you want to say arising from?
No, Chair.
Nothing.
Thank you.
Okay, it remains for me to thank you, Mr. Buchelez, and your instructing attorney or your colleague for all the cooperation, and to thank Ms. Myeni and Ms. Hofmeyer. We will adjourn, and as I said, with regard to Ms. Myeni, there is still the ESCOM part, and there may still be something else arising out of the invocation of the privilege, but that will be dealt with through the right channels in due course. We are going to then adjourn for the day. We adjourn.
Thank you, Chair.